bare injunction by the plaintiff. She
He will
contends.
prove it, don't worry. Yes. Anything else? The petitioner is before this court calling in question the orders of the concerned court in OS 287 of 2021 and the order of the first appellate court in MA 20 of 2022, both 2022. The petitioner is the defendants 1 to 4. After hearing the parties, the application of order 39 rule 1 and 2 is answered in favor of the plaintiff by granting injunction in a suit for permanent injunction. This is called in question by the present defendants before the first appellate court in MA 20 of 2022, which comes to be rejected. Therefore, for the last close to 3.5 years, the interim order granted on 39 1 and 2 is operating. There is no warrant to interfere with the well-reasoned orders of both the trial court and the first appellate court. Finding no perversity in those orders, the petition stands rejected. Next.
19.
Petition. The one rule
For partition,
suit for declaration.
declaration. Who are you?
Declaration. I am the plaintiff.
Order 1 rule 10 ತಾನೇ ಇದು?
ಹೌದು.
ಯಾಕೆ ರಿಜೆಕ್ಟ್ ಆಗಿ ಯಾರನ್ನ ಇಂಪ್ಲೀಡ್ ಮಾಡಬೇಕು ಅಂತ?
ಸಬ್ಸಿಕ್ವೆಂಟ್ ಪರ್ಚೇಸರ್ ಮತ್ತೆ ಅವರು ಡಿಪೆಂಡೆಂಟ್ ಸನ್ಸ್ ಮತ್ತೆ
ಯಾವಾಗ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರು?
ಅವ್ರು ಪರ್ಚೇಸ್ ಮಾಡಿರೋದು 15/6
ಸೂಟ್ ಹಾಕದ್ಮೇಲೆ
ಸೂಟ್ ಇನ್ ಬಿಟ್ವೀನ್ ನಾವು ಸೂಟ್ 19/6/23 ನಲ್ಲಿ ಫೈಲ್ ಮಾಡುದು, ಅವರು 15/6/23 ನಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಂಡಿದ್ರು. ಅವ್ರನ್ನ
petitioner is before the court calling in question rejection of an application under order 1 rule 10 of the CPC filed by the present plaintiffs to bring in the subsequent purchasers of the properties in the suit for declaration. In the suit for declaration, the rejection of which runs counter to law. In that light, further proceedings before the concerned court shall remain stayed till the next date. Petitioner to serve at the trial court automatically. Occupation. Yes. Next. 6th August.
For the petitioner in this matter.
20.
20, my lord, I am the petitioner in this matter.
Interest calculation.
Please, my lord. I'm aggrieved by the orders of the interest calculation. I was the plaintiff in a suit for specific performance. In RFA, my lord, the
Serve on
orders.
the respondent.
Please, my lord. May I be permitted to serve it on the counsel appearing?
The petitioner to serve on the petitioner, the decree holder is before this court calling in question the calculation made for what?
On the refund of the entire amount payable.
Calculation made while refunding the entire sale consideration. The petitioner shall serve on the counsel representing the respondent judgment debtors before the concerned court. List on 1st August.
Grateful.
Next.
21.
Again for respondent number
Demolish.
2.
ಡೆಮಾಲಿಷ್ ಅಂದ್ರೆ
Demolish ಅಂದ್ರೆ ಹೊಡೆದಾಕದು.
ಹೌದು.
ಅದನ್ನೇನ್ ಮತ್ತೆ?
Lord, the interim order is construct in accordance with the sanction plan.
ನೀವ್ ಯಾರು?
I am for the plaintiff, my lord.
Plaintiff ಯಾರು?
Lord, plaintiff is the neighbor. Lord, he files a suit for
BBMP ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ sir.
ಮಾಡ್ಸೇತು.
ಏನಾಯ್ತು?
ಅವ್ರು ಏನು ಮಾಡೋದಿಲ್ಲ. Then I file a suit.
ಒಂದ್ ಹಾಕಿ LB ಅಲ್ಲಿ direction mandamus.
Now that there is a suit, my lord, then there is an injunction order stopping the construction in full.
In your favor?
In my favor.
Now what is the problem?
Now, my lord, they come before this court in an MFA. They say, at least permit me to construct in accordance with the plan. This court says, okay, construct in accordance with the plan.
According to the neighbor, the construction will never be in accordance with the plan.
No, my lord. Therefore,
it should be in accordance with your plan.
No, my lord. Thereafter, my lord, a commissioner was appointed. Commissioner finds, my lord, that the construction put up is not in accordance with the sanctioned plan. All that I am saying is, when you give a commitment to the court, saying that you will put up construction in accordance with law.
ಏನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ?
ಈ construction complete ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅವರು. In contravention of the direction given. Lord, in the MFA.
ಇದೇನ್ ಈ ತರ construction ನಾ? This is the picture of construction?
Yes, my lord.
ನಿಮ್ದ ಮೇಡಮ್?
Appearing for respondent number 2, my lord.
Correct. Stop ಮಾಡಿ ಮೇಡಮ್. Why are you constructing?
No, I am for a BBMP, my lord.
Why have you not taken action?
I just don't have any other information.
Why have you not taken action against the erring neighbor?
I'll seek all the information, my lord, right.
The petitioner is before the court. What did the court do now?
The court has now, my lord, said, I will not consider your application. I will consider it after evidence.
The petitioner is before this court calling in question an order dated, ಆವಾಗಿನ ಒಂದು ವರ್ಷದಿಂದ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಇಲ್ಲಿ?
My lord, filed in April,
ಅದಕ್ಕೆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮುಗಿದೋಗಿರೋದು.
filed in April, my lord.
ಫೈಲ್ಡ್ ಇನ್ ಏಪ್ರಿಲ್.
April, ಹೌದು.
ಹೌದು.
Interim
ಆರ್ಡರ್ ಇಸ್ 23 to 24.
Yes, my lord.
ಒಂದು ವರ್ಷ ಸುಮ್ನೆ ಇದ್ರಿ
Yes, my lord.
ಫಸ್ಟ್, ಆಮೇಲೆ 6 ತಿಂಗಳು ಸುಮ್ನೆ ಇದ್ದೀರಾ. You allow the construction to go up. Now you want the construction to be stopped.
Not stopped, my lord.
ಮತ್ತೆ
Let them remove, my lord, the construction which they put up in contravention of their undertaking. That is all that I am saying.
where is the undertaking?
My lord, please see, my lord,
Page.
page number, my lord, 73.
Anyway, because of the 1.5 year delay, you serve on the council.
I'll serve, my lord, I'll serve.
The petitioner shall serve on the council who represented the defendants before the concerned court in OS so and so, list on Friday.
Grateful.
ಕಾಪಿ ಕೊಟ್ಬಿಡಿ ಇವ್ರಿಗೂ.
You will put. Grateful.
ಒಂದೂವರೆ ವರ್ಷ ಸುಮ್ಮನೆ ಇರಬಾರ್ದಾಗಿತ್ತು.
22.
The petitioner is before this court calling in question an application filed under all 29 rule 21 of the CPC. The petitioner to serve on the council who represents the decree holders before the concerned court and file an acknowledgement of such service. List the matter on 1st August. There shall be an interim order of stay of further proceedings to the next date. Next.
23.
Police protection application.
My lord, I request the court to pass or
the-
to issue the direction
What
to the
direction?
trial court to consider and pass the appropriate order.
Petitioner is before this court calling, seeking the following prayer. Heard the learned counsel appearing for the petition. Petitioner is the plaintiff.
Yes, my lord.
I'm dictating, yes. Petitioner is the plaintiff. Files an application before the concerned court seeking directions for police protection. The said application is languishing before the court. ಯಾವಾಗ ಫೈಲ್ ಮಾಡಿದ್ದು?
27/7/2022.
22.
Yes, my lord.
The petition, the learned counsel for the petitioner submits that the said application is pending before the concerned court for the last 3 years and the court is refusing to pass an order on the said application. If the, it is shocking that the application filed in 22/7/2022 is still pending consideration at the hands of the concerned court. Therefore, the concerned court shall now dispose the application within the next 15 days from the date of receipt of the copy of the order, if not already disposed, ordered accordingly.
Much
24.
obliged.
Next.
For the petitioner, your lordship. Lordship, this is a suit for permanent.
Now
injury.
represented,
Sorry?
are the defendants represented now?
Please, your lord. Please,
Then
your
go
lord.
before the court. I will direct the concerned
Lordship, we
court.
already have an order that is passed, your lordship. Defendant number 1 happens to be the brother of the plaintiff.
What order is passed?
There is already a prior OS suit where he sought for a declaration. Page
Sir,
number
39
71.
1 and 2 is not considered.
Not considered.
Only notice is issued.
Please, your lordship.
Now the defendants are represented. I will direct the concerned court to decide it in 15 days.
Lordship, until then.
No, what until then?
Interim prayer may be kindly.
What until then? Nothing. Yes.
To consider the IA, your lordship.
That is what I am directing.
Now, until then, emergent stay may be granted, your lordship. I mean,
Yes.
non-interference in the scheduled property may kindly be granted, your lordship, because he's coming over and creating a ruckus in the spot.
The petitioner is before this court calling in question an order dated 15/5/2025 by which the application filed by the petitioner order 39 rule 1 and 2 is not entertained in the sense that no temporary injunction sought for is granted, but only a notice is issued. The learned counsel for the petitioner submits that the respondents are represented now and next date.
31/7.
And the next date before the concerned court is 31/7/2025. The learned counsel will further submit that the respondent defendants are interfering with the property of the petition, interfering with the possession of the petitioner on the score that there is no injunction granted. In the light of the matter being listed on 31/7/2025 and the defendants being represented, I deem it appropriate to direct the concerned court to decide the application under 39 1 and 2 on the next date, i.e. 31/7/2025. In the event a court would not decide the application, the petition should merit any temporary restraint order. Yes, ordered accordingly.
Please, your
Next.
55.
20?
5.
Chokka Reddy? ನೀವು ಯಾವಾಗ ಚೇಂಜ್ ಆದ್ರಿ? Yes.
Sir, petitioner, is the application number 28A of
Stamp
Karnataka
Act.
Stamp Act. Kindly see the
They serve on the plaintiff. The petitioner to serve on the counsel representing the plaintiff before the concerned court and file an acknowledgement of such service, 1st August, same order. Yes, next.
26.
Stay. Same order andre adene.
My lords,
ಅದು
my lords, my application for appointment of a court commissioner for taking my property, taking my belongings from the house has been rejected. Suit for eviction, my lords. The suit was filed after I was dispossessed, my lords. And there are several criminal, during COVID, I wasn't paying the rent for 2 or 3 months, my lords. Instead of filing a suit, I was illegally dispossessed. Criminal complaints were filed. Thereafter, he filed the suit for eviction, my lords. During the course of cross-examination, there's
What
an
will court
admission.
commissioner do, madam?
My lords, I may be permitted to take my belongings, my lords. Otherwise, my lords, this has been filed after the admission came through in the cross-examination, my lords.
Nothing.
My lords,
Your belongings are there for the last 4 years. You think it will be there?
my lords, he has admitted, my lords, he has
Where
in
is
the
the admission? Where is the
cross-examination.
admission?
My lords, in the cross-examination,
Page.
page 30, my lords.
Paragraph.
Sorry, my lords, page 54, my lords. There's a specific question that was posed to him, whether you would allow the defendants to break open the lock and take back his household articles. His answer is if the defendant pays the arrears of rent, he can take back his household articles. My lords, there's a deposit of 5 lakhs that is with him, my lords.
What is the arrears?
My lords, the arrears would be, he has claimed in the plain till date, my lords, but I have been only 3 months, my lords. 32,000 rupees is the rent, my lords.
That's a question of fact to be decided there.
My lords, the reason this
What will the
application.
court commissioner do, madam? Nothing.
My lords, my lords, in the event the suit is now, it's only for recovery of his money, my lords. After he withholds the money, withholds my rent, the balance may be ordered to be refunded, my lords. But for me
I
to,
will only permit drawing of inventory of the articles inside. And nothing beyond that.
obliged, my lords. Yes, my lords.
The petitioner is the tenant, the respondent, the landlord. A suit for eviction comes to be filed in OS 4751 of 2021. The issue is with regard to the application seeking appointment of a court commissioner being declined. The application is preferred by the tenant. The reason for preferring the application is that several movables are still in the tenanted premises, i.e. the premises owned by the landlord. The learned counsel would take this court through the cross-examination where the landlord admits that movables are there in the house and the same can be taken after clearing the arrears of rent. Therefore, the court commissioner, therefore I deem it appropriate to permit the court commissioner, prima facie I deem it appropriate to permit the court commissioner to visit the premises and draw up an inventory of what is available inside the house. The same would so and so. In the light of the respondent not represented, the petitioner will serve on the counsel who represents the respondent in the trial proceedings and file trial proceedings in the course of the day. List the matter on Friday. We'll dispose it on Friday in preliminary hearing. Next,
obliged,
please.
my lords.
27.
Appear for petition,
Who has filed recasting of issues?
casting issue.
Who has filed?
Court is filed.
Who has filed, sir?
No, my lord. The court is after the completion of argument.
Court by
recasting.
itself does it?
Court overnight. After
Order
the
14 rule fight, anytime it can be done in this suit.
Please, my lord. Issues framed on preliminary issues, my lord, same issues, my lord. Issue number 2, whether the
The
plaintiff is
petitioner
proved
is
that.
before this court calling in question the order of the concerned court which so moto in exercising power under order 14 rule 5 recasts the issues
Correct, my lord.
of
But
the year.
same issue-
One ನಿಮಿಷ ಹೇಳ್ತಾ ಇದ್ದೀನಿ sir. Recast the issues after 11 years of framing the issues. In that light, there shall be an interim order of stay of the order impugned. It is made clear the trial is not stayed. Emergent notice to the respondents.
Please.
Yes,
And
next.
connected with my lord, already connected matter is stayed, my lord.
ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಷ್ಟೇ ಮಾಡಿದೀವಾ?
stay ಆಗಿದೆ.
ಅದು ತಪ್ಪು. ಎಸ್ ಕೊಡಿ ಅದು. Anyway, tag the petition along with
And
some.
issue. Respondent number 2 to 28 is
ಅದ್ರಲ್ಲಿ ಏನು?
dispense, my lord. Notice,
2 to 28 dispensed at the risk of the petitioner.
please.
So, yes, next.
28.
Tag with Uday Taleshe.
Number 40.
Commercial OS, is it?
Yes, my lord.
Why?
It's a order was passed on issues, my lord, wherein court has took up the issue as preliminary issue in respect
Correct,
of
whether
arbitration.
it is maintainable or not.
Because they ought to have filed an application under section 8. At the first instance itself, they did not file any such applications. Court framed the issues. And court held that
Question of jurisdiction, definitely it can, at any time, we will see.
there are caton of rulings of
The
Supreme Court, my
petitioner
lord.
to serve on the council who represents, why banks are parties?
Recovery proceeding, your honor, as
The-
against a bank.
Petitioners shall serve on the council who represented the defendants before the concerned court. The learned counsel for the petitioner submits that the suit was to be tried only before the commercial court and not as a regular suit. Therefore seeks its restoration on plethora of grounds. In the light of the said submission, list the matter on 1st August. Further proceedings before the order dated so and so shall remain stayed till the next date. Next.
29.
Ill health, how many days?
Sir,
Commercial
963
Commercial
days.
OS.
No, it's not commercial. MA.
MA,
Bias and
MA.
miscellaneous and MM.
Miscellaneous was dismissed. Subsequently, they preferred appeal, miscellaneous appeal.
Yes.
That has been allowed.
Ah.
The same has been challenged by me, the plaintiff.
ಯಾಕೆ ಅಲೋ ಮಾಡಬಾರ್ದಾಗಿತ್ತು?
Remand back, actually, they are not participated. Every proper steps has been taken. In spite of that, there are 963 days it is delayed.
963
days.
In filing
delayed
the appeal.
While filing the miscellaneous.
That is condoned.
No, that has been dismissed in the first occasion in the miscellaneous. Subsequently, in the miscellaneous, first appeal.
Appeal ಹಾಕಿದ್ರಾ?
Yes, yes, my lord.
Where is the order?
Order is annexure.
In MFA,
MM.
Annexure H, my lord.
77.
page?
Yeah,
77.
77.
Suit for?
Specific performance.
They are new plaintiff.
Now, I am plaintiff.
You are the plaintiff.
I'm the minor. At that point of time, I'm the minor.
Yes, sir.
My lord.
1000 days delay.
No, no, no. What happened, my lord? The suit filed against the
ನೀವು ಮೇಜರ್ ಆಗೋವರೆಗೂ ಕಾಯ್ತಾ ಇದ್ದೀರಾ?
defendant number 1, 2, 3. Kindly turn a moment in page number 39, my lord, a moment. Initially, they not filed any application for against the minor. No guardian has been appointed. In page number 39, they produced the order sheet, my lord. 39 order sheet. No application 32 rule 3 has been filed. The notice has been issued by the trial court and the defendant number 1, 2, 3 has been appeared. And after that, the taking steps of the minor defendants, they filed application after filing of institute suit on 2/11/2011.
Suit of?
Suit of specific performance.
2011.
2011. They filed application after institution of the suit.
All right.
My lord, and directed, no notice has been issued to the minors.
All right.
And my lord, thereafter, on the same day, on 17/8/2022, the application came to be allowed and written statement has been allowed. So written statement has been not filed by the defendant. But my interest has not been protected by my guardian. He is not contested the case. My interest has not been protected by my guardian. My lord, in this regard, the judgment of the Honorable Apex Court, my lord.
ಕೊಡಿ.
Para 23, my lord, page number. In this case also, there is a 862 days delay, my lord. In the first para itself. My lord, para 23 in page number 70.
Yes.
Annexure B, I filed an application for the appointment of the guardian that.
ಆಯ್ತು contest ಮಾಡಿ.
The matter is posted for on 1 date for evidence issues has been framed, written statement has been filed.
Vegan month challenge.
On 1 date it posted for the evidence.
Contest the suit.
Expeditiously, it may be.
ಅದು ಮಾಡ್ಬೋದು. The petitioner is before this court calling in question an order dated 9/4/2025 passed in MA 23 of 2024. The learned counsel for the petitioner would give up all the prayers and submit that if a direction is issued for expeditious disposal of the suit in OS,
672 of 2000.
672 of 2011 would suffice for the present. In the light of the suit pending for the last 14 years, and the prior sought by the petitioner being innocuous, I deem it appropriate to infuse finality into the proceedings by directing the concerned court to dispose OS so and so with an outer limit of 6 months, if not earlier, from the date of receipt of the copy of the order.
30.
Please, my lord, defendant's writ petition, suit for specific performance. Plaintiff files an application for appointment. Admission kottadmele, it's a suit for specific performance. Personal knowledge irbeku. SPA holder, my lord, kindly.
SPA holder is bought in when, sir?
After partially cross-examined. Page 85 notes.
Reason?
Yeah, medical illness anta ಹೇಳ್ತಾರೆ. They have not produced anything, my lord. They have not produced anything. Kindly see.
We'll see the evidence will remain. He will conduct the proceedings, that's all.
No, SPA holder cannot give, it's a suit for specific
ಆಗೋಗಿದೆ ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ
ಇಲ್ಲ partially kindly see.
ನೀವೇ ಹೇಳಿದ್ರಿ ಈಗ ಆಗೋಗಿದೆ ಅಂತ.
Partially ಆಗಿದೆ cross. Kindly see page 85.
Petitioner to serve on the counsel representing the plaintiff before the concerned court. Plaintiff hyphen respondent number 1 before the concerned court. List the matter on 25th.
So kindly see
25th in
85.
plenary hearing. What's the next date?
28/8.
List the matter on 25th. Yes, next.
31.
Present the advocate for the petitioner, my lord, is
WS is taken on record after 120 days?
it was not taken, my lord.
Not
application
taken
was
correctly, yes.
That was rejected, my lord, since there was a delay of about 50 days, my lord. After
One
the
day
mandate.
also gone. No written statement.
Para 4 of my affidavit to the
Oh, you
application,
may
my
have
lord.
an excellent ground, but 120 days, there is no condoning power there.
My lord
Even
has
this
taken-
court has no condoning power.
That is the only ground, my lord.
That's
I
the
bear.
only ground that Wobex's arrest.
Para 4 of my affidavit to the applications, my lord. Not inordinate delay, my lord. There was a
Delay
50
is
days.
delay, sir. Where if it were to be a regular suit, no problem.
I understand, my lord.
Not commercial OS.
I understand.
The petitioner is, the petitioner, the
My lord, serial
defendant,
number 36 also same, my lord, arising out. of
common
this-
order ಮಾಡ್ಬಿಡ್ಲಾ?
In the common order, my lord.
These petitions arise out of a common order passed by the concerned court in commercial OS 137 of 2024, dated 21/4/2025, by which the filing of the written statement along with the counterclaim comes to be rejected by the defendant, comes to be rejected on the score that it is filed after the period of limitation getting over, i.e. beyond 120 days. The issue need not detain the court for long or delve deep into the matter. This court in so and so on judgment in the court has, while considering the same, considering this very issue, is held as follows. In the light of the law being clear, there can be no expansion of limitation that is prescribed under the act, prescribed under law, with particularly of commercial suits. In the light of the issue standing answered as quoted herein above, the petition does not deserve any entertainment. However, the defense of the petition will say, ಮುಂದೆ ಯಾಕವಲ್ಲ ಬೇಡ, so and so is dismissed. Next.
Serial number 36 also.
Same. ಎರಡು ಕಾಮನ್ ಆರ್ಡರ್ ಮಾಡಿ.
The application filed for the recall of PW2 for cross-examination is
ಕಾರಣ
because of the ill health of the advocate ಅಂತ
ಎಷ್ಟು ವರ್ಷ?
ಅಲ್ಲಿ ಜನವರಿಯಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ ಚೀಫ್.
ಅಲ್ಲ ಎಷ್ಟು ವರ್ಷ, ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಕೇಳಿದ್ರಿ? ಎಷ್ಟು ಸರ್ತಿ ಮಾಡಿದ್ದೀರಾ ಮುಂಚೆ?
ಇಲ್ಲ, ಒಂದ್ಸಲ ಅಡ್ಜರ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ವಿ PW2ಗೆ. PW1 ಆಗಿತ್ತು. So
The petitioner is before this court calling in question an order passed by the concerned court, commercial OS.
commercial wise.
ಎಷ್ಟು ವರ್ಷ ನಡೆಸ್ತಾ ಇದ್ದೀರಾ ಮತ್ತೆ?
Actually earlier it is a regular transfer to commercial.
In commercial OS 134 of 2021, whereby the concerned court rejects recall of PW2 for further cross-examination as he was partially cross-examined on a particular day. I deem it appropriate to prima facie grant one opportunity, but after hearing the respondent, list the matter on 25th. Petitioner to serve on the counsel for the respondent and final acknowledgement.
One more WP.
ಯಾವತ್ತಿದೆ ಅದು?
31/7 ಇದೆ.
ಸರಿ ಕೊಡಿ. ಇನ್ಯಾವುದಿದೆ?
ಇನ್ನೊಂದು
Tag the petition along with so and so. Next. 39(1) and 2.
Yes, my lordship.
Ah,
Suit for injunction.
correct. Now they are represented. What was the next date?
31/7, my lordship.
Huh?
31/7.
31/7. The petitioner is before this court calling in question. 31. Avatin for next date, are they represented defendants?
Illa, still they are not it.
Emergent notice to the respondents, defendants. The petitioner shall serve the defendants by way of hand summons as well. List the matter on 1st August. Again, suit for?
Suit for injunction, my lordship. They are respondents are no way connected to the property.
The status quo, the property we made, injunction. The respondents, defendants are restrained from interfering with the position of the petitioner till the next date of hearing. List on first.
Obliged.
Next.
34.
For the petition.
617 allowed for the second time.
Please, my lords, after this, at this stage of arguments, my lords,
First application ಯಾವಾಗ allow ಆಗಿದ್ದು?
first application 2017, 24.
2024. You are what, defendant?
I'm defendant number 1. Plaintiff amends, my lords, seeks
The
for amendment of
petitioner
plaint.
is the defendant. In suit in OS 134 of 2014, the plaintiff is permitted the first amendment by allowing the application on 20th March 2024. The plaintiff would again repeat the same on several grounds. It also comes to be allowed on 3/4/2025. Prima facie, the repeated application seeking amendment of the prior at the fag end of the proceedings ought not to have been permitted by the concerned court, as the affidavit so filed seeking such amendment bears no reason for seeking the said amendment. In that light, further proceedings the order dated so and so 3/4/2025 shall remain stayed. It is made clear the trial is not stayed. It shall proceed according to it shall proceed in terms of what was available before it prior to 3/4/2025. Emergent notice to the response.
Great.
Next.
For the petitioners in this case, my lord, I apologize for appearing on VC. A week's time may be granted to produce the certified copy of the OS.
Current counsel for the petitioner seeks a week's time to produce a certified copy of the order passed by the first appellate court.
OS 29 of 2024, my lord.
List the matter on 30th. Next.
My lord, 29th if it's possible.
30th, sir. Yes, next.
Much obliged.
36 is for 37.
Appear for the petitioner, my lord.
You serve, sir. 23 Rule 3.
This petition may be called along with writ petition 18/38, my lord.
18?
18/38 of 25.
18038.
Yes, my lord.
Barkodi. Tag this petition along with so and so. List them both on 30th. Next.
38.
The petitioner is before this court seeking the following prayer. The petitioner is the defendant, files an application seeking vacation of the interim order under 39(4) of the CPC, order 39 Rule 4 of the CPC. The said application is not taken up by the concerned court despite it being filed a year ago. In that light, I deem it appropriate to direct the concerned court to dispose the application filed under order 39 Rule 4 in OS 195 of 2023 in the next 4 weeks, if not already decided. 4 weeks from the date of receipt of the copy of the order, if not already decided, ordered accordingly.
39.
Yes, next. The petitioner is before this court calling in question an order dated 28/3/2025 by which the application of the petitioner under order 16 Rule 1A comes to be rejected. The application was preferred for production of Google Maps. It was the concerned court ought to have permitted the same to resolve the dispute. the same is being rejected is contrary to law. In that light, further proceedings before the concerned court shall remain stayed. The petitioner shall serve on the counsel who represents the plaintiff before the concerned court and file an acknowledgement of such service list on 6th August. Next.
My Lord, I appeal for the petitioners. Petitioners who are judgment debtors before the execution court. My Lord, the respondent sought to execute a decree which is a nullity. My Lord,
why?
My Lord, the suit for injunction.
All right.
My Lord, the defendant was died in the year 2014. The impugned decree was passed in the year 2016.
LRs are not brought on record?
No, my Lord, it was not brought on record.
You are the judgment debtor.
Debtor who are not parties to that in a decree.
Why?
No, we
were not made parties?
No, my Lord, we were not made as a party. Lord, ink page.
Page, where is the decree?
Decree, my Lord. Now judgment debtors, my Lord. Ink page 61, my Lord, decree. Annexure E. Nanjegowda, Madegowda. Illa Swami. Then execution.
Legal heirs idangidira?
Illa, now Oppa legal 96, my Lord, in page 72, my Lord, execution petition.
Suit for?
Suit for injunction.
You are in possession of the property?
Yes, my Lord, we are in possession of the property. Even, my Lord, the police officer.
Petitioner judgment debtors are before. Alle executing court alle heli adna?
ಹೇಳಿದೀವಿ ಮಾಡಲಿಲ್ಲ ಸ್ವಾಮಿ ಮತ್ತೆ ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ನಾನು ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೂಡ ಕೊಟ್ಟಿದ್ದೀನಿ
The petitioners judgment debtors, the petitioners who are described as judgment debtors in the decree pursuant to the decree in the execution proceedings are before this court contending that the judgment debtors were not parties to the suit. The injunction is, the suit for injunction is decreed in the year 2016.
4/4/2016.
4/4/2016, by which time the defendants therein, defendants before the concerned court had already died.
That is on 11/10/2014 as per annexure
Died
C.
on 11/10/2014. Therefore, the learned counsel submits that there is no executable decree against these petitioners who are drawn as judgment debtors, and the concerned court has not considered the application of the petitioners and has now ordered for police protection on the score that the petitioners are interfering with the property of the decree holder. In the light of the aforesaid, there shall be an interim order of stay of further proceedings in the execution till the next date of hearing. Yes.
Grateful.
List the matter on 6th August. Emergent notice written by 6th
yes.
August. Yes. Next.
41.
Application allowing an application under 22 rule 3 of the CPC after inquiry. The respondents claim to be the legal representatives of the original plaintiff, deceased
The
plaintiff.
petitioner is the defendant.
Please.
Calls in question an order dated 7/4/2025 in OS 1217 of 2017, whereby the concerned court allows an application under order 22 rule 3 of the CPC. In the light of the submissions made, there shall be an interim order of the order date. There shall be a stay of the order dated, order impugned. It is made clear further proceedings before the concerned court are not stayed. Yes, next.
One submission. 52 is also the same matter between the same parties.
Wait.
Please.
Yes.
42.
No, there
617 rejected.
Not rejected, but there are two final decree proceedings are pending, my Lord. The one is filed by the petitioner arising out of the OS number 401/1989. The suit filed by the petitioner for the relief of partition, my Lord. The another one suit filed by the respondent number, father of the respondent number 1 to 5 in OS number 74/1988, my Lord. That was ended in compromise. Arising out of the compromise, they have filed the father of the respondents filed FDP number 16/2021.
All right, you serve on them.
Brother,
I will not state. Yes.
the hearing date is on 29/7. The commission has already filed report.
List the matter on 28th. Petitioner to serve on the counsels representing the respondent and file an contesting respondents and file an acknowledgement by the 25th. Yes. Next.
43.
Appear for petitioner, kindly pass over, my Lord.
Pass over. Why, sir?
My lord, in this matter, my lord, the suit for partition filed by the respondents, my lord, the petitioner are the 5 and 6 in different 5
When
and
did,
5 and 6,
when did you file your counterclaims?
my lord, on 5, my lord, on 13/7/2021, my lord. My lord, only on the deal
Counterclaim ಯಾವಾಗ ಹಾಕಿದ್ರಿ ಹೇಳಿ sir?
13/7/2021
What is the stage of the proceedings?
My lord, different evidence ಇದೆ ಸ್ವಾಮಿ, DW1 evidence.
Will not permit, sir. Yes.
My lord,
Nothing wrong with the order.
My lord, in page
Suit
number
of the year
67,
2014. Yes.
my lord, page number 67, my lord, para number 6 ಅಲ್ಲಿ ನಾನು contention ತಗೊಂಡಿದ್ದೀನಿ ಸ್ವಾಮಿ, but there is no prior, my lord. For that reason only, my lord. Page number 67, para number 6 ಅಲ್ಲಿ ಸ್ವಾಮಿ.
What's the next date?
Next week ಇದೆ. Next week ಇದೆ.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings. Next. And file an acknowledgement of such service. Next.
Date may be.
Please, ma'am. The petitioner is before this court calling in question an order dated so and so, whereby the concerned court allows the application filed by the respondent seeking application filed by the respondent and order 6 rule 17 permitting amendment of the plaint. Correct?
Oh, Swami. After conclusion of trial.
Correct. Amendment of the plaint at the fag end of the trial in a suit for
declaration.
In the suit for declaration, prima facie, the order of the concerned court runs counter to law as it is hit by the proviso to rule 17. In that light, the order dated so and so shall remain stayed. Emergent notice to the respondent. It's made clear that trial is not stayed. Yes, next.
45.
Appears for petitioner. Trace for 2 days. Out of station is senior.
Out of station.
Emergency ಅಂತ ಬರುತ್ತೆ.
Case ಅಷ್ಟೇ ಎಲ್ಲ out of station. ಇಲ್ಲ. What you claim to be secured creditor? Yes, sir.
2 days.
List the matter after 2 weeks. Yes, next.
46.
Petitioner in this case, suit for declaration.
Correct, sir. 21/4/23 order.
Please, my lord.
ಇವಾಗ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Now the by of interfering, they want to change the nature
file
of
another
property.
application if you want. 3 ವರ್ಷ ಹಳೆ application ನ ಇವತ್ತು ನಾನು stay ಮಾಡಲ್ಲ.
Even still, not applications is not considered, my lord.
Which application?
All IA number 2, 3, 4. One, not to change the nature, not to alienate and not to interfere.
1 into ಹಾಗೆ ಇದೆಯಾ?
ಹಾಗೆ ಇದೆ.
ಸರಿ, ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡೋ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತೀನಿ, not the first one.
Defendants are placed ex parte, my lord. And only the contesting defendant is the defendant number 10 to 12.
No problem. I will allow prayer B.
My lord.
Prayer B I will allow.
Please, my lord.
Not A.
Let my applications be considered, my lord.
ಅದೇ prayer B,
Now
sir.
one
ನಿಮ್ಮ petition ನೋಡಿ ಸ್ವಲ್ಪ.
Please, my lord.
ಎಲ್ಲಿದೆ ಫೈಲ್?
Please.
ನಿಮ್ದೇನಾ?
ಹೌದು ಸ್ವಾಮಿ.
The petitioner is before this court seeking the following prayer. The counsel for the petitioner would now restrict his submission to a direction to the concerned court to consider the applications pending before the concerned court in IA 2, 3 and 4 filed under order 39 rule 1 and 2. Amala?
All the
order 39 rule 1 and 2. The submission of the counsel for the petitioner is that even today those applications are pending and not considered despite them being filed with 2.5 years ago. In that light, I deem it appropriate to direct the concerned court to hear the parties and pass necessary orders on the pending applications. It is made clear the court has not pronounced, considered the merit of those applications, the merit of this application within, to dispose within 4 weeks from the date of receipt of the copy of this order. It is made clear.
My lord, defendants are placed ex parte, my lord.
Already placed ex parte. Why?
Please, my lord. All defendant 1 to 10 and 13 are placed ex parte. And only 11 and 12 are avoiding the service.
15 days anta ಮಾಡಿ. Yes, next.
47.
ಅಲ್ಲೇ ಮಾಡಿ. ಯಾರು ಇಲ್ವಲ್ಲ ಮುಗಿಸ್ತಾರೆ, ಸೂಟೆ ಮುಗಿಸ್ತಾರೆ ಬಿಡಿ.
ಅಲ್ಲ, they are not considering my IS, my lord.
Short date.
Why, madam? 38.
47.
47 ಹೋಗ್ತದೆ.
Counsel on record is not well known.
Concurrent.
Any day.
At the request of the council appearing for the petitioner, list on Monday, 28th.
48.
The petitioner.
Objections ಬೇಕಾಗತ್ತೆ. Will not state.
My lord, I have taken 3 adjournments and last week I filed application for taking adjournment. In fact, I had filed application for appointment of commissioner. So the trial court has rejected on the ground that we have not disclosed the formation of suit for declaration, mandatory injunction and possession in respect of B scheduled property which measures 4 gutas, which is part of A scheduled property. So I have, in fact, I have disclosed in my plaint. My lord,
There is heard the learned counsel for the petitioner. There is no representation on behalf of the caveat or respondent. List the matter on 28th. Till the next date, the learned counsel for the petitioner submits that the orders that are challenged are contrary to law, as the appointment of the court commissioner in the subject suit was imperative for the reason of identification of the property, i.e. the B scheduled property which the petitioner is claiming, which both the petitioner and the respondent are claiming. In that light, further proceedings before the concerned court shall remain stayed till the next date of hearing. List on 1st August.
49.
Reopen the case at the fag end.
Yes, my lord.
The petitioner is before this court. There is no representation behalf of the caveat. The petitioner is before this court calling in question an order dated 16/4/2025, allowing an application in IA 15 and 16 in the subject OS of the year 2014. The applications are preferred to reopen the case from the stage of examination.
Arguments.
From the stage of arguments.
After hearing arguments, this application has been.
That's correct. At the reopen the stage from the stage of examination after the arguments of the parties, after the arguments of all the parties were completely concluded. In that light, there shall be an interim order of stay of the order dated so and so. It is made clear further trial is not stayed in the case at hand. Yes. Next.
50.
For the petitioner.
So the application seeking to refer the signature of the father to a
Page
handwriting
33.
expert. Hello?
Page 33, sir.
Yes, my lord.
No ground.
My lord,
nothing wrong with the order.
My lord may kindly see issue number 2. The burden is on me to prove that there was a
Correct, sir.
family arrangement. And
Suit for partition.
Suit for partition. My lord, defendant denies, plaintiff denies in the witness box the signatures.
One niche.
My lord, kindly turn to page 61. The PW1, para 7, evidence. Now I see signatures on diary shown to me. It is not signature of my father. So she denies. My lord, I mark it in my evidence at page 69. Exhibit D41. ವಕೀಲರ ತಕರಾರಿಗೆ ಮತ್ತು ದೃಢೀಕರಣಕ್ಕೆ ಒಳಪಟ್ಟು. My lord, it is marked subject to objection. Now kindly turn to the document, my lord. Document is at page 81.
Yes, sir.
Handwritten.
One moment.
Lord, the application was filed, my lord, for comparison of handwriting and the signature. My lords may take those 2 documents, my lord, which were referred. My lord, there's no handwriting at all. The only signature of the
page.
One, my lord. My lord, page number 92, my lord. 90 for a moment. Annexure L and annexure M, my lord. Annexure L and annexure M were sought to be compared with the diary, my lord. Lord, in
Annexure LL signature matra, na?
Please, my lord. Even in annexure M, it's a typed document.
Annexure
But
M
the trial court
signature.
has held that there's no handwriting, my lord, which is to be compared with the alleged diary. And this application
My
was
lord,
filed after a period of 13
signature,
years.
my lord, signature can be compared, my lord, because the right below the
2012
contents.
suit.
Please.
My lord, right below the contents, my lord, signature is affixed. Signature can be compared if
not on that. It's not necessary. Yes.
My lord, the application is specifically seeking to compare both signature as well as the handwriting. Yes, I agree that there is no available handwriting.
Then
My lord, what
Why
happens?
why should you seek such orders? Yes.
My lord, what happens is otherwise there is no way I can prove my case.
I
My
will
lord, there
say,
is a
yes.
specific entry conferring, it creates a vested right in my favor insofar as the
List on
property.
28.
My lord, 23rd is the next.
No, take, seek an adjournment.
They have to,
Seek an adjournment. Yes.
it
I'm
is
not
for
convinced
plaintiff's
at all.
argument, they will proceed with the arguments.
No problem. Yes. List on 28. Please.
51.
Great.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement of such service by the 25th. List on 1st August. Further, the further proceedings before the concerned court shall remain stayed till the next date. Yes, next.
52.
Order impugned is an order passed under 22 Rule 3.
Not a wife?
No, my lord. She claims to be the wife. There is, after inquiry, the court holds that the defendant has to establish a superior position in order to say the respondent is not the wife. Whereas the 22 Rule 3 does not make any distinction, irrespective of the nature of the relationship.
What is suit for?
Suit is for mandatory injunction and to hand over possession and an injunction.
23 Rule 3.
22 Rule 3, my lord.
Let's see, serve on the respondents. Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement by the 25th. List on 28th. Sorry. Yes.
53.
Next. 39 1 into R, they represent government.
My lord, I am
Huh?
seeking, because it is a election petition, my lord.
Election petition.
Oh, before
Stop the affairs of the respondent Samaja. They're interim order.
The interim order, ಅಂದ್ರೆ they are appearing and proceeding for the proceeding relating to finance, all these things, my lord.
ಏನ್ ಕೇಳಿದಿರಿ?
ಅಲ್ಲ, only direction I am seeking, my lord.
Conduct the proceedings day to day.
ಅಲ್ಲ, election petition within 6 months it can be
ಆಯ್ತು ಅಂದ್ರೆ.
disposed of.
We will only direct expeditiously as possible. ಅಷ್ಟೇ.
Within 6
No,
months, my lord.
day to day.
Because election petition, my
ಆಯ್ತು,
lord.
6 months, fine.
Yes.
It's 2025 OS, sir.
ಹೌದು.
The petitioner is before this court seeking the following prayer. After arguing the matter at length, the learned counsel of the petitioner would restrict his prayer for a direction to the concerned court to dispose the suit in OS 42 of 2025 within a timeline. The petitioner is the plaintiff, calls in question the elections conducted to Taluk Executive Committee of the third respondent.
Yes.
Since the issue is of the elections and the matter will have to be decided expeditiously, I deem it appropriate to direct the concerned court to conclude the proceedings with an outer limit of 9 months, if not earlier. Yes,
Please.
next. Ordered accordingly.
54.
Suit for partition. Petition number 1 to. respond number
39
1.
1 and 2 not considered.
Please, ma'am.
Are they represented now? What is the next date?
Next date is, my lord, 8/9, my lord.
Notice issue ಆಗಿದೆ ಯಾವತ್ತು?
ಆಗಿದೆ, ಲಾಂಗ್ ಬ್ಯಾಕ್ ಆಗಿದೆ.
ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿಲ್ವಾ ಡಿಫೆಂಡೆಂಟ್ಸ್?
ಇಲ್ಲ, ಮೊನ್ನೆ ಲಾಸ್ಟ್ ಹಿಯರಿಂಗ್ ಡೇಟ್ ಅಲ್ಲಿ ಆಗಿದೆ. ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ಮೇಲೆ ಅವ್ರು ಗೊತ್ತಾಗಿ ಹಾಕಿದ್ರು, ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ.
ಹಾಕಿದ್ದಾರೆ. So we'll direct the court to consider it on 31st.
Please.
The petitioner is before this court seeking the following prayer. What drives the plaintiff to this court is non-consideration of a grant of a temporary injunction under Rod 39 Rule 1 and 2. The learned counsel for the petitioner submits the defendants are now represented before the concerned court. Therefore, I deem it appropriate to dispose the petition with a direction to the concerned court to hear the to permit the petitioner to move an application seeking advancement of the proceeding and to the 31st of July 2025. ಅವ್ರಿಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಗುತ್ತೆ?
ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡ್ತೀವಿ.
So and so. ಇಲ್ಲಾಂದ್ರೆ ಸರ್ವ್ ಮಾಡ್ಬಿಡಿ. I will take it on Friday. The petitioner to serve on the counsel for the defendants by the 23rd, list the matter on 25th and preliminary hearing. Our dispose ಮಾಡೋಣ. ಈಗ ಸರ್ವ್ ಮಾಡ್ಬಿಡಿ. Yes, next.
55.
Why 2197 rejected?
But he is not appeared.
Not appeared ಅಂದ್ರೆ?
and he is not contested and it is not dismissed. It is.
Who are you?
I am the decree holder. I am the decree holder. Third party, he has not nothing to do. He is a son of respondent number 3.
LAC na?
LAC. For taking the compensation.
Compensation, you are the decree holder.
I am the decree holder.
What were you doing?
But I have filed the application for 1/3 share to release the amount.
Serve on the respondents. The learned
Directed trial
HCGP
court
is
to-
directed to accept notice for 1 and 2. Petitioner to serve set of papers upon the aforesaid counsel. Petitioner shall serve the counsel who represented the judgment debtors, i.e. 3 and 4, before the concerned court. List the matter on 1st of August. Compensation, if not dispersed today, shall. 2197 rejection ashte. Yes, list on 1st August. Next.
56.
Of attachment IA.
Conditional attachment.
It was done ex parte. We are just seeking.
What ex parte?
That
Order
order was
demonstrate ex parte.
Order is at 11/10/23. Page 19.
19.
Yes. Where is the conditional attachment? Order is at page 20, my lord. Page 19 is the order, bottom, middle.
Where is the conditional attachment orders?
Page 20. In the facts and circumstances of the case.
Page 20 na, 18 na.
20 mail, my lord. Exercising jurisdiction or 38 rule 53 of the CPC, the property mentioned in IA number 5.
Conditional letter subject to hearing of the parties after the appearance of the LRs.
Yes, from 23 till now they have not heard the lifting of attachment IA.
Yeah, 2 ವರ್ಷ ಆಗಿದೆ.
2 ವರ್ಷ.
We will direct the court to consider your application.
Within 2 months.
Within 4 weeks.
4 weeks.
They heard the learned senior counsel to Vivek Reddy appearing for the petitioner. The petitioners are judgment debtors. What has driven the judgment debtors to this court is a direction, is the non-consideration of an application filed by the petitioners under order 38 rule 1 and 5, seeking recall of the order of conditional attachment. The order that has become the bone of contention now reads as follows.
20, page 20.
Page 20, marked portion. The learned senior counsel would submit that a direction be issued to the concerned court to dispose the application filed under order 38 rule 5 and 1 and 5 of the CPC, seeking recall of the said order within a time frame. Therefore, the concerned court shall consider the application within 4 weeks from the date of receipt of the copy of the order and pass necessary orders in accordance with law, if not already passed.
Yes, please.
Yes. Next.
Oblige. Same matter.
Same.
Two executions.
Same order.
Please.
What is the stage of the proceeding?
So the defendant evidence.
Application ಹಾಕ್ದಾಗ.
Defendant evidence. Defendant evidence.
Issue frame ಆಗಿದೆ ಯಾವಾಗ? Suit for partition.
Suit for partition. 2 properties are left out at the time of filing this.
All properties should be there.
So therefore, the present application is fine. Only 2 properties were left.
You have filed the application.
Yeah. Plaintiff filed the application.
The petitioner is the plaintiff, files an application under order 6 rule 17 seeking inclusion of 2 properties that were left out while instituting the suit. It is right that in a suit for partition, all the members of the family and all the properties, joint family properties must be in the suit schedule properties. In the light of in that light, the application filed by the petitioner should have merited consideration. The same is rejected contrary to law. Petitioner shall serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement. 6th August, further proceedings shall remain stayed till the next date. Next.
59.
1/10 application filed by the petitioner.
59.
1/10.
1/10 ಅಲ್ಲ ಅದು.
1/10 my lord.
59.
Please my lord.
ಏನ್ ಕೇಳಿದ್ದೀರಾ ಮೇಡಮ್?
Implead as a defined number 5 my lord. There is a registered sale agreement my lord.
When suit for what?
Suit for partition and separate portion.
When did you purchase it?
I have purchased in the 29/4/2020 my lord.
Suit instituted on?
suit is instituted
61 of
on,
2010.
18/6/22, my
Come
lord.
in the FDP. Preliminary
FTP
decree.
not filed, my lord. That is a stage in the,
It is still in the preliminary decree stage. You have no right to enter there.
my lord.
No, no, madam.
My lord, that is in the stage of evidence, my lord.
Maybe.
Evidence, my lord. My lord, I have got the compromise in the another suit. I have filed the specific performance suit, my lord.
Contest that suit.
Allah, already compromised, my lord. In between defendant number 1 and 2, my
You
lord.
have no right to enter into these proceedings, madam. Partition al nimden stranger you are.
I am not a stranger, my
Then
lord.
what, madam?
I suit item number 2 is my, I have purchased, my lord.
That is after the institution of the suit.
No, my lord. In the year 20, my lord.
Suit
Suit is-
yavaginda, madam.
Suit is filed on 18/6/22, my lord. 18/6/22, my lord.
Petitioner shall serve on the counsel who represents the plaintiffs 1, 2, and 3 in the course of the day. List the matter on
ಇವತ್ತಾಗ
Friday.
ವಸ್ತುರ್ಗ ಸ್ವಾಮಿ.
Sorry, Vasdurga. List the matter on 1st August.
Mara, there is a evidence, my lord. Already
Adjournment
chief examination ಇದೆ. ಅಲ್ಲ,
List,
ನಾನು-
list the
ನಾನು-
matter on 1st August. The
That is-
further proceedings before the concerned court shall remain stayed. Next.
60.
If a petitioner,
The
my lord,
petitioner is before the court calling in question rejection of an application under section 24 of the CPC seeking all the suits pending on the same cause of action to be tried before a concerned, before a particular court. The ಇದಕ್ಕೆ ಸ್ಟೇ ಎಲ್ಲಿ ಕೊಡಕ್ಕಾಗತ್ತೆ? ಆಗಲ್ಲ.
ಅಲ್ಲ, my lord.
ಯಾವ ಸೂಟ್ ನ ಸ್ಟೇ ಕೊಡ್ಬೇಕಾಗತ್ತೆ?
ಅಲ್ಲ, I want stay of the suit 1893, my lord, filed by the respondent number 3 and 4, my lord. My lord, if the suit for injunction filed by the respondent decreed, my lord, there will be chances
How
of
many suits are pending?
2 suits, my lord.
Sorry, which is the first suit?
For suit
OS 2018 ಯಾವ್ದ್ರದ್ದು?
25202, my lord,
Correct. Suit for
partition filed by the petitioner, my lord,
Hmm.
seeking partition. During the subsistence of interim order, my lord, the respondents have purchased the property. They have filed a separate suit before some other court seeking permanent injunction, my lord. It is pending,
No,
my
it's
lord.
correct to be tried. Anyway, for the petitioner, you are the purchasers, is it?
I am not purchaser, my lord. I am the plaintiff in the original suit, my lord.
2018 suit.
18 suit.
Which is the next suit?
Next suit is, my lord, at 1893, my lord.
The petitioner is the plaintiff in OS
25202.
OS 25202 of 2018 filed seeking partition and separate position. A subsequent suit is preferred seeking permanent injunction against these petitioners by a purported purchaser of the property during the subsistence of the present suit. The
Order, my lord.
Huh?
Subsistence of the interim order, my lord.
present suit and an interim order operating not to alienate.
Yes, my lord.
In that light, the petitioner preferred an application under section 24 for both the suits to be tried together to avoid conflict. The application comes to be rejected, rejection of which is prima facie erroneous. Therefore, the suit in OS, subsequent suit in
1893.
OS also shall remain stayed. Next. Till the next date of hearing, petitioner to serve on the counsel who represents the respondent in the trial proceedings, file an acknowledgement by 25th, 6th August.
61.
For the petitioners, suit for partition and declaration, my lord.
The petitioner is before this court seeking the following, our 2011 suit.
2011, my lord,
The petitioner,
is an octogenarian.
petitioner, an octogenarian, is at the doors of this court seeking expeditious disposal of the suit registered 14 years ago. The suit for partition and separate position. The learned counsel for the petitioner takes this court through the documents appended to the petition seeking to demonstrate that the concerned court has gone on granting adjournments for the asking and not concluded the suit. In the light of the advancing age of the defendant petitioner and the suit being of 14-year vintage, I deem it appropriate to infuse finality into the proceedings by directing the concerned court to dispose the suit in OS so and suit outer limit of 6 months, if not earlier, from the date of receipt of the copy of this order, ordered accordingly. Next. The petitioner is before this court seeking the following prayer. The allegation of the the allegation of the petitioner is that the application filed under Order 39 Rule 1 and 2 has not met its consideration despite it pending before the concerned court for the last 8 years. It is surprising that the concerned court has not disposed the application so pending has driven the plaintiff to this court in the subject petition. In that light, the concerned court shall dispose the application that is set.
This is under MA. on-
MA, the concerned court shall dispose
ಅಲ್ಲ,
the,
it is disposed of. It is
dispose ಆಗಿದೆಯಾ?
ಹೌದು, ಆಗಿದೆ.
ಮತ್ತೇನ್ ಕೇಳಿರೋದು ನೀವು?
Defendant's application under order 39 rule 1 and 2 came to be rejected
ಹಾ,
and subsequently he preferred an appeal.
ಹಾ,
In appeal, the application came to be allowed. And subsequent to the allowing of the application, they came near the property and created trouble. And
ಮತ್ತೆ
also,
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರಿ?
ಇಲ್ಲ ಹಾಕಿಲ್ಲ.
ಮತ್ತೇನ್
ಅಲ್ಲ,
ಮಾಡಿದ್ರಿ?
ಅದ್ರ ಮೇಲೆ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು MA ಮೇಲೆ.
ಅಲ್ಲ, if they create trouble later, ಮತ್ what is the?
ಅಲ್ಲ, they came to the police station and they have stated that we will not interfere with the 1 acre of property. That is there.
We will serve on the respondent.
ಅಲ್ಲ,
The
status
petitioner
quo
shall
ಇದೆ.
serve on the counsel representing the respondent defendants before the concerned court in the next, ಯಾವ court ಇದು?
ಅದು ಸಿರಾ.
Concerned court and file an acknowledgement of such service. What is the next date there?
Next date is 2nd of August.
List the matter on
Till then status
30th.
quo.
List
ಅಲ್ಲ,
the matter on 30th. Yes, next. ಅವತ್ ಕೊಡುವ.
ಅಲ್ಲ, ಇಲ್ಲ ಅವರು ಕೊಟ್ಟಿದ್ದಾರೆ.
30th. Yes. Next.
53.
For the petitioner, my lord.
Serve on the respondents. 2 and 3 Partition Act.
Indeed, my lord, for right of preemption is being sought. The
Right. Let's see. Sale ಇದೆಯಾ?
auction sale, the court has
When?
right of auction sale.
When?
24th is the court sale, my lord. 24th
The
July.
petitioner shall serve on the counsel representing the respondents. The petitioner is the co-sharer or a member of the judgment debtor.
Second judgment debtor, my lord. They are in
The-
possession of the residential house.
The
property.
petitioner is said to be the second judgment debtor. He is before this court that his right under section 2 and 3 of the Partition Act is not adhered to as you want to purchase the property.
Indeed, my lord.
And is wanting to purchase the property, we would further submit that he has precedence over the sale to be, precedence over the public sale. In that light, there shall be an interim order of stay of the sale slated to be held on the 24th till the next date of hearing. List the matter on 6th August.
64.
This case I am appearing for the petitioner.
My lord, appearing for.
Who are you, sir?
My lord, respondent number 4, my lord.
Suit for injunction.
Suit for
Yes,
bearing
my
injunction.
lordship.
Who are you?
My lord, I am the property being, this has been acquired
Acquired by what?
by notification, my lordship.
Application ನೀವು ಹಾಕಿದ್ದಾ?
Please, my lordship, for impleading, this has been allotted to the board, my lordship. Now, despite that, they have filed a suit in there.
Where is the allotment?
My lord, one date may be given, my lordship. I'll produce the document and
The
everything.
learned counsel appearing for the respondent. The petitioner plaintiff is before this court. Plaintiff, huh?
Plaintiff.
Plaintiff is before this court calling in question an order dated 12/6/2024 by which order date, no?
11/6.
Order dated 11th June 2025 by which the application of the respondent defendant under order 1 rule 10 comes to be allowed. The learned counsel for the respondent submits that he would place all the records on the strength of which the concerned court has allowed the application. Till such time, the order dated so and so shall remain stayed.
My lord, a date may be given.
Next list on, ನೀವು ಯಾವತ್ತು ಹಾಕ್ತೀರಾ?
We'll file in 2
List on 30th, next.
65.
Suit for injunction. my lord.
Witness summons.
To recall the stage, I posted for arguments.
ಮತ್ತು
To lead further evidence, I filed application. Suit for injunction. No,
ಅದರಲ್ಲಿ
only with
ಯಾವ
regarding
ಯಾವ
the
ವರ್ಷ?
only with regarding.
2017 ಇಂದ ಪೆಂಡಿಂಗ್ ಇದೆ.
Yes, my lord.
No,
Only with regarding the 4 guntas, the person who has executed the sale agreement and taken full entire amount. To recall that
No, sir,
witness.
nothing. What were you doing at the outset? ಗೊತ್ತಿರ್ಲಿಲ್ವ ಅವಾಗ? ಸುಮ್ನೆ ಡ್ರ್ಯಾಗ್ ಮಾಡಕ್ಕಷ್ಟೇ.
No, my lord. No, she is the very. No, I have filed the application. No, even I filed the documents in the last page number 59, 60. She is the agreement, she has executed.
ಮುಂಚೆ ಗೊತ್ತಿರ್ಲಿಲ್ವಾ? ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಬೇಕಾರೆ. Advocate change ಮಾಡಿದ ತಕ್ಷಣ ಮತ್ತೆ application recall, nothing.
After seeing that there are some materials has not been placed and important witness has been not.
ನಾವು injunction suit ಅಲ್ಲವೇ? Already.
ಇಲ್ಲ, ಯಾಕಂದ್ರೆ my lordship, she is the person
No,
has
no.
executed sale deed in favor of the defendants. She is the main witness.
Document ಇಲ್ವಾ?
Yes, there is a
ಮತ್ತೆ
document. my lordship.
document ಇದ್ರೆ ಅದು ಬಿಡಿ.
No, in front
Nothing,
of her,
not
it
at
has to
this
be
stage, I will not
confronted.
permit. Nothing wrong with the order.
It has to be confronted, my lordship, because that is the document.
What
which is
were you
very
doing,
most-
sir? It is a document of vintage. You should have confronted it at the time when cross-examination happened.
No, they
Not
were
at this
previous,
stage, I will
previous
not
counsel was
permit.
not aware about that, and now it has came to knowledge.
Not at this
No,
stage.
within the period of 15 days or 10 days or 1 month, we will finish the case.
Right, you will make,
time
if the
may be
respondent consents, we will do it. Petitioner to serve on the counsel who represents the respondent in the trial proceedings.
Like-
List on 28th.
Till next date,
No,
because
no,
it is
no.
posted for our final arguments. my
No
lordship.
problem, sir.
No,
You
even the
notice
date is not
ಮಾಡಿದ್ದಾರೆ
given.
ಅಂತ ಹೇಳಿ, you take
No,
advantage of it.
no, date is not giving well.
No,
sir. Till next date, till next date.
ಇದೆ, no dismiss ಮಾಡ್ಬೇಕು ಅಂತಿದ್ದಾರೆ. Only if the
So,
respondent consents to it, will.
30 days it may be framed, time may be
No,
fixed.
sir.
We'll
ಬರ್ಲಿ.
finish it up.
You get him, next week ಹಾಕಿದ್ದೀನಿ 28th.
66.
Judgment debtor,
Yes, my lords.
attachment warrant.
Attachment warrant.
What's wrong?
My lords, initially, my lords, motor vehicles accident claim tribunal awarded the compensation fixing the liability on the petitioner, my lords. As per compromise petition, my lords, at execution came.
Who
to
are
be-
you?
I am
Owner of the vehicle?
Owner of the vehicle, my lords.
Yes, sir. Anything else?
My lord, initially 3,25,000 paid by the petitioner in by filing compromise petition. During the pendency of the execution petition, my lords, claimants are filed MFA before the honorable court. That has disposed enhancing 11 lakh something, my lord. Subsequent to that, insurance company paid the compensation.
Joint and several.
Joint and several. Paid the, yes, pay and recovery, my lord. Illegal.
recover.
Pay and recovery. Earlier 3,25,000 euro comprehensive petition ಅಲ್ಲಿ ಪೇ ಮಾಡಿದ್ದಾರೆ. Again, ನಾವು ಇವಾಗ,
No, sir.
my lords, kindly appreciate, my lord. For a minute, my lords.
Any amount of appreciation will not lead to
ನಾನು
any
already
order.
3,25,000 yes paid. Now insurance company filed execution petition including that amount, my lords. Kindly.
ಅಲ್ಲ ಅಲ್ಲೇ before the executing court.
Once the attachment warrant is executed, my
Oh,
lord,
no,
nothing remains, my lord.
Take its recall on this ground.
My lords, meanwhile, petitioner in filed review petition. I am, prayer is limited for, till listing of the review petition, my lords, execution petition may be, for a minute, my
Yes,
lords, kindly, page number 77, my
No,
lords.
no.
Kindly appreciate, my lords.
We will not trouble the claimants. Yes.
ಇಲ್ಲ, claimants ತಗೊಂಡಾಗಿದೆ. Claimants ತಗೊಂಡಾಗಿದೆ. Now,
ನೀವು
insurance,
recover ಮಾಡಕ್ಕ?
now insurance company
On you.
filed execution petition against the petitioner.
Correct, pay and recover.
Yes, my lord. Claimants ಏನ್ ಮಾಡಿದ್ದಾರೆ, ನಾನು ಅರ್ಲಿಯರ್ ಕೊಟ್ಟಿದ್ದನ್ನು ತಗೊಂಡಿದ್ದಾರೆ. ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದನ್ನು ತಗೊಂಡಿದೆ. They have received excess amount.
ಯಾರು?
Claimants. For a minute, my lord, kindly.
Claimants ಅವ್ರ ಆರ್ಡರ್ ಪ್ರಕಾರ ಅವ್ರು ತಗೊಂಡಿದ್ದಾರೆ.
ಇಲ್ಲ, ನಾನು ಇನಿಷಿಯಲಿ 3,25,000 ನಾನು ಒಮ್ಮೆ ಕೊಟ್ಟಿದ್ದೆ.
ಯಾಕೆ ಕೊಟ್ರಿ?
For a minute, my lord.
ಅಲ್ಲ,
Page
ಯಾಕೆ
number
ಕೊಟ್ರಿ?
63. Initially filed execution petition against me. In that it ended with compromise.
MFA was pending then.
ಹೌದು, ಅವಾಗ ಪೆಂಡಿಂಗ್ ಇತ್ತು. 3,25,000 has been paid. Subsequent to that, my lords, MFA has disposed by enhancing the compensation amount. 11 lakh 2,000 enhance ಆಗುತ್ತೆ. Insurance company deposited 11 lakh.
Over and above 3 lakhs.
Yes, ಅದನ್ನು ಸೇರಿಸ್ಕೊಂಡು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ. Now
over and above 3 lakhs is what the order in
my
MFA
lords,
is.
kindly see the execution, their execution petition.
You go to the order in MFA.
My lords,
MFA order ಅಲ್ಲಿ.
ಇಲ್ಲ, page number 65, my lords. 74 ಅಲ್ಲಿ total compensation of rupees 11 lakh 2,800. ಮೂರು ಲೈನ್.
Page
74, my lords. 3 lines below, above, my lord, from the below. Thus, all claimants are held entitled to total compensation of rupees 11 lakh 2,800.
2011.
Yes, now,
ನಿಮ್ಗೆ 3,25,000 ಕೊಟ್ಟಿದ್ದೆಲ್ಲಿದೆ?
Page number 63, my lord. Compromise petition filed under order 23 rule 3.
ಲೋಕ ಅದಾಲತ್ತ?
Yes, ಲೋಕ ಅದಾಲತ್.
Page
63, my lord.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ?
3,85,000 award ಆಗಿತ್ತು. Settled at 3,25,000.
This was not taken note of by the division bench?
No, my lord, none of them are brought to the notice of this honorable court, my lord.
The petitioner, the owner of a vehicle which meets in an accident, is calling in question execution proceedings in 149 of 2021. The counsel for the petitioner submits that out of a compromise arrived at pending MFA 9902 of 2013, the claimants had received amount of rupees 3,25,000. The MFA in MFA 9902 of 2013 comes to be disposed, enhancing the to 11 lakhs, 11 lakh 2,800, which undoubtedly would be inclusive of 3,25,000 already paid by the owner in favor of the claimants. The court directed to pay the claimants and recover it from the owner, as the owner was found to be negligent. The execution petition is now filed, including the amount of 3,25,000 already paid by the owner, apart from the recovery of 11,02,800 is the submission of the counsel for the petitioner. In that light, the execution proceedings shall proceed without considering the amount that is already paid by the petitioner, 3,25,000 in pursuant to a compromise, till the next date of hearing. Emergent notice to the respondents. Respondents returnable by 14th August, list on 18th August, list on 18th August.
67,
It is made clear the execution proceedings are not stayed.
67,
See, the IA has been raised on same.
67 same.
Yes, ma'am.
ಯಾವತ್ತು ಆಗ್ತದೆ ಮಂಡೇ ಲಿಸ್ಟ್ ಆನ್ ಮಂಡೇ ಅದು ಸೀಲ್ ನಂಬರ್
Same number, 65.
65 ಜೊತೆ ಟ್ಯಾಗ್ ಮಾಡಿ ಮಂಡೇಗೆ ಹಾಕಿ. Yes, next.
68,
Not, there is an issue regarding identity of the property.
What identity? What is the B report impact in this?
Well, because the same allegation that I am constructing in violation of the order, FIR was lodged, B report is filed. In fact, not the, when an order of police protection was granted by the trial court,
ಈಗ ಏನಾಗಿದೆ?
this honorable court has not granted an order of stay. Now, my lord, after that, again a miscellaneous petition is filed, my lord, alleging contempt. When earlier the trial court, my lord, has taken a view, there is a dispute regarding identity, because, my lord, the partition suit is filed, my lord, claiming 2/5 share out of 5 guntas. I am the owner of 20 guntas of land.
Contempt miscellaneous petition.
Yes. My lord, again, my lord, harassing me the same.
The learned senior counsel Srinivas Raghavan appearing for the petitioner. The petitioner shall serve on the counsel who represents the respondent before the concerned court. The list the matter on 1st August. Till such time, the proceedings in miscellaneous 12 of 2024 shall remain stayed. Next.
69,
Why reopen the case?
Because we have produced certain documents which are related to the social property of 1913 and other revenue entries, Your Honor. So we have produced already that when permitted to be marked down, because that will show the flow of the title in favor of the plaintiff, Your Honor.
Suit of 2014.
14.
Yes, sir.
Already we have produced it. It will be marked and will be subject to offer of the cross examination by the PW1, Your Honor.
No, sir.
Immediately it can be done, Your Honor.
No. ಮತ್ತೆ ಅದರಿಂದ 10 proceedings will initiate.
No, no. They are only
No,
in
sir.
respect of the social
Suit for-
property. Suit for a declaration.
Oh,
possession,
yes, anything
cancellation-
else, sir?
Cancellation of the.
Anything
sale.
else, sir? Prove it in according to documents that are available. Yes, madam. ಏನು? Allow ಮಾಡಲಾ?
Kindly go to, no, my lordships, kindly go to page number 65, my lordships.
Yes,
Those documents were already, my lordships, it is of the documents.
already marked.
No,
No,
not.
my lordships, documents of the year 2015, my lordships. They have got a knowledge in the 2015, now they wanted to produce it, my lordships. It has been elicited in our objections, my lordships.
2021. Which paragraph, madam?
64, my lordships,
64.
64,
65.
first paragraph, my lordships. Particularly that those documents he intends to produce now are obtained by the plaintiff on 30th 11/2015, 9/3/2020 and 22/12/2021, about 4 years ago. Then such being the
Anything
case-
else, sir?
we have produced more than what documents are referred on because
Alla,
other
anything-
documents are not available with us here. That is the reason. That will
ಇನ್ನೊಂದು
prove
2
our
ವರ್ಷ ಬಿಟ್ಟು
case
ಇನ್ನೊಂದು ಹೊಸ ಡಾಕ್ಯುಮೆಂಟ್
easy to, that will be
you will
helpful
find documents after
for
documents.
proper adjudication of the case being
Yes, the
necessary.
petitioner is, anything else? The petitioner is before this court calling in question an order dated 16/6/2025 passed in OS 7354 of 2014, rejecting the applications filed by the petitioner order 18 rule 17 seeking production of certain documents. Heard so and so. The petitioner is the plaintiff. Institutes a suit for declaration and permanent injunction.
Possession and also cancellation. of the
Possession,
sale.
declaration and possession, and cancellation of a particular sale deed. What has driven the plaintiff to this court at this juncture is rejection of an application filed under Order 18, Rule 17, seeking production of 4 documents. The learned counsel for the respondent would take this court through the affidavit so filed by the petitioner plaintiff in support of the documents that are sought for. The affidavit reads as follows. Madam, at page.
My lordship, that is the objections filed by us,
Sorry,
my lordships.
the learned counsel for the petitioner respondent submits that those objections, those documents were already available at the time of institution of the suit or immediately thereafter. Therefore, the objections the petitioner, the respondent took is as follows. The learned counsel for the respondent would reiterate the objections so filed, contending that 3 documents that are sought to be filed are all either 10 years, are all between 5 years to 10 years old, which at all times was available to the petitioner. At the fag end of the proceedings, the subject application comes to be filed, and therefore the concerned court has rightly rejected those applications. The order of the concerned court rejecting the application reads as follows. Page
69, my lordships.
Page 69. Mark ಮಾಡಿದ್ದೀನಿ 68 to 70. I do not find any perversity in the order for this court to interfere in exercise of its jurisdiction in Article 227 of the Constitution of India, more so in the light of the fact that the application is preferred at the stage of arguments. Petition dismissed. Next.
Obliged.
70.
Gift deed before the appellate court, why?
Lord, appellate court, my lord, refuses it. And now there is an alienation by defendant number 1 in favor of defendant number 3. All that I'm saying is, my lord, let there not be any alienation or creation of third party rights.
You are the appellant.
I am the appellant, my lord, plaintiff.
Suit is still pending.
Suit is still pending.
The petitioner plaintiff, suit for partition, huh?
Suit for partition, my lord.
The petitioner plaintiff institutes a suit seeking partition of the suit schedule property in OS 493 of 2023. The concerned court declines to grant an answer the application order 39 rule 1 and 2. Rejects the application.
Vacating the ex parte order.
Rejects the grants an ex parte injunction which stood vacated on an application filed by the defendant under order 39 rule 4 of the CPC. The petitioner then prefers an appeal before the first appellate court. The first appellate court declines to grant the relief sought for, and therefore the petitioner is before the court. The learned counsel for the petitioner submits during the pendency of the subject pendency of the subject appeal, the defendants are selling the suit schedule properties. Therefore, to protect the interests of the plaintiff or the defendant, the defendant shall not alienate the property till the next date of hearing. List the matter on 6th. Petitioner to serve on the counsel who represents the respondent in the trial proceedings and the appellate proceedings and file an acknowledgement to that effect before the court or by the 25th.
Great.
Yes. Next.
Great.
71.
Who are you?
A villager and a devotee of the temple, my lord. There are parallel proceedings pending before the Karnataka Appellate Tribunal in respect of the same land, wherein the impleading applicant has filed an appeal, my lord. That's pending consideration. before the Karnataka Appellate Tribunal at ink page 26, Annexure B, my lord.
You are not a proper part, you are very difficult to.
My lord, have a judgment.
What interest do you have? Temple idu?
A temple, only to protect the interest of the temple, my lord. In fact, I rely upon a judgment of the honorable, this one, division and judgment. When a devotee can maintain a.
Correct, that I am not,
Please, my lord.
that I am aware. Yes. The petitioner shall serve on the council who represents the respondents in any of the proceedings pending between the parties. Till such time, further proceedings in suit so and so shall remain stayed on the score that the petitioner is wanting to implead into the proceedings to protect the interest of the temple. It is trite that a devotee can can implead himself into the proceedings, into the proceedings if the interest of the temple is involved in and the temple situated in the village in the place in which the impleading applicant resides. Yes, next.
72.
Suit for declaration, madam. Plaintiff has filed the
2610A.
2610A.
Nothing.
ಅಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಏನಿದೆ ಆ ಸೇಲ್ ಡೀಡ್ ನಲ್ಲಿ ಇರೋ LTM ನಂದಲ್ಲ ಅನ್ನೋದೇ ಪ್ಲೇಂಟಿಫ್ಸ್ ಕಂಟೆನ್ಷನ್. ಅದು ಸೇಮ್ ಕಂಟೆನ್ಷನ್ಸ್ ಪ್ಲೇಂಟ್ ಅಲ್ಲೂ ತಗೊಳ್ಳಿದ್ದಾರೆ ಮತ್ತೆ ಅಫಿಡವಿಟ್ ಅಲ್ಲೂ ಹೇಳಿದ್ದಾರೆ ಸರ್. ಇಟ್ ವಾಸ್ ಇನ್ ದ ಸ್ಟೇಜ್ ಆಫ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್. ಸೂಟ್ ವಾಸ್ ಇನ್ ದ ಸ್ಟೇಜ್ ಆಫ್ ಆರ್ಗ್ಯುಮೆಂಟ್. ಅದ್ರಲ್ಲಿ ಯಾರೋ ಬೇರೆಯವ್ರನ್ನ
ಕರೆಕ್ಟ್ ಆಗಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ.
ಬೇರೆಯವ್ರು ಯಾರನ್ನೋ ಕರ್ಕೊಂಡು ಹೋಗಿ LTM ತಗೊಂಡಿರೋದು ಬೇಸ್ಡ್ ಆನ್ ದ ಸೇಮ್ suit for declaration and the cancellation of same alleged sale deed, madam.
On the documents, nothing. Yes, ಏನ್ ರೆಫರ್ ಮಾಡಬೇಕಾಗಿತ್ತು?
As a fingerprint ನಂದು ಅಲ್ವೇ ಅಲ್ಲ, ಅದು ಡಿಫರೆಂಟ್ ನಂಬರ್
ಥಂಬ್ ಇಂಪ್ರೆಷನ್, ಫಿಂಗರ್ ಪ್ರಿಂಟ್ ಅಲ್ಲ.
ಥಂಬ್ ಇಂಪ್ರೆಷನ್
ಸೇಲ್ ಡೀಡ್ಸ್ ಗೆ ಫಿಂಗರ್ ಪ್ರಿಂಟ್ ಹಾಕೋ ಲೆವೆಲ್ ಬಂದಿಲ್ಲ.
ಸಾರಿ, ಥಂಬ್ ಇಂಪ್ರೆಷನ್ ಅನ್ನೋದು ನಂದಿಲ್ಲ ಅನ್ನೋದು ಪ್ಲೇಂಟಿಫ್ ನಂಬರ್ 1 ಆಗಿದೆ.
ನೋ ಸರ್.
ಮಿಲಾಟ್ಸ್ ಅದರಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ನ ಕ್ಯಾನ್ಸಲೇಷನ್ ಗೆ ನಾನು
serve on the defendant, list the matter on 28th. Petitioner shall serve on the counsel to the
case is on
defendant.
25th, Milord.
No sir.
Until then the stay may be granted.
No. Yes, next.
73.
For the petitioners, my lord, defendant's petition.
Status quo is reversed.
A temporary injunction was refused by the trial court, granted by the appellate court only on the ground that there is one notice issued by Tashildar for eviction of the plaintiff from the government land. It's a government, admittedly a government land. It is pleaded in the plaint as well. Her application for
Suit is instituted by the respondent plaintiff in OS 187 of 2021 seeking injunction against these defendants. A temporary injunction was refused after hearing the parties. This is called in question by the plaintiff in MA 2 of 2024. The first appellate court has now granted temporary injunction 4 years after its rejection. A perusal at the order indicates that it places reliance upon an order passed by your Deputy Commissioner.
Tashildar.
Order passed by the Tahsildar, in which eviction notices are issued to the
all the occupants, page 70 is that.
To
notice
all the occupants.
of government land.
All the occupants of the government land, which is a general order. In the light of no injunction being operating for 4 years, the order basing upon the order of the Tahsildar is on the face of it erroneous, albeit on the face is erroneous, albeit prima facie. Therefore, the order of the first appellate court shall remain stayed till the next date of hearing. Next.
74.
And for the petitioner, madam.
Concurrent.
No, madam.
TI rejected.
TI, first court, my lord, TI rejected, my lord. And the appellate court, my lord, granted TI, my lord.
Suit for?
Suit for injunction, my lord. By filing the injunction suit, my lord, they are sought for the declaratory relief, my lord.
No,
Easement right, my lord.
the injunction was refused.
In the trial court. In the MA court, it is granted, my lord. Though, my lord, the plaintiff's title deeds, my lord, in the schedule, my lord, not matching with the plain schedule, my lord. Though, my lord, in the plain schedule, my lord, plaintiff title deeds schedule, my lord, not matching with the plain schedule deeds, plain schedule, my lord.
That's the reason granted.
No, my lord.
That's the reason on which.
My lord, in
Yeah,
fact,
is
my lord,
acted.
there is no beaker of property, my lord. Trial court hold that there is no beaker of property, my lord. In the B schedule, they are treated that, my lord. The B schedule is the
Road property.
B, they are stating that, my lord.
What do you mean road property?
They are stating, in fact, there is no such road, my lord.
Well,
My lord, in fact, what has happened?
disturb the road, yes.
No, my lord, this is not the road, my lord.
You say you file. You're in cooperative society now.
I am the cooperative society. That
ಅದಕ್ಕೆ
entire building is. my
Road
lord.
is yours.
Road is mine, my lord.
Mine.
Sorry.
Road is
Society
yours, society da.
Society though, there is
ಹೆಂಗೆ?
no such road is existed in the
ಹೆಂಗೆ? Society road ಹೆಂಗಾಗುತ್ತೆ?
My lord, there is no such road is existed, my lord. What the plaintiffs are saying that they are the A schedule property owners. They are purchased by the some private owners, my lord. They are stating that, my lord, that what they are stating in the, my lord, kindly see the plaint, my lord, for a moment.
Correctly granted.
No, my lord.
We will not disturb it, yes.
Sorry, please, my lord, 1 second.
To
my lord.
serve on the respondents.
My lord,
The
for-
petitioner
for-
to serve on the counsel who represented the plaintiffs before the concerned court and file an acknowledgement of such service. List on 30th.
my lord, till then, my lord,
No, till then.
MA order may be
No,
stayed, my
no,
lord. For a moment, my lord, kindly see, my lord, saying that, my lord, they are creating the B
How
schedule.
can
they
a
are-
road be the property of a
My lord, there
cooperative
is-
society?
in fact, my lord, there is no such road is existed, my lord.
Adu nod, barli. Yes, next.
75.
My lord, kindly fix the
The
date, my lord.
petitioners are before this 30th ಹೇಳಿದ್ನಲ್ಲ. The petitioner heard the counsel. The petitioner is before this court seeking the following prayer. The petitioner is said to, the plaintiff, you are the plaintiff, right?
I'm the plaintiff.
The plaintiff institutes a suit in OS
654 of
of
2018.
654 of 2018 seeking
Relief of cancellation of the gift deed.
relief of
injunction.
cancellation of the gift deed
And
and
consequent-
files an application before the concerned court for recasting of issues under Order 14 Rule 5 on 29/9/2022. Despite the lapse of 2.5 years, the concerned court has not answered the application. It is therefore the petitioner is before this court. In the light of the aforesaid prayer, it is surprising that the concerned court has kept the application for recasting of the issues for the last 2.5 years. Therefore, the concerned court shall now answer the application within 15 days from the date of receipt of the copy of this order, ordered accordingly.
May I make one submission? Subsequent to that, the defendant have filed IA number 7 and 8.
What is that?
One, my lords, is for appointment of a commissioner.
Other order pass, Madam Milburn. Yes, next.
76.
Don't go beyond your prayer. Yes, next.
76.
Same case, my lord, Authorized order, same.
ಇದು court commissioner.
Yes, my lord, to appoint the court commissioner to prove that we are in the possession.
Monday. ಅವತ್ತೇ ಹಾಕಿರೋದಲ್ಲ ಎಲ್ಲ.
Yes, my lord.
Tag along with ಯಾವ್ದು ನಟರಾಜ್? 65, 67
76.
and 76. ಮೂರು tag along and Monday.
27.
ಏನ್ ನಿಮ್ದು ಇನ್ನೂ ಮುಗ್ದಿಲ್ವಾ? 138 proceeding ಅಲ್ಲಿ I heard you
Yes, my lords.
once, twice, thrice.
Thrice, my lords.
ಈಗ
on the
Apple representatives ಬಂದ್ರೆ ಏನ್ ತಪ್ಪು?
No, my lords, may make
Yes, sir.
this thing.
Why are you worried about them coming and
No,
deposing?
why am I worried about, my
Yes,
lords?
sir.
One is that they are expressly barred under the law to call anybody else.
Why?
My lords may look at, my lords may look
What
at order
anybody
11.
else?
No, my lords may look at order 11, rule 11. My lords, where it clearly says whatever documents, my lords, which they are seeking to ask for, they have to first lay out a pleading, my lords. My lords, the stage of the case is today is at the cross-examination stage. Now, my lords, what they do here is that, my lords, they file. Now, my lords, I'm on the other side. I am the plaintiff here. They file IA number 20, IA number 21, 22. They keep filing IAs after IA, my lords, only to, my lords, go for a fishing inquiry. In fact, my lords, my lord's judgment, which is at page number 186, my lords, we see same documents, which, my lords, they wanted to produce it at a particular court before the magistrate, has been turned down, my lords, by saying that, my lords, such fishing inquiry cannot be held. My lords, may look at that for a moment. One nimsha, because it has a direct impact. What they do.
Heard the learned counsel appearing for the petitioner. The learned counsel for the petitioner submits that the respondents have filed applications or after applications seeking the very same relief, one of which was considered by this court as well. The applications are filed at the fag end of the proceedings, and now the representatives of Apple are Apple company, Apple Inc. as have been summoned. The learned counsel submits that could not have been done at the fag end of the proceedings. In that light, further proceedings, in that light, the said order, permit, the impugned order shall remain stayed.
Let the stage go on.
That's, it is made clear that the proceedings are not stayed.
State minutes.
Yes, emergent notice to the respondents
Next.
returnable by the 1st of August.
Yes, it's.
So
Whereas
next-
in
next
so far
also
as the
same.
respondent, the contesting respondents are only 1 to 3. The remaining may be dispensed because they are, as I remember. I'm
Yes.
sorry. And next matter is connected. Idu agida anta, next aye hakondo, now they're going ahead with calling them directly.
Same order.
Same.
79,
The petitioner is before this court seeking the following prayer. The petitioner institutes P&SC 1 of 2023, which is said to be pending for the last 3 years.
Disposed of.
Huh?
Petition is disposed of. I filed
ಮತ್ತೆ ಏನ್
an
ಕೇಳ್ತಾ
IA
ಇದ್ದೀರಾ?
under 152 and 153. I
Oh,
filed
you
two
was
IAs.
what, the petitioner files 2 applications in P&SC 1 of 2023 after its disposal, seeking correction,
Correction.
seeking correction of the order and an application filed under section 152 and 153 of the CPC. The said application has not yet met its consideration. Therefore, despite lapse of 1 year, and therefore the petitioners are at the doors of this court. In the light of the application so filed for correction, the concerned court ought to have considered the same and passed necessary orders by now. In the light of the orders not being passed, I deem it appropriate to direct the concerned court to dispose the applications under 152 and 153 within 4 weeks from the date of receipt of the copy of this order, if not already disposed.
There's one mistake in the prayer, Mala, the name of
ಅದಕ್ಕೂ
the court.
correction ಬೇಕಾ?
No, the name of the court, I may be permitted to change.
Yes.
80,
Petitioners, my lord. R6 Rule 17 application is allowed. Simply, so suit for bare injunction was filed before the trial court. Now they want to convert it into declaration.
ಏನ್ ಮಾಡಬಾರ್ದು ಅಂತ ಹೇಳಿದೆ?
ಅಲ್ಲ, so in this matter, what has happened, my lord, a temporary injunction has been granted, that has been upheld by the appellate court, and the writ petition has been filed before.
That is
this-
only temporary injunction, sir.
No,
Suit is
so
not
far, so
decided.
far as that is, there is a direction of this honorable court, my lord. I produced that on or before 31st of July this month. They have to dispose of this matter.
Dispose of what?
Suit, my lord.
Suit itself.
Also,
Suit is of the year
2020.
23, my lord.
23.
Also.
Which is that? Where is that order?
This is,
Page?
In page number.
141, direction of this honorable court.
Nothing stops conversion, sir.
ಅಲ್ಲ,
Yes.
my humble submission, please lordship. It is a.
ನಿಮ್ ಪರವಾಗಿ ಆರ್ಡರ್ ಆಗಿರೋದು.
ಇಲ್ಲ, ನನ್ನ ಪರವಾಗಿ ಆಗಿದೆ. ನನಗೆ ಇಂಜಂಕ್ಷನ್ ಗ್ರಾಂಟ್ ಆಗಿತ್ತು. That MA was filed. The injunction was upheld. Before this honorable court, they have filed the writ petition. In that writ petition, the both the party has directed to maintain status quo. That order was modified. And that regard, the matter was direction was given. The matter was disposed with July.
ಎಲ್ಲ ಆಯ್ತು, ಈಗೇನ್ ಅಪ್ಲಿಕೇಶನ್
ಈಗ ನನ್ನ application, I filed the application. They have denied in filing a written statement, Your Honor. They have denied my title. On that basis, I have.
ಈಗ ಡಿಕ್ಲರೇಷನ್ ಕೇಳಿ.
ಅಷ್ಟೇ declaration. ನಾನು ಬೇರೆ ಏನಿಲ್ಲ. The same pleading. I am not changing any pleadings.
So far as declaration is concerned, my lord, the way very cause of action will differ. And here, my lord, the direction of this honorable court, this has to be disposed.
disposal, don't worry about that. Yes.
Both parties have to maintain status quo, and
that
the
will
very
continue.
court will lose its jurisdiction, my lord.
That will continue.
The jurisdiction of the court will lose, my lord. It
That
will go
will
to a
stay.
senior court.
List on 28th.
Tomorrow it is posted for orders on the application filed.
No
for-
problem, sir. Day after, list on 28th. Seek adjournment there. Next.
Grateful.
80? 39, 1 and 2.
Yes,
Are
my
they
lords.
represented?
Partition. My lords, they have not represented.
Partition suit.
Yes, my lord.
ಅದ್ರಲ್ಲಿ ಏನ್ ಬೇಕು injunction ನಿಮ್ಗೆ?
My lords, they have not represented, my lords.
When is the next date?
My lords, next date is 31/7, my lords.
31/7.
Yes.
Will direct the court to consider on the said date if they are represented.
My lords,
ಈಗೇನ್ injunction ಯಾಕೆ?
my lords, there is no, my lords, I'm just take out page number 103, my lords. 103.
Lords, as per this, defendant number one, that is my father, D.V. Krishnappa, has got the scheduled properties. Last ಅಲ್ಲಿ ಒಟ್ಟು ಕುಟುಂಬ ಇದ್ದುಕೊಂಡು ಸುಖವಾಗಿ ಅನುಭವಿಸಿದ ಬರುತ್ತೆ. This is admittedly ancestral and joint family property. And the present petitioners are daughters of D.V. Krishnappa, that is defendant number one. And defendant number two is the brother. My lords, on 21/6/2025, I have
To serve on the council who represents in Ilvala.
ಇಲ್ಲ ಇನ್ನು.
Petitioner to serve the respondents by way of hand summons and file an acknowledgement of such service. List the matter on 1st August. The defendant shall not alienate the property till the next date of hearing. Yes, next.
Grateful.
82,
The petitioner, the plaintiff, calls in question the order dated 36/2025 by which the applications in IA 20 and 21 in OS 335 of 2014 filed by the defendants to recall DW1 and DW2 comes to be allowed at the fag end of the proceedings. In that light, there shall be an interim order of stay of the orders of the order impugned dated 36/2025 till the next date of hearing. It is made clear trial before the concerned court is not.
Sorry.
Okay.
I have made application, my plaintiff, IA 2021.
DW and DW2, you are the plaintiff.
I sought for, my lord, the recalling.
DW and DW2.
I sought. My lord, what happened is, my lord, they are parties, my lord, they are brothers and sister, suit for partition.
Further proceedings shall remain stayed till the next date of hearing. Yes, next.
83,
Petition, my lord. In a suit for partition, impleading application was filed.
Who are you?
I'm for the plaintiff.
Ayyo, who are you, sir?
Plaintiff in the case, I'm the petitioner in this case.
Impleading applicants yaro?
Sub-registrar and revenue authority.
Why?
So during the pendency of the proceedings, interim order is operating. This was intimated to the judicial sub-registrar. In spite of that, he has helped the defendants, got registered the document.
Criminal case register ಮಾಡಿ.
That is why I have made an application for impleading that authorities, and also made an application for seeking leave of the court to made a leave of the court to implead them.
ಅದರಿಂದ ಏನಾಗಲ್ಲ. ಪಾರ್ಟಿಷನ್ ಸೂಟಾ?
ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಸ್ವಾಮಿ. ಇಲ್ದಿದ್ರೆ ಈ ಅವ್ರಿಗೆ ಆಪರೇಟಿಂಗ್ ಇದ್ದು ಕೂಡ ರಿಜಿಸ್ಟರ್ ನೋಟ್ ಮಾಡ್ಕೊಂಡು ಕೂಡ ಪ್ರಾಪರ್ಟಿ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ. ಎರಡು ವ್ಯಾಲ್ಯೂಬಲ್ ಪ್ರಾಪರ್ಟಿ ರೋಡ್ ಅಕ್ವಿಸಿಷನ್ ಆಗಿದೆ.
ಎಲ್ಲ ವ್ಯಾಲ್ಯೂಬಲ್, ಅದಕ್ಕೆ ಪ್ರಾಬ್ಲಮ್. Petitioner to serve on the counsel representing the defendants before the concerned court list on 28th.
Interim order.
28th hours ಕೊಡು.
Please.
ಸರ್ವ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವತ್ತು ಕೊಡಲ್ಲ. ಇವತ್ತು ಸರ್ವ್ ಮಾಡಿ.
I may be directed.
Next.
84,
The petitioner is before this court seeking the following prayer. The petitioner is the defendant. A suit is instituted by the respondent in OS 731 of 2025 seeking injunction.
Injunction, my lord.
Seeking injunction. A temporary injunction is granted. Ex parte order of temporary injunction order 39 rule 1 and 2 is granted. The petitioner files an application seeking vacation of the same by through an application order 39 rule 4. The said application has not met its consideration even as on today. It is therefore the petitioner is before this court. Seeking a direction.
Please, my lord.
Seeking a direction for expeditiously disposing the said
Also to
application.
quash ex parte temporary injunction, my lord. My lords, I'm in the possession of the property. My lords, I'm constructing, I'm putting up construction, my lords. Construction is stopped, my lord.
ಅಲ್ಲೇ ಕೇಳಿ. Therefore, the learned counsel for the petitioner submits that the petitioner is in possession and is undertaking construction, and despite in the light of the interim order subsisting, he is unable to proceed with the construction. In that light, I deem it appropriate to direct the concerned court to answer the application filed by the petitioner order 39 rule 4 within an outer limit of 4 weeks from today, if not earlier, after hearing the parties ordered accordingly. Yes, next. It is made clear this court has not considered the merit of the application so filed by the petitioner. Yes, next.
85,
Petitioners are the dependent people, the trial court. That your lordship may.
617 allow ಆಗಿದೆ LRs.
ಹೌದು,
Bringing the LR, so what?
at the stage of closure of his evidence ಮಾಡಿದೆ.
Partition suit.
ಇಲ್ಲ, suit for declaration.
Declaration.
They have file application for to modification of the scheduled property ಮಾಡಿದೆ.
The
Extent ಅನ್ನ ಜಾಸ್ತಿ.
Suit in OS 39 of 2017 is preferred seeking declaration and possession. In the said suit, at the stage after conclusion of the proceedings, trial and arguments, comes the impugned application under Order 6 Rule 17.
After the closure of plaintiff evidence ಮಾಡಿದೆ.
After the closure of the plaintiff evidence comes the application under 617. The application is preferred at the belated stage and the court has permitted amendment of the suit schedule property itself, which takes away the, which disturbs the nature of the suit so instituted. In that light, there shall be an interim order of stay of further proceedings.
Please,
Before the amendment stay marana. In that light, there shall be an interim order of stay of the impugned order. Yes, next.
Please.
Made clear that the proceedings are not stayed. Next.
86.
JDR petition, my lord.
The interest waive ಮಾಡಕ್ಕೆ ಯಾರು
ಅಲ್ಲ 77 years ನನಗೆ
ಏಜ್ ತಕ್ಕಂಗೆ ಇಂಟ್ರೆಸ್ಟ್ ವೈವ್ ಮಾಡ್ತಾ ಇರ್ಬೇಕಾ?
because my lord I have
How sympathy jurisdiction JDR petitioner to serve on the decree holder, first respondent and final acknowledgement to that effect. Yes.
till then.
Not till. Yes, next.
87.
My lord, appear for the petition.
Partition suit.
Partition suit. my lord.
Impleading.
But already
ಏನಾಗಿದೆ?
partition is done, my lord, now. And she has admitted in her evidence that what is goes to the developer will be developer's share, my lord. Unnecessarily, she has made us a party.
You are not a family member?
I'm a family member.
Then anything else?
So partition already over with her father, my lord. Now again, she's filed a suit only
No
against
problem.
her father.
No problem. Yes, nothing wrong.
Lordship may pass over.
Pass over.
I engaged the senior counsel, my lord.
List on 28th, passed over by a week. Next.
88.
Are they represented now? 39 1 and 2. ಇನ್ನು ಆಗಿಲ್ವಾ?
The possession is not given, my lord.
ಎಲ್ಲಿಂದ ಓಡ್ ಬಂದ್ರಿ?
Second court.
Yes.
Lord, under the agreement, page 80, Lord, the possession was never given to him. It was only an agreement to sell.
Suit for specific performance?
No, my lord, it's suit for injunction.
Injunction ಅಷ್ಟೇ.
Please, my lord. Now, the
Heard the
reason
learned
is,
counsel had Shanti Bhushan appearing for the petitioner. The learned counsel would take this court through the agreement upon which the suit for declaration is filed by the respondent. The, you are the defendant, Allah?
this suit filed by the plaintiff petitioner himself.
For what, sir?
Injunction, my lord. The reason is.
Suit for injunction. Counsel for the petitioner takes this court through the ಜಮೀನಿನ ಶುದ್ಧ ಕ್ರಯ ಪತ್ರ ಅಂತಿದೆ?
No, my lord. If your lordship may kindly see.
Annexure D, page 36.
That is ours, my lord.
Which is the defendant's?
Page, my lord, page 80 is the, I'm sorry, page 71. Annexure K, Mungada Kararu Patra. Page 71.
The learned counsel takes this court through the agreement of sale, on the strength of which the defendant is now causing disturbance with the possession of the petitioner, possession of the property with the petitioner. The learned counsel submits that no possession was handed over pursuant to the agreement of sale, and therefore the ಎಷ್ಟು ಡಿಸ್ಕೊಂಡ್ರೆ ವಾಪಸ್ ಕೊಡ್ಬೇಕಾಯ್ತು?
We've terminate. Notice is issued.
The petitioner, learned counsel for the petitioner submits that since no possession was delivered pursuant to the agreement of sale, the concerned court ought to have granted an injunction, a temporary injunction under ex parte temporary injunction and Order 39 Rule 1 and 2. In that light, there shall be, the respondents are injuncted from interfering in the possession of the property, possession of the plaintiffs till the next date of hearing. The petitioner shall serve the respondents by way of hand summons and file an acknowledgement list on 6th.
Great.
Yes, next.
89.
For the first respondent, my lord.
My lord, commissioner application has been allowed. This is a suit for bare injunction that has been filed. Otherly, the defendant has taken a contention that the plaintiff is encroached. In their written statement, they haven't filed a counterclaim or anything. Instead, they have filed a commissioner application and have sought appointment of the local talukdar as a commissioner. And it is a contention of the plaintiff that whatever it is, a commissioner cannot be appointed as a means of finding evidence or collating evidence on behalf of the court.
Violate that settled principle.
Yes,
One-
my lord.
One submission, my lord's preliminary submission. A friend of mine has filed wakalat for the first respondent today. There was a bereavement in his family, my lord, so therefore any date, even Wednesday would be
What's the
fine.
next day?
It's on the 28th, my lord, Monday.
Wednesday.
25th?
Please, my lords.
Learned counsel so and so submits that he has entered appearance for the respondent and there is a bereavement in the family today. In that light, list on 25th in plenary hearing.
Grateful, my lord.
Obliged, madam.
Yes, madam.
20.
Commercial court ಹೋಗ್ಬೇಕಾ?
Yes, sir.
ಯಾಕೆ?
The suit is for recovery of money, your lordship.
It is prior to the act itself. Suit is instituted in 2013.
Suit is instituted in 2013, your lordship.
All those
Now, by
ought
virtue
to have
of
been
this-
transferred. Yes.
Yes, sir.
Petitioner shall serve on the counsel who represents the respondent in the trial proceedings. List the matter on first. The contention of the petitioner is the suit ought to have been tried before a commercial court after the commencement of the act, after the act coming into force. In that light, further proceedings before the concerned court shall remain stayed till the next date, 1st August.
Grateful.
Next.
Sir, copy on the respondent. Respondent, like, copy, sir.
Madi.
Right.
91 for the petitioner.
The petitioner is before this court calling in question an order in IA so and so dated so and so, allowing an application under order 26 rule 10A, which at the fag end of the proceedings, in that light, there shall be an interim order of stay of further proceedings. Interim order of stay of the order impugned. It is made clear the trial is not stayed. Next.
Obliged. 92.
I appear for the petitioner.
39 1 and 2.
Please, my lord. My application came to be allowed before the trial court. Then, my lord, it came to be set aside by the first appellate court. Lord, there's no interim order, my lord, during the pendency of MA. My lord, I file an application, my lord, concerning survey number
21 MA.
Please, my lord, there was no interim order. So till 2025 June, my lord, I had an interim order of stay that has been set aside by the first appellate court.
The concerned court in OS 33 of 2021 filed by the petitioners for permanent injunction is application IA 31 rule, order 31 rule 1 and 2 of the CPC filed by the petitioners comes to be entertained by the first appellate court by granting temporary injunction on 15/1/2021. This is challenged before the first appellate court in MA 12 of 2021, which comes to be reversed after 4 years. There was, the learned counsel submits that there was no stay of the order throughout the proceedings before the first appellate court. In that light, there shall be an interim order of stay of the order of the first appellate court dated 19/6/2025 till the next date of hearing.
Lord, in fact, defendants had filed their application, my lord, seeking 39 1 and 2 with respect to their suit schedule property.
What happened to that?
That was dismissed. My application came to be allowed, against which a common appeal was preferred, my lord.
I will correct it.
Please.
Okay, yes,
Great.
next.
Great.
53.
Who are you?
My lord, I am the plaintiff.
Order 1 rule 10.
Order 1 rule 10.
Whom did you want to implead?
I wanted to implead the partnership firm of which defendant was a party. The defendant takes a defense in the written statement that the amount paid by me was taken to the firm of which he is a partner. I wanted to implead that partner. He admits in his written statement that the amount has been paid to the firm and not to him
Petitioner
personally.
to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement of such service. List the matter on 1st August. Further proceedings before the concerned court shall remain stayed. Next.
94.
Section
Which is
10,
the earlier application under section 10?
earlier application. My lord is.
That is page 105.
Oh, my lord, earlier application, my lord, is 52. that was allowed and suit was stayed. In the meantime, my lord, my suit for partition, they filed an application for rejection of plaint. Partition suit, my lord, plaint came to be rejected, I filed an appeal. So appeal was pending before this court, writ petition, my lord, challenging the stay of suit was also, my lord, pending before this court. My lord, the RFA got dismissed because I did not bring the legal heirs on record. When the RFA was dismissed, my lord, the writ petition was listed, they said now that there is no RFA, the section 10 application does not survive. My lord, RFA was restored, RFA was allowed, and now the plaint for partition is restored. So therefore, question of res judicata will not arise because earlier, my lord, there was no adjudication.
The petitioner is before this court seeking, calling in question an order dated 3663/2025 rejects the application filed under section 10 seeking arrest of a suit in OS 43, which is the one you want to be stayed?
4316 of 2000.
Arrest of a suit in OS 4316 of 2015. The counsel for the petitioner takes this court through the documents appended to the petition to demonstrate that the reason so rendered by the concerned court, i.e. res judicata, is contrary to the records. The submission is vindicated on a perusal of the documents appended to the petition. In that light, suit in so and so shall remain stayed till the next date of hearing. Yes, next.
95.
Amendment application not allowed belatedly.
ಈಗ 2013 suit ಅಲ್ಲಿ
2015 suit.
You are the defendant.
I am the defendant.
Petitioner shall heard the land counsel Sunil Rao appearing for the petitioner. A suit partition suit alla. Yen amendment kelid.
Now they wanted to include certain other properties after the completion of the plaintiff's evidence.
ಎಲ್ಲ ಪ್ರಾಪರ್ಟಿ ಇದ್ರೆ ಒಳ್ಳೇದಲ್ವಾ?
They wanted to seek setting aside of a will, my lords, which we have narrated on 17/8/2015.
That amendment will stay. But
and they wanted to seek setting aside of a sale deed, which we have narrated in the written statement on 2015. So they clubbed all these things together and brought it in a common amendment application. That was the.
That will see. Petitioner to serve on the counsel represents the plaintiff, first respondent before the concerned court. The petitioner is before this court seeking, calling in question an order dated 2/7/2025 by which the concerned court allows 3 applications.
Single amendment application.
allows an application which seeks 3 amendments. One, to challenge the will.
Yes.
And the other to challenge the sale deed. And the third to include certain properties. This order on the face of it is erroneous. Therefore, there shall be an interim order of stay of the orders impugned till the next date of hearing. Yes, next.
96.
39 1 and 2.
39 1 and 2. My wife was the owner of the property. Wife dies. The plaintiffs are husband and daughter.
The petitioner to serve on the respondent by way of hand summons and file an acknowledgement of such service. Status quo where the property be maintained till the next date of hearing.
Not to alienate.
I'll status quo then. Yes, next.
I have 2 reliefs I have sought. One for interference, not to interfere with my possession. And number 2, not to.
Cover the status quo. Yes, next.
97.
Why commercial OS ಹೋಗ್ಬೇಕು?
No jurisdiction because it is a residential project. Sale deed is executed in relation to a residential villa. Commercial court gets no jurisdiction in view of, my lord,
the dispute is not between them and us. The dispute is between the landowner and the builder, and it falls under 21C6, which talks about construction contracts.
Residential apartments?
Yes, residential villa.
Villa with a buyback option?
There's no buyback option.
No chance it is a commercial dispute.
One submission, three judgments of the Karnataka High Court, which is no longer res integra. Karnataka High Court itself has gone into this judgment.
Yes, sir.
Karnataka High Court, Bombay High Court, and Delhi High Court.
In fact, my lords have held that it is not.
I have last week held it, sir. I can't go against that. You have to challenge that.
By following Ambalal.
Yes.
May I just?
Residential apartments.
See the judgment in.
Please.
Because if we take up tomorrow, I'll just examine the judgment.
Friday.
Right.
Just on Friday.
Till then, my lord, they are marking documents there on a day-to-day basis.
Next day, next day. Then don't precipitate till then. Counsel for the respondents undertake not to precipitate the matter till the next date of hearing. Look into the judgment.
Please.
98.
This
617.
ಹೌದು.
ಏನು?
My lord, the suit for injunction, where the restraint is in relation to access to my road by using a government land. That government land, my lord, is sought to be included as a separate schedule, and an injunction is sought to be, my lord, sought in relation to that for clarity purposes. I'm not making any new claim, but only, my lord, describing the government land through which, my lord, I'm gaining access. And that government land should not
What's
be.
the next date?
State would, you just check up.
Serve ಮಾಡಿ Monday ತಗೊಂಡು.
Very.
Petitioner to serve on the counsel
Same, my lord.
representing the defendant list on 28th.
Right.
28th in preliminary hearing. Yes, next.
99.
Lords, in this case, I may be permitted to file an impleading
When did you-
application, my lords.
Impleadment application.
Correct. Purchaser ಯಾವಾಗ?
Purchase 2023.
Suit ಆದ್ಮೇಲ, suit ಮುಂಚೆನಾ?
Suit ಇರುವಲ್ಲಿ. when it
Suit
was
ಇರುವಲ್ಲೇ?
pending.
Suit for what?
Suit for partition and declaration in respect of a sale deed which has been perpetrated by fraud.
No problem.
This is of the year 2005.
ಅಲ್ಲಿ ಆಮೇಲೆ?
When the matter was pending.
FDP.
My lord, when the matter was pending
My lord, sir,
before
No problem, sir.
my lord,
Come in FDP.
my lord, may I make a
Preliminary decree, we will not
No, it's not a
include a
preliminary decree.
subsequent purchaser to the subsequent to the institution of
My
the
lord,
suit.
a suit is now, as it is now issue, the stage is for framing of issues. Now it has got a little background also.
You Western background early, sir.
No,
We
my lord,
will not permit it.
these lands are notified for acquisition by KHB in the year 1989. Then
ಆಮೇಲೆ preliminary decree, no stranger.
now as it is, may I kindly for a minute, I will take the sale deed which he has executed, the way in which
File a separate suit.
annexure, my lord,
File a separate suit.
no,
sir.
annexure K, may I kindly take?
File a separate suit if you want.
Sir, I can
In a
understand.
partition suit, I will not permit you to come in now.
No, I filed the, I am the plaintiff. I made an application to implead the person who has now.
ಅದೇ ಅದಾಗಲ್ಲ ಈಗ ಅಂತ.
ಅಲ್ಲ, it leads to again multiplicity application.
ಏನ್ ಹಂಗಂತ preliminary decree ಬಿಟ್ಬಿಟ್ರೆ ಎಲ್ಲಾರ್ನು ಮುಗಿತಾವ.
ಅಲ್ಲ, for a minute, my lord, now the understanding of the application and also the understanding by the learned trial judge is wrong. May I kindly take one paragraph, one paragraph.
Understanding may be wrong. Order is correct.
No, my lord, the only one paragraph, para 11 of
Oh,
the.
sir.
No, para 11 of
Yes,
the.
Prakash, sir.
My lord, kindly, my lord, there is an error which now, as it is the land sharing.
Anyway, take chance next week. List the matter on 30th. Change ಆಗಿದ್ರೆ ಅಕಸ್ಮಾತ್.
ಇಲ್ಲ, ತಮ್ಮ ಮುಂದೆನೆ ಮಾಡ್ಬೇಕು.
Oh, yes.
100.
39, 1 and 2.
And to my lords, say holding that agrarian land, agricultural land only without notice anta.
The
Honorable court has held that.
petitioner shall serve on the serve the respondents by way of hand summons and file an acknowledgement of such service. List the matter on first till such time the temporary injunction as sought for shall be granted.
Grateful.
Yes.
List number 2.
We'll continue at 2:30.
My lord, 2:30.
A week accommodation, my lord.
95?
List two.
Ah,
I'm praying for 1 week time, my lord.
I think grant, don't. We'll grant it.
If you like.
My lord, item 92 of list one, my lord. My lords were pleased to stay the
List one na?
list one.
Ah,
Lord, aದಲ್ಲಿ interim injunction was granted in my favor, which was set aside with the first appellate court. Lords were pleased to stay the first appellate court judgment, my lord. OS ಅಲ್ಲಿ ಇರೋ injunction it may be reinstated, my lord.
that is effect ಅದೇನೆ ಮತ್ತೆ ಇನ್ನೇನು?
Maybe stated.
Restoration ಆಯ್ತು.
Please, great.
ಇನ್ನೂ ಸೈನ್ ಮಾಡಿಲ್ಲ, don't worry.
Please.
Serial number 88 leads to, I'm filing memo for withdrawal.
Serial number?
88, list number
List
2.
to 88. The counsel for the petitioner files a memo seeking to withdraw the petition. Petition disposed as withdrawn in terms of the memo. Great. Announcement. Madam Nandra.
Petitioner.
List ಇದೆಯಾ madam? हाँ, करो ना.
Petitioner.
The criminal petition insofar as petitioners 2 to 4 are concerned is allowed. The special CC 1493 of 2024 registered against 2 to 4 stands quashed. Criminal petition qua the first petitioner husband stands dismissed.
Serial number 2.
Serial number? Ah. Dismissed.
3.
Dismissed.
4.
Okay, I appear for the petitioner on this matter.
Petition is allowed, application so and so is rejected.
May I also make a request for expedited dismissal?
Madam, impleading application reject ಆದ್ಮೇಲೆ expedite ಎಲ್ಲಿಂದ ಆಗುತ್ತೆ?
Well, defendant is also on, is also
Correct.
before your lordships. It's a 2006.
I already said 6 months.
Very well, very well.
I know first defendant is also there.
Very well, I'm repeating.
5. For the petitioner, my lord.
5. Spurti. ನನ್ನ ಹತ್ರ sorry, sir.
Yes, one more gold medal in the.
One more gold medal. ಈಗ ಮಾಡ್ಲೇಬೇಕು. The petitioner, a disabled person, having driven to this court to bear the brunt of litigation, litigation on account of the officers of the state must be mulcted with payment of exemplary costs. The costs are to be imposed as a caution or to serve as a reminder to the officers of the state that justice delayed, especially to those who overcome the gravest of odds like the petitioner is, not only justice denied but dignity diminished. The writ petition is allowed with costs of rupees 2 lakhs payable towards litigation expenses to the petitioner. The respondent state is directed to release the payment of 1,26,000 to the petitioner within 2 weeks from the date of receipt of the copy of the order. In the event the amount 1,26,000 is not paid to the petitioner within 2 weeks as directed, the petitioner would become entitled to costs of rupees 1,000 for every day's delay after the said 2 weeks, day on day, till the amount reaches the doors of the petitioner. The cost of rupees 2 lakhs shall be borne personally by the officials of the Department of Youth Empowerment and Sports responsible for denying the petitioner his due. This said sum shall not be drawn from the public exchequer. The directions in clause 2 and 4 supra shall be complied with within 4 weeks from the date of receipt of the copy of the order. 1,000 ಜಾಸ್ತಿ ಪರಲ್ಲ. ಕಾಸ್ಟ್ ಬೇಕಾದ್ರೆ 1 ಲಕ್ಷ ಜಾಸ್ತಿ ಮಾಡಿ. ಮಾಡಿ. ಎಸ್. 1 lakh. ಇದೆಲ್ಲ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದಕ್ಕೆ ಕಾಸ್ಟ್. ಎಸ್, ನೆಕ್ಸ್ಟ್. Oh, sorry. Dismissed.
May I request for a time-bound disposal because 2 IAs were PNSC for 2 years it's pending there. The petitioners are more than 70 years old. That's the only reason, my lord.
All right.
Time-bound.
Yes, madam. 6 months add madla.
Request
in fact, the person who's leading evidence is not 70 years old. She's like 45 years old.
I'm saying the person who's supposed to be appointed
ಯಾರೋ
as
ಒಬ್ಬರನ್ನ 70 ಅಂತ ಇರುತ್ತದೆ.
no, my lords may check the cause title. The administrator is more than 70 years old. The proposed administrator.
ಅದರಲ್ಲಿ ಒಂದು ಬರ್ಕೊಳ್ಳಿ. Both the learned counsel appearing for the petitioner and the respondent would submit that since it is
may not be recorded
in the light of the proceedings being summary in nature, I deem it appropriate to infuse finality in the peculiar facts and circumstances of the case. The concerned court shall dispose the proceedings with an outer limit of
6 months.
6 months, if not earlier.
8 months. May I request 8 months, my lord? There are 3 witnesses.
ಏನದು ಬೇಕಾಗದೇ ಇಲ್ಲ. P&SC 6 months ಗಿಂತ ಏನ್ ಬೇಕು?
Most great.
Yes. ಮೇಡಮ್ ಒಂದು ಹಾಕ್ಬಿಡಿ ಅದಕ್ಕೆ.
7.
Petitioner, please.
Bharat Kumar. Yes. Writ petition is dismissed with exemplary cost of rupees 10 lakhs to be paid by the petitioners to the Karnataka State Legal Service Authority within a period of 4 weeks from the date of receipt of the copy of the order. All petitions dismissed. No choice. Yes. Earlier order. Why is Raul waiting?
List 2, your lordship.
Ah.
Till number 19. This report regarding the special investigation team formulate.
It's listed, is it?
It's listed, your lordship. List 2, your lordship.
One moment. Admission. List 2.
List 2.
Till number?
Serial number 19.
19.
The SIT matter is listed today along with the 482 which is listed before the coordinate bench.
Oh, it's listed
Now, on
here, is
account
it?
of special
It's
orders,
listed.
now it's come before this court.
Which serial number?
19.
19.
90.
19.
19.
Ade.
Then wait. A court ಹೋಗ್ಬೇಕಾ?
Illa, I'll wait.
Wait. Yes.
This number 2.
Password. Devaya, password.
Order seal number 2.
Last ತಗೊಂತೀನಿ ಇವತ್ತು. You finish all your work and come by 5 o'clock. Yes.
Petitioner matters.
Seal number 2.
Interim to the extended matters.
ಅದು ಬರೀ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಹಂಗಾಗಲ್ಲ. ಕೇಸ್ ಏನು?
Statement of objection filed by the R.
ಒಂದೇ ನಿಮಿಷ.
3 matters.
Excuse me. Excuse me, ma'am. Case number 2.
Yes.
Appearing for the respondent.
Yes, ಏನ್ matter?
ಅದರಲ್ಲಿ R3 ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್
ಹಾಕಿಲ್ವಾ ಇನ್ನು?
ಹಾಕಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಾಪಿ ಆತರ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ಮಲರ್ಸ್.
Comply ಮಾಡ್ತೀರಿ my lords. There was a counter case regarding the same. Ali respond to
What's the matter?
It was the assault my lord, that dog case. Counter case ಅಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ಸ್ಟೇ ಆಗಿದೆ.
List the matter on 25th.
Sure my lord, ಅದು ಟ್ಯಾಗ್ ಮಾಡಬೇಕಿತ್ತು.
Tag the petition along with so and so. List the matter on 25th.
Much obliged.
Entry mod to the extent of
Interim order subsisting will continue till the next date of hearing. Next.
3.
My lords, I appear for the petitioner. My lord, we have been served with a copy of.
Respondent.
Please, my lords, we have been served with a copy on 18/7/25. My lord, we'll take necessary steps, my lord.
List the matter after 2 weeks. The necessary steps be taken by the petitioner in terms of the memo. Next.
Please, my lord.
4.
I am for the
Non-compliance of office objections. Virupaksha.
ಪ್ಲೀಸ್ ಮೇಡಮ್, ಇದರಲ್ಲಿ
ಇದು ನಿಮ್ದೇನಾ?
ಹೌದು ಮಲರ್ಸ್.
ಏನು?
ಇದರಲ್ಲಿ ಲೇಂಟ್ ಸೂಟ್ ಟು ಎಜುಕೇಶನ್ ಆರ್ಡರ್
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನು?
ಇದರಲ್ಲಿ ಸೇಲ್ಡ್
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನು?
ಇದರಲ್ಲಿ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ not produced.
A week's time is granted to comply with the office objections.
Date may be fixed.
In the event the office objections would start complied, list next Thursday. Next Thursday.
Please, madam.
What date? 31st. Yes, 31st of July.
Time.
Petitioner, my lord. Lord, I'm for condonation of delay.
What is office objection?
IA1 is filed for condonation of delay. It's not required, my lord. I may be permitted to not press that IA.
The learned counsel for the petitioner submits that the only office objections is qua an application seeking condonation delay. He would submit that his
Copy also not served, my lord.
ಅದು office objection ಅಲ್ಲ ಅದು.
Copy.
ನೀವು ಕೇಳಿಟ್ರಾ?
Yes, my lord.
One ನಿಮಿಷ. He would submit that he is not he does not wish to pursue the said application. This application is disposed as not pressed. The learned counsel for the respondent submits copy of the petition is also not served.
No, my lord.
What is that?
My lord, this is affidavit, my lord. My lord, in
What
this-
affidavit?
My lord, I filed for eviction suit, my lord. So order
Correct,
ಆದ್ಮೇಲೆ-
affidavit ಏನು?
Yes, my lord. Execution.
What is that affidavit?
For delivery warrant, my lord. I'm in the possession of the property. The bailiff, along with the police protection, I have given me the.
Anyway,
possession
list
of
the matter
property.
on 25th. Yes. Next.
6.
ಇದು ಇವತ್ತು ಟೈಮ್ ಇಲ್ಲ.
A date.
We'll take it on Thursday na?
Thursday is fine for us, my lords.
Advocate general ಇದ್ದಾರಾ? Yes sir. ನಾಡಿದ್ದು ತಗೊಳ್ಳ? ಇವತ್ತು ತುಂಬಾ ಇದೆ, ಆಗಲ್ಲ. We'll take it day after tomorrow.
Day after tomorrow.
Heard so and so, learned advocate general ಅಂತ ಹಾಕಿ madam. List on Wednesday.
Wednesday.
Great.
7.
Paid cost of rupees 1 lakh.
This case
ಯಾರು
second-
impose ಮಾಡಿದ್ದು? Oh, that wheelchair.
Correct.
My lord, last time I.
ಒಂದ್ ನಿಮಿಷ,
filed-
ಒಂದ್ ನಿಮಿಷ.
Please, ma'am.
I was,
My lord, in that match.
ಒಂದ್ ನಿಮಿಷ, application ಹಾಕಿದ್ದೀರಾ?
Yes, sir, please, next day.
Application ಎಲ್ಲಿ?
Tomorrow, my lord.
I will issue warrant now.
Please, my lord. Because of the.
ವೀಲ್ ಚೇರ್ ಮೇಲೆ ಬಂದಿರೋದು 1 ಲಕ್ಷ ಕೊಡಕ್ ಆಗಲ್ಲ ಅಂತ ನಾನು ಹೇಳಿದ್ರೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಅಂತ 4 ಸರಿ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಆಗಿದೆ.
Yes, sir. Tomorrow I can call up.
I will direct warrant to be issued against the petitioner
Tomorrow,
now.
my lord, please.
ನಿಮ್ಮಿಂದ that poor lady of 87 years
My
old
lord,
is suffering.
Call up that signature in the.
What signature?
Please, tomorrow, my lord, please.
List tomorrow. If no application is filed, I'll issue warrant.
Tomorrow I can file that.
4 ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಬೇಕಾ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಕ್ಕೆ?
Tomorrow I can file that.
ಕಾಸ್ಟ್ ವೇವ್ ಮಾಡ್ತೀನಿ, ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಅಂದ್ರೂ ಹಾಕಲ್ಲ. Yes.
8.
R3 and R4, my lord.
Who's R1, 2, 5 and 5 to 10?
Notice may be dispensed to.
Memo.
Yes, I will.
File a memo.
Yes, I will. Memo.
ಇದು madam, in case memo is filed, only then you type it saying, in terms of the memo, the learned counsel for the petitioner files a memo seeking dispensation of issuance of notice to R1 and 2, 5 to 14, dispensed with at the risk of the petitioner. Only after receipt of the memo, you type this.
My lord, I have submission.
ಏನ್ submission ಇಲ್ಲ, yes.
The interim order which was granted because of communication gap, my lord.
The gap between whom, sir?
Between me and the parties.
Me and the parties. So?
The amount was not deposited as ordered by this court.
What amount, sir?
1 lakh. My
Which
lord,
matter are you arguing?
before that date only, my lord, 5 lakhs rupees was paid to the.
Don't tell me all that. Where is the order? Madam, file code your name.
Dated 13/7/2022.
Yes, your
my
lordship
lord.
kindly
13/7?
2022. It was a conditional order provided.
Yes.
One
Deposit
ನಿಮಿಷ. ಕೊಡಿ
1
ಕೊಡಿ
lakh.
ಫೈಲ್ ಕೊಡಿ.
13/7/2022, my lord.
1 minute, sir. 1 minute. ಇಲ್ಲೇ ಇರ್ಬೇಕು ಮೇಡಮ್, ಇಲ್ಲೇ ಇದೆ. ನಮ್ಗೆ ಕೈಯ. Thirteen 7/2022, na?
Yes, my lord.
Please, my lord.
Within a period of 4 weeks from the
Yes,
executing
a
court.
detailed order was passed
Yes, sir.
on 13/7/22, my
I will
lord.
also pass a detailed order now. Anything else, sir?
No, no, I am only submission.
This
my lord.
court on 13/7/2022 had passed the following order. The coordinate bench stayed further proceedings before the executing court in execution petition 25023 of 2013, subject to the petitioners depositing 1 lakh within a period of 4 weeks before the executing court. Not 4 weeks, 14 weeks.
No,
More
before-
than 28 months have passed by. The learned counsel for the respondent submits not a rupee has been deposited.
No, 5
This
lakhs.
court on 21/3/2025 had extended the interim order only on the condition that the petitioners would comply with the order. Even today, there is no compliance. Therefore, there is no warrant to continue the interim order, which was made a condition precedent for deposit of a sum of rupees 1 lakh within 4 weeks, 3 years ago. Therefore, the interim order subsisting shall stand vacated.
Your lordship,
My lord.
may
Next.
only one submission. my lord.
Next, yes.
5 lakh rupees was paid to them,
Next,
my lord.
sir.
There is a receipt for that.
You may have paid 100 lakhs before the order. After the order, how much have you deposited?
We are not.
Yes, fine. Next.
9.
LR application has been filed, by some defective for office has
Trial court,
raised
my
a
lords.
rectification. I will make it.
That's the
Then
order.
another one is a respondent number 23.
One
Counts-
Order of my lord says that only pronouncement is to be deferred. The trial court is adjourning the matter as saying await orders. That's the difficulty. Means therefore I
Pronouncement
filed-
is deferred ಅಂದ್ರೆ ಅದೇ ಆರ್ಡರ್
That's the-
ಇನ್ನೇನು ಬಿಟ್ ಇದ್ರೆ ಪ್ರೊನೌನ್ಸ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ
ಅಲ್ಲ ಎವಿಡೆನ್ಸ್ ಯಾವ್ದು ಮಾಡ್ತಾ ಇಲ್ಲ.
ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ಗೂ ಅದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ?
That's what my lords, the await orders ಅಂತ ಹೇಳಿ adjourn ಆಗ್ತಾ ಇದೆ. Proceedings are not taking place.
This court on 27/6/2025, ಅಲ್ಲ one ನಿಮಿಷ, which is that order? Not my order, sir.
9/12/2022.
This court on 9/12/2022 had, the coordinate bench of this court on 9/12/2022 had passed an order directing deferment of pronouncement of the judgment in OS 3 of 2007. The learned counsel for the respondent submits that on the score of pendency of the interim order, further proceedings are not conducted before the concerned court. The coordinate bench was clear that it is only deferment of pronouncement of the judgment, not stay of the proceedings before the concerned court. Therefore, the concerned court shall continue the proceedings except pronouncement of its judgment. The interim order stands extended subject to the aforesaid clarification.
Please,
Needful be done in the next 2 weeks.
please.
Next.
10.
On 17/7, I filed an application to bring the LRs of respond number 14.
I have filed application for vacating interim order, my lordship.
ಎಲ್ಲಾರ್ಸ್ ಏನ್ ಹೇಳಿ ಸರ್ ಆಮೇಲೆ
My lords, respond number 14's LRs have to be brought on record. The notice has to be issued on my IA, my lord.
Memo.
What's the matter about?
My lords, this is a matter where I've challenged my dismissal of my amendment application, my lords. Under
617.
6 rule 17.
ಯಾವಾಗ
Please.
ಹಾಕಿದ್ರಿ?
First appeal.
My lords, this is in the first appellate.
Suit
Suit is declared.
before the first appellate court, ah?
Before the
Yes, sir.
first appellate court, it is in the year 2020, my lords. What has happened is, my lords, along with me, there were 3 other
And
appellates.
ಇದು 2 ವರ್ಷದಿಂದ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ? Yes,
Please.
sir.
There are 3 other appellants.
Come on Wednesday, list on Wednesday in preliminary hearing.
Because may I kindly request.
Petition entertain madbekare, I will have to
Yes,
issue
my lord.
notice. If I have to dismiss it, no notice.
Yes, my lords.
Come on Wednesday.
My only
Next.
request is, may I kindly request for next week, my lords.
No, sir. Yes.
My lordships, in this case, my lordships, they have developing certain properties and alienating the properties. We have filed application.
ಈಗ ರಾತ್ರಿ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ತಾರಾ? ಇಲ್ಲ ತಾನೆ? Wednesday ಹಾಕಿದ್ದೀನಿ. ಇಲ್ಲ ಅಂದ್ರೆ at the request of the council appearing for the petitioner list after 2 weeks.
Wednesday, there is
ಸುಮ್ಮನೆ ಇರ್ಬೇಕು. ಅದ್ರಲ್ಲಿ ಏನು?
I'm sorry, my lords, there's some difficulty.
No,
on my
sir. ನಾ ಸುಮ್ಮನೆ ಅವರಿಗೆ ಎದುರಿಸಿದ್ದೆ ಅಷ್ಟೇ. You don't take cue from.
No, my lords.
Yes, next.
I kindly request next week, my lords.
No,
Any day.
sir. Next.
My lords, interim order.
Interim order subsisting will continue till the next date of hearing.
Appearing for the petitioner, my lords. My lords, senior is unavailable.
11 is wrongly listed saying process fee. There is no order issuing notice.
ಹೌದಾ? ಕೊಡಿ ಮೇಡಮ್, ಯಾವ್ದು 11?
ಅದು ಅವತ್ತು ಬಂದಾಗನು ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದಕ್ಕೆ ಟೈಮ್ ತಗೊಂಡಿದ್ರು.
Pendency of this will not come in the way ಅಂತ ಬರ್ದಿದ್ದೀನಲ್ಲ already.
ಅದಕ್ಕೆ
ಇದರಲ್ಲಿ ನೋಟಿಸ್ ಏನಾಗಿದೆ? The indication of non-furnishing of PF be deleted from the cause list next week.
ಅದು ಇಂಜಂಕ್ಷನ್ ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ 3 ಸಲ 3 ಸೂಟ್ ನಲ್ಲಿ ರಿಜೆಕ್ಟ್ ಆಗಿ 4ನೇ ಸಲ ಮತ್ತೆ ಕೇಳ್ತಾರೆ.
ಇಲ್ಲೇನು ಕೊಟ್ಟಿಲ್ಲಲ್ಲ ನಾನು.
ಇಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ, ಬಟ್
and I have in turn directed that the court should proceed. Yes, heard so and so on that. Next. 12.
My lords, I appear for petitioner in this matter. By order I appear for petitioner in this case, please. Lords, by order dated 27/6/2025, your lordship were pleased to dispense with production of my lords entire copy of Annexure E and my lord certified copy of Annexure H. That has been reiterated once again in the list, my lords, please.
This court on 27/6/2025 had passed the following order. Despite this, the office indicates IA pending, IA 1 of 2024 pending. The IA has already answered the office to verify. Interim order subsisting will continue to the next date of hearing. Next.
If your lordship may kindly fix the date, my lords, I'll be grateful, my lords, please. Because of this, my lords.
Next.
My lords, by name. Please.
Can I seek indulgence of 1 more week's time for complaints, my lord?
Petitioner, come this side.
Can I seek indulgence of this court for 1 more week's time?
Learned counsel for the petitioner seeks 1 more week's time to do the needful. List after week. Yes.
14.
Early hearing.
Respondent, my lords. My lords, this is
Application seeking early hearing of the matter stands rejected. List the matter on 1st August and preliminary hearing.
My lords, we have filed the early hearing, my lords.
They reject ಮಾಡಿದ್ದೀನಿ.
14.
We are
14.
Happy for the petition.
May I make a we are requesting for the disposal of matter, my lords. We have filed the IF for
Before the court. Which disposal?
My lords, this writ
This
petition.
disposal, 1st August. Yes. Preliminary hearing. Next.
My lords, I sent the copy through registered post to DHR and JDR.
DHR and JDR.
Both
Their
the-
initials adu.
Manas?
Judgment debtor and decree holder. Yes.
Both the copies were sent to both the parties.
Counsel
One
for the
is
petitioner
towards the
submits
advocate.
needful has been done office to verify. Next.
And kindly have it on day after tomorrow,
No,
Manas,
sir.
because
Next.
urgency is there. It is
Friday.
Going to be action.
25th. ಯಾವತ್ತು auction ಇರೋದು?
ಈ week ಇದೆ Manas.
ಈ week ಅಂದ್ರೆ ಯಾವ್ದು?
I
Monday
could
to
not-
Saturday.
I will get the date.
Get the date and move them. Yes. Next.
Sorry, Manas.
16.
With the R1 and R2.
Memo for dispensation. R1 and R2.
R1 and R2 may be dispensed.
The counsel for the petitioners filed a memo seeking dispensation of issuance of notice to R1 and R2. Memo is accepted, dispensed at the risk of the petitioner. List post the matter of preliminary hearing on Friday. ನೀವು ಯಾರು? ನೀವು ಕೇಳ್ತಾ ಇದ್ದೀರಾ? ಸರಿ.
20.
Service matter.
Please, man. Please.
Sir, you have come.
Yes. Come with special order.
Yes, sir.
Since.
Should we fix a date for hearing?
Yes. that will be
ಇವತ್ತು ಮುಗಿಲಿ, ತುಂಬಾ ಇದೆ.
ಹೌದು. If it is not inconvenient, can I request your lordship to have it on the 25th Friday?
Not inconvenient at all, no problem.
ಅಲ್ಲ ಹಾಗಲ್ಲ, ನಿಮ್ ಪ್ರೆಷರ್ ಆಫ್ ವರ್ಕ್ ನಾವು ನೋಡ್ತೀವಲ್ಲ.
ಅಲ್ಲ ಅದಿರ್ಲಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. Now it will become pleasure of work.
ನಿಮ್ಮ ಲಿಸ್ಟ್ ಅಲ್ಲಿ 100 ಅಲ್ಲ 200 ಇದ್ರು ಮುಗಿಸಿ ಹೋಗ್ತೀವಿ. ಅಲ್ಲ, on our part, both, that is why I'm
That
saying.
is exactly why I said. Now pressure ಇಲ್ಲ.
Using a plural. On our part, both of us are ready, but I know the pressure.
Shall I take it on Friday?
This Friday, I don't know, because that
ನಿಮ್ಗೆ
is
ಯಾವತ್ತು
going to
ಬೇಕು
the
ಹೇಳಿ?
last Friday existing benches. ಅದೇನೋ change.
ನಿಮ್ಗೆ ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ?
Next week, any day.
But last time I've indicated.
ನನಗೆ 30th I have
No
got
right
29th
to
ಆಗೋದು.
leave maintainability or otherwise. No
Yes.
right has flown to you at all.
I'm ready today, but if he has got any inconvenience, mother, kindly have it on 29th or.
29th is.
All fine. 29th.
29th.
Heard the learned senior counsel. Subramanian Joyce appearing for the petitioner and learned senior counsel.
Request is not
Yes, Rajagopal.
considered unreasonable. Can it be had at 2:30 sharp?
All right, no problem. 2:30.
ಎಲ್ಲ ರೀಚ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ಯಾವ ಟೈಮು ಡೋಂಟ್ ವರಿ ಅಬೌಟ್.
Yes. List the matter on 29th at 2:30 PM.
Great, great.
18. For the petitioner, Your Lordship.
Lordship, just seeking indulgence of this honorable court for delinking of this.
Delinking what, sir? KLR matter. ಅದೇ ಲಿಂಕ್ ಆಗಿದೆ.
ಕನೆಕ್ಟ್ ಮಾಡಿದಾರೆ ಅವರು.
ಯಾರು ಮಾಡಿದ್ರು? Previous bench ನಾನಾ?
Previous bench.
ಹಂಗಾದ್ರೆ
ಸರ್ ಸೇಮ್ ಪ್ರಾಪರ್ಟಿ ಸರ್ವೆ ನಂಬರ್ ಸೇರ್ ಮಾಡಿದ್ದಾರೆ.
ಏನ್ ಡೀಲಿಂಗ್ ಪರವಾಗಿಲ್ಲ ಹೇಳಿ.
And as far as this second matter is concerned, Your Lordship, on Thursday I submitted that.
No, don't worry about it.
17.
No, I'll just make a subject matter is entirely different except for the survey.
ಈಗ there is already a special order by the Honorable Chief Justice. I will not say delink. It's by special order that has come. So leave it. Tell me.
As far as the first matter, Your Lordship, I've just filed the wakalat on Saturday. So just I seek for 1 week's time to just.
I'll take it on.
Any day.
List on next week.
Good.
List on next Friday, Hakim Madam.
Please.
Interim order.
Interim order, yeah?
Status
Interim order will
order.
continue to the next date of hearing.
The connected matter also same.
Yes, sir?
Also same.
Huh?
Connected matter.
Connected matter interim.
ಎಲ್ಲಿದೆ? ಎರಡರಲ್ಲಿ ಇದ್ರೆ ಅದು ಕಂಟಿನ್ಯೂ. Yes, next.
ಇಲ್ಲ, that is ಬಂದು 2017 showcase notice they challenge now after 8 years.
ಆಯ್ತು, ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಯಾಕೆ? ಅವತ್ತು ನೋಡೋಣ. Yes.
19,
yes.
That 19 I'm to the petition.
Which is the connected matter?
19.1 is the connected matter. I have to just tell your lordship.
Your lordship, I'll place the
But
status
after your
report.
lordship passed that order directing for both the 482 and the WP to be placed before the chief justice for order, there was a sudden attempt, Lord, before the 482 court to move it out of turn and seek for withdrawal of that 482 petition, which in the last 3 weeks before that withdrawal memo was filed, they were prosecuting their interim relief with so much urgency. They suddenly moved the 482 court when the matter was listed on 22nd, out of turn seek to withdraw the matter before
Let's
that
see if
court.
they're so interested in withdrawal, let them do it here.
I don't know. Filed an application.
For withdrawal.
Then, Lord, that was already filed there also. No, but that was filed subsequent to your lordship's order, Lord, for the matters.
You want to withdraw the petition?
Already filed.
No problem. Learned counsel appearing for the petitioner seeks leave of this court to withdraw the petition. The
19.1.
On the 19.1, withdraw the petition. The petition is disposed as withdrawn.
Yes, and so far as 19 is concerned, Lord.
Lordship, the status report, your lordship, as on today, what?
The learned.
The 19 is for withdrawal, my lord. 19 is for withdrawal. Memo.
19 or 19.1 na?
Vachan HU, the petitioners.
When 19 for withdrawal?
Yes, my lord. Sorry.
What is this, Tejas?
7631.
19 for withdrawal.
What do you mean 19? 19 is the one that I am monitoring the matter.
19.
How can that be withdrawn? ನೋಡೇ ಇಲ್ವಾ ಏನು?
ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಹಂಗಿದೆ ಸರ್, ನಮ್ಮ ಹತ್ರ ಇರೋದ್ರಲ್ಲಿ ಹಂಗಿದೆ.
ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಎಲ್ಲಿದೆ?
19 withdrawal ಅಂತ ಇದೆ.
19 withdrawal ಅಂತ ಎಲ್ಲಿದೆ? Memo for withdrawal filed by the petitioner ಅಷ್ಟೇ. The learned AGA Shri Rahul Kariyappa places on record the status report of the investigation as obtaining on 21st July 2025. The same is taken on record. List the matter on 25th.
But you're also directed in the original order constituting the SIT for the state to report on whether paragraph 13 is
So
implemented.
let me just see this, what has happened on list on Friday.
Yes, so great.
Yes.
Also, please.
20.
That's for the petitioner, my lords. I'm appearing for the respondent. I'm appearing for the respondent. My name. I'm appearing.
Sorry,
for,
sir. Yes, tell me.
I'm appearing for the respondent. My name is wrongly typed in the cause list.
Serial number 20 ಅಲ್ಲ?
Please, my lord. ಚಂದ್ರಕಾಂತ್ ಅಂತ ಆಗ್ಬೇಕು, CHDN ಆಗ್ಬಿಟ್ಟಿದೆ.
CHD ಕಾಂತ ಅಂತ.
ಹೌದು, ಹಂಗ ಆಗ್ಬಿಟ್ಟಿದೆ. On 4th, this matter was listed.
Huge mistake. ಈಗೇನ್ ಬಂದಿದ್ದೀರಲ್ಲ ಹೇಳಿ.
On 4th, this matter was listed, my lord. Interim order was granted by this honorable.
Will extend it.
ಅಲ್ಲ, ನನಗೆ ಏನಂತ ಅಡಕೆ ತೋಟ, ಈಗ ಅಡಕೆ ಬಂದಿದೆ ಕೊಯ್ಯಕ್ಕೆ, ಈಗ ಅಲ್ಲಿ ಹೋಗಿ ಪ್ರಾಬ್ಲಮ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Yes, sir.
Very small issue.
Only a week may be granted, Your Honor. We have not served the copy to the.
ಅಲ್ಲ, ನಮಗೆ ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ. ನಾನು ಕೇವೇಟ್
ಅಷ್ಟರಲ್ಲಿ ಅಡಕೆ ಖಾಲಿ ಮಾಡ್ಬಿಟ್ರೆ ನೀವು.
There was a Jubani Issa between mother and defendant number 1, my lord.
No, the petitioners is a dumb and deaf.
Kindly see, my lord.
List thereafter tomorrow in preliminary hearing.
Please, please.
Yes. ಅದೇನ್ ಕಾಪಿ ಕೊಡ್ಬೇಕು ಕೊಟ್ಬಿಡಿ. Registry to print the name of CHD Kanta as Chandrakant R. Patil.
Please.
21.
Appear for
R1 and
petitioner. Eitherly, the document agreement of sale was opposed on the ground that it is insufficient stamp. The first, the trial court hold that it is sufficient stamp and it is admissible. A review petition was filed in an independent proceeding. In that
ಇದು ಬಂದಿರೋದು ನಾನ್ ಸರ್ವಿಂಗ್ ಸರ್ವ್ ಮಾಡಿದಾರಾ?
Yes, yeah.
Okay, yes. List the matter on Friday in preliminary hearing. Enter ಮಾಡಿದ್ಯಾ?
ಇನ್ನು ಕೊಟ್ಟಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ.
ಅಲ್ಲ
ಇಲ್ಲ ಅಂದ್ರೆ ಅದೇ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. Yes.
Friday.
List on 25th. Next.
The objections is that defendant 1 and 2 are not made as parties because they are no more. So that's why that office objection has to be overruled.
Accepting the submission of the counsel for the petition, office objections overruled.
A suit filed for partition by one of the son.
What's the
respondent
matter now?
Matter is
the petitioner
challenging
suit
amendment.
2015 direction na.
Direction ಅಲ್ಲ, ಅಮೆಂಡ್ಮೆಂಟ್ ಕೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಏನಂದ್ರೆ ಸೂಟ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದ್ದು ಕನ್ಸೀಡ್ ಮಾಡಿದ್ದಾರೆ. ಡಿಫೆಂಡೆಂಟ್ಸ್ ಎಲ್ಲ ಹೌದು ಆನ್ಸಿಸ್ಟ್ರಲ್ ಪ್ರಾಪರ್ಟಿ ಎಲ್ಲರಿಗೂ ಶೇರ್ ಇದೆ ಅಂತ ಹೇಳಿ ಕನ್ಸೀಡ್ ಮಾಡಿದ್ದಾರೆ. ಕನ್ಸೀಡ್ ಮಾಡಿದ್ದಾದ್ಮೇಲೆ ಲೇಟರ್ ಆನ್ ಇನ್ 2022 ಈ ಫೈಲ್ಸ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಸೇಯಿಂಗ್ ದಟ್ ಮದರ್ ಹ್ಯಾಸ್ ಎಕ್ಸಿಕ್ಯೂಟೆಡ್ will in his favor and he sought for declaration saying that he becomes the absolute owner of this property. And will is subsequent to
respondent ilwala first time your
suit proceedings irli bari order matra stay
adu gottu. Heard the learned counsel idral beda. Let's day after tomorrow in preliminary hearing.
Much obliged.
Because one damele madidre ella. Yes. Next. 23 post immediately after service of notice upon the respondent. Entry ಮಾಡಿದ್ರೆ continue ಮಾಡಿ. Next.
24.
Madam. In case I don't tell, continue entry ಮಾಡಿ check ಮಾಡಿ.
I appear for the respondent.
24.
Notice to R2 may be dispensed with.
ಇಲ್ಲ ಇದೆ 24. ನೀವು ಯಾರಿಗೆ?
Respondent. 17 to 20.
You are appearing for whom?
I am appearing for my lord Vatsala Construction. Respondent.
ಅದು ಯಾರು respondent ಕೇಳಿ?
Number 1, my lord. In 17 to 20.
Vatsala Construction ನನಗೆ. Yes.
17 to
learned
20.
counsel for the learned counsel Abhinav Ramanand.
He is there, man.
ಕೇವಿಟ್ ಇದ್ದಾರೆ.
My colleague is there, man.
ಮತ್ತೆ ಏನ್ ಬೇಕೀಗ?
It's for disposal, my lord. My lord said put it for disposal.
List on
I filed a memo.
ಏನಿದೆ ಅಲ್ಲ IA 25 production so and so.
Lord,
One is for
during
PF ಯಾರಿಗೆ? R2 ಯಾರು?
R2 is a company which was dissolved during the pendency of the arbitration proceedings itself.
Badwa.
It is no more in. is in
Petitioner
existence.
files a memo seeking dispensation of issuance of notice to second respondent. The memo is taken on record, dispensed with at the risk of the petitioner.
And one of the application which I have filed seeking for amendment of the writ petition, that is subsequent
IA
events.
2 of 2025 shall be heard along with the main matter. IA 1 of 2025, IA 1 mele, for the reasons indicated in the affidavit accompanying the application and being satisfied with the same, the application is allowed dispensed with list on Friday in preliminary hearing.
Interim order may be extended.
Till then, I vote till then. Yes. ಇದು ನಿಮ್ 24.1
Interim order ಇರ್ಲಿಲ್ಲ last time.
defer the proceedings ಅಂತ ಹೇಳಿದೀನಿ. ಅಷ್ಟೇ ಅದೇ interim.
25.
So having served, awaiting post immediately after service of
I have
notice
served upon the counsel for the plaintiff. I am seeking dispensation for respondent number 5, my lords.
Counsel for madam memo for the reasons. Yes.
My lord, identical matter, identical order against the very same defendant has been stayed by this honorable court.
Learned counsel for the petitioner submits that identical petition pending between the parties. There is an interim order of stay. In that light, there shall be an interim order of stay in the case at hand as well, list after 2 weeks. Next.
My lord, this matter needs to be connected to serial number 125, my lords, same, between same parties.
Movie ಹೋಗ್ಬೇಕಾ? Wait. Yes.
Lords, I have complied with the office objections, my lord. The matter before the trial.
Non-compliance of office objections.
I have complied with all the objections.
Interim order ಇದೆಯಾ?
Illa. Matter before the trial court, my lord, is on 25th, my lord.
With regard to RERA execution.
25th.
25th.
With regard to RERA execution, it is squarely covered by a judgment. A section 47 application cannot be invoked where a decree is enforceable is only based on the legal fiction, which is.
Office objections overruled, list day after tomorrow in preliminary hearing. Next.
Much of.
27.
For the petitioner, my lord. My lord, there has been a bereavement in the petitioner's counsel's family.
ಹೌದು ಬೆಳಗ್ಗೆ ಹೇಳಿದ್ರಲ್ಲ.
ಬೆಳಗ್ಗೆ ಆಗಿತ್ತು. So my lords may have it on Friday, my lords.
At the request of the counsel appearing for the petitioner next week.
25th, my lord. Some emergency 2010's FDP proceedings, my lord.
ಆಯ್ತು 28th, list on 28th preliminary hearing. ಇದು ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್. Office objections accepting the submission of the counsel for the petitioner. Office objections overruled, list on Monday in preliminary hearing, 28th. Yes, next. Post immediately after service of notice upon the response. Already idare.
And for the respondent.
Vector appear for the petitioner.
Then awaiting service of notice.
Respondent has already entered appearance.
Registry to delete the indication of awaiting service of notice in respect of the respondent. List on Friday in preliminary hearing.
Interim order.
Interim order subsisting will continue to the next date of hearing.
Great.
29.
My lord, I appear for the impleading applicant. I have filed IA 2 of 25 for impleading. I am the tenant under the respondent, my lord. Now the petition.
That is rejected, is it? Allah, that is allowed. Why are you here?
Lordship's interim order was not granted. The TI was not granted by the honorable court. Lordship's granted the TI. He is not at all a party before the court before any proceedings, your lordships. The matter originally was listed, supposed to be listed on 23/7.
I the application is pending. You appear before the court and submit.
Lordships, the matter was heard before your lordships heard it, saying that because there are two conclusive suits against them, your lordships. Two RSAs are pending.
Application pending idya ilva?
Application is pending.
39 1 and 2 application pending idya ilva?
After hearing your lordships, my senior your lordships
That's
saying
all
that
right.
there are two
Is it pending or not?
They were temporary pending, your lordships. Interim order is not
I will
granted.
continue this for another 15 days. The court will consider it.
May I make one submission? I represent the respondent. By virtue of the interim order granted by this honorable court, they removed the wall between my property and his property. And also they put a junk sheet, not allowing us to ingress and egress to our property.
But you are saying tear down the wall. Yes.
My lord, I am the tenant. I am running
Now
a tea
tenant
shop.
is under me.
They block
He is
the
also-
access, power, water,
Power
everything.
connection, everything
I
has
have
been
to jump the
disconnected
compound and start my business now.
Lordships,
Even
we
the
heard on
access is
23rd,
blocked.
your lordships.
My
Matter is
grievance is
listed
very
on 20.
limited, my lord. I am the tenant under the respondent.
ಎಲ್ಲ ಹೇಳ್ಬಿಡಿ ಏನೇನು ಹೇಳ್ಬೇಕು. ನೋಡಿ, you have disturbed cough.
Sorry.
ಅಲ್ಲ ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಂದ.
No, I am just checking in limited prayer.
Limited vacation of interim
Limited
order.
prayer, my lord. Let them allow me to
ಅವ್ರು
enter.
ಕೇಳಿದಂಗೆ ನೀವು ಲಿಮಿಟೆಡ್ ಇಂಟ್ರಿ ಮಾಡರ್ ಕೊಡಿ ಅಂದ್ರೆ ಲಿಮಿಟೆಡ್ ವೇಕೇಟ್ ಮಾಡಿದ್ರೆ
Leave to your lord.
Monday 28th in preliminary hearing.
Order to be extended, your lordships.
Yes.
Interim order to.
Granted.
Lordship, he is not a party at all. Since
ಅಯ್ಯೋ
2000,
adjournment ಆದ್ಮೇಲೆ argument ಬಿಟ್ಬಿಡಿ
since
ಮೇಡಮ್.
2000, your Lordships, he is not at
Next
all.
week reserve your horses for the next week.
30, Lordships, 28, your Lordships.
28.
Interim order.
ಅಯ್ಯೋ ಕಂಟಿನ್ಯೂ ಮಾಡಿದ್ನಲ್ಲ ಮೇಡಮ್. Yes.
This, there's one office objection with respect to one or two documents, but we are not relying on those documents.
All right, but ಈಗ emergency.
No, it has to be heard because the rejection of plaint application, which is dismissed.
CRP na.
No, ಇದು
dismissed.
commercial court. Commercial court. Commercial court.
Who filed? You.
We filed an application. Application, of course, rejected. We are before your lordships. This is a partnership.
Karana?
I'll tell you, lordships. It's dissolution deed of the year 2003. And the firm was dissolved. After which, my lord, they in the year to file an arbitration, not them, but some other partners file. And my learned friend's client in that CMP says, I want to be transposed as a claimant under the dissolution deed. Then under the dissolution deed, the honorable arbitrator holds it is barred by limitation.
This needs to be heard day after tomorrow.
Very good. Yes. But only thing, my lord, is last time my learned friend was kind enough to say that they will not proceed with the matter.
But no. Why you're not continuing? You're not continuing your kindness?
No. The difficulty is this: they are alienating the properties. If they also say they'll stay their hands, they have no difficulty.
Both of you have a hands-off approach till day after tomorrow.
Oh, today the court is saying I'll keep it till 4 o'clock. If the High Court does not stay the proceedings, I'll post it for orders.
It is for injunction. Therefore, if he also says that he will
but
not.
last time you came and made a statement that you will not proceed with the hearing.
Last time ಅವರು ಮಾಡಿದ್ರು, ಇವತ್ತು ನೀವು ಮಾಡಿ.
ಅಲ್ಲ ಹೋದ್ಸಲಿ ಅವರು ಇರಲಿಲ್ಲ.
I don't know what to say.
Trial time argue the application.
Day after tomorrow, I'll.
Only an application for injunction.
We'll decide it day after tomorrow.
What difficulty? Let them also stay their hands. Let them, because
what are they doing?
They are entering into agreements with third parties with flats. That's the whole subject matter.
Thing is on record.
If they say day after tomorrow, they also stay their hands, because it should not be that the whole thing is.
My learned friend is getting he's getting an injunction in my petition all the time.
If he wants
second time alone, my learned friend is doing.
If he wants some equity. If he wants some equity, he should also do equity. If there is only,
I'm only saying day after tomorrow, your lordships may have it.
Between now and day after tomorrow.
Let the court not proceed with it till then. Lordships, I'll show you lordships how this is completely wrong order.
There's an applicant for injunction. I have argued. He has to argue it today. It is not anything which is going to happen by day after tomorrow. If he says, I will also not alienate the property, then I have no difficulty. We will record it and then we will say that the.
Why will he say in his petition that he will not alienate?
If he wants an order for stay of proceedings.
Stay of proceedings, where there is an on my order 7 rule 11 itself.
Kindly note, this is an application for rejection of plaint. Ultimately, if the order of injunction is granted, he has a remedy of appeal. And if this honorable court will decide that the plaint should be rejected, that order will go. Therefore, this is not a reason why he should defer his arguments on the injunction application. Or because I have an apprehension that there is a threat of alienation of the flats. Flats are being entered into with third parties, and then the whole thing will be rendered infructuous. If he also said to say, yes, I will not argue.
The only issue is the proceedings here should not be rendered fair compli.
It will not be.
The idea is to just keep putting pressure on us. 2003 till 2025, they did not have any problem. 2024, they initiate a suit.
If you want to argue all this in the
building is ready now, my lord. The building is ready now.
Now,
one of the restaurant.
If
they are the persons who filed an arbitration.
Building is ready and the Gro Pravesha baki idea.
How apartment building.
Most properties. If he wants to argue these points before the trial court, I have no difficulty. The court is willing to hear him.
Waiting.
Yeah, absolutely.
Yes, my lord.
Lord, last time when the matter had come up, your lordship will recollect. We said it will not be heard until your lordships hear this matter.
No, please. I'll point out what happened. He moved it at 10:30 for 2:30. We were on caveat. We said have it on the next day. Till that day we will not. Then next day we were there. They took time.
Why did not object?
They took time, and then we pointed out we were ready. They said there was some inconvenience and pushed it.
Day after tomorrow.
I'm ready. But what do I do in trial court? Lords may.
Day after tomorrow.
But I have to tell something in trial court.
You have to tell that it is urgent to day after tomorrow.
They are insisting.
Madli amel nodoಣ. Yes.
I'll inform them.
ಹಿಂಗೆ ಹೇಳಿದ್ರು ಅಂತೀರಾ? ಮಾಡ್ಲಿ ಆಮೇಲೆ ನೋಡೋಣ.
Where's the question? Lordship may just inform them.
For his arguments. I'm sure my learned friend, if he starts arguing.
Let's day after tomorrow in preliminary hearing. Yes.
31.
Amendment application was rejected. Notice has been served on
memo for having served ಅದಿರೋದು. Memo ಹಾಕಿದ್ದೀರಾ acknowledgement? Counsel for the petitioner submits needful has been done. Office to verify. Day after tomorrow. Preliminary hearing.
My lord, one submission is, tomorrow the matter is posted before the trial court.
Adjournment.
Limited stay.
Tomorrow, day after tomorrow. Yes.
32.
For the petition in this case, my lords, I have served the copy on the learned counsel appealing for the
Counsel for the
respondents.
petitioner submits needful has been done. Office to verify. Interim order ಇದೆಯಾ?
Please.
Interim order subsisting will continue. Next.
Great.
33.
For the petitioner, there is no order to issuance of notice to respondent number 1.
Anyway, ಇದಾರಲ್ಲ.
Filed the ವಕಾಲತ್ ಮೇಲೆ.
Learned counsel ನಿಮ್ಮ ಹೆಸರಾ? ರಾಜೇಶ್ವರ ಅಲ್ಲ ಅದು ಹೆಸರು ಗೊತ್ತು ನೀವು ಹಾಕಿದ್ದೀರಾ ಯಾರು?
ನಾನು ಹಾಕಿದ್ದೆ.
Learned counsel Rajeshwara PN submits that is entered appearance for the respondent. Registry to print the name of so and so is appearing for the respondent. 25th.
So I have one submission with your lordship's permission. Subsequent to your lordship staying the matter,
Stay
police
ಇದೆಯಾ?
stay there. Subsequently, the police authorities have intervened in a civil dispute. They call me every day. And they make unwarranted statements.
GM court.
ಅಲ್ಲ ಅದು ಇದೆ. I'll go my lords in a civil dispute. They call me every day. They have got the photographs.
ಎರಡು ಆಪ್ಷನ್ ಇದೆ 482 ಕೋರ್ಟ್ ಇಲ್ಲ GM.
They don't even register the
CPC
complaint. That's right, my lords. Let the impugned order your lordships have stayed. Police, my lords, they have taken protection. And subsequently, they are pressing on me, calling me every day.
Pressing on you?
As in calling me every day to the property.
4/4/2005, the delivery warrant is executed.
That is stayed.
Writ petition.
4/4/2005.
Writ petition is 2025. Sorry, 2020. And this writ petition is filed in June 2025, after we take our possession.
ಅಲ್ಲ ಅದು ಪರವಾಗಿಲ್ಲ ನೀವು 2005-25.
So there's no
My
question
only
of.
grievance, my lords, as on today, let the police, my lords, they are intervening in a civil dispute. If they register a complaint.
GM. Yes.
I have got the
Travel
photographs
4
also.
courts away. Yes.
No, they don't even register they register whatever. there
ಎಲ್ಲ
is.
ಅಲ್ಲಿ ಕೇಳಬೇಕು ಸರ್. Yes.
Your lordships have stayed, specifically, my lords, the interim order.
Interim order subsisting will continue till the next date of hearing. We'll have it on 30th. It's list on 30th.
Great.
Yes. Next.
34.
Parent for petitioner, ma'am.
What is that, sir? Withdrawal. ಮತ್ತೆ? ಹಾ. ಅಲ್ಲೇ ಕೊಡಿ ಪರವಾಗಿಲ್ಲ ತಗೊಳ್ಳಿ ಯಾಕೆ? ಅವ್ರು ಕೌಂಟರ್ ಹುಡುಕ್ತಾ ಇದ್ದಾರೆ.
ಮೈಲಾಡ್ R1 ಗೆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರಿ. R2 R3 ಗೆ ಮಾಡಿರಲಿಲ್ಲ ಮೈಲಾಡ್.
Dispensation.
ಹಾ.
Madam, R2 and R3 dispensed with at the risk.
Interim order
subsisting will continue to the next date of hearing. Next.
5.
R1 and R2 council has issued the petition copy.
Council is here, sir.
Respondent number 3 for R3 man.
ನೀವು R3 ನಾ? R1 and R2?
Copy serve ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ.
Maintainability ಹೆಂಗ?
Maintainability ಅಂದ್ರೆ I am not the party before the court, my lord.
Not the party.
So therefore, my lord,
List the matter. Stay ಇದೆಯಾ?
stay ಕೊಡ್ಬೇಕಾಗಿದೆ, ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಡ್ಬೇಕಾಗಿದ್ಯಾ?
ಹೌದು ಸರ್.
ಈಗ ಆಗಲ್ವಲ್ಲ. Yes, sir.
ನಮ್ ಪ್ರಾಪರ್ಟಿ ಏನಿದೆ ನಮ್ ಸೇತ್ ನಾವು ಮಾರ್ಬಿಟ್ಟಿದ್ವಿ ಸ್ವಾಮಿ. ನಮ್ ಜೊತೆಗೆ ನಮ್ ತಮ್ಮನು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಸಹ ಮಾರಾಟ ಮಾಡಿದ್ದಾಗಿದೆ ಸ್ವಾಮಿ.
ಮಾರಾಟ ಆದ್ಮೇಲೆ ನೀವೇನ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
My lord, that is the after sale, the trial court has confirmed the TI, my lord. Only in portion of item number 1. That is why I am before this.
ಕಾಪಿನ ಕೋರ್ಟ್ಗೂ ಸಹ ಹಾಕಿದ್ವಿ ಸ್ವಾಮಿ. ಮೆಮೋ ಜೊತೆಗೆ ಕೋರ್ಟ್ಗೆ ಹಾಕಿದೀವಿ.
ಈಗ
ಆವಾಗ ಕನ್ಸಿಡರ್ ಮಾಡುವಾಗ ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ, ನೋಡ್ಕೊಂಡಿಲ್ಲ ಅಷ್ಟೇ.
ಅದು ಈಗ ಸ್ಟೇ ಕೊಡೋಣ ಹಂಗಾರೆ. The list the matter after 2 weeks. The learned counsel for the petitioner submits that the needful has been done, office to verify. Till the next date of hearing, there shall be an order of restraint directing the defendants not to interfere with the position of the petitioner.
Please, my lord.
ಅಥವಾ ಸ್ಟೇಟಸ್ ಕೋ ಕೊಡ್ಲಾ?
ಅಲ್ಲ, ಸ್ಟೇ ಕೇಳಿದ್ದೀನಿ ನಾನು.
ಅದೇ ಕೊಟ್ಟಿದ್ದು. ಬೇಡ ಅಂದ್ರೆ ಸ್ಟೇಟಸ್ ಕೋ ಕೊಡ್ತೀನಿ.
ಸ್ಟೇ ಅಲ್ಲ, ಇಂಪ್ಯೂಗ್ಡ್ ಆರ್ಡರ್ ಸ್ಟೇ ಕೇಳಿದ್ದೀನಿ.
Yes, we'll see. ಅದೇ ಆರ್ಡರ್ ಅಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬಂದಾಗ.
36.
A week's time is granted to do the needful.
37.
ಒಂದು ನಿಮಿಷ. A week's time is finally granted 36 ಅಲ್ಲಿ. A week's time is finally granted to do the needful. In the event needful is not done, the interim order would stand automatically vacated. 37.
Lord, I appear for petitioner. Lord, I have served the copy and filed the acknowledgement.
Learned counsel ಹಾಕಿದಾರಲ್ಲ.
ಹಾಕಿದ್ದಾರೆ, ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ.
List the matter on 30th in preliminary hearing. Interim order, yeah?
ಇಲ್ಲ
30th in preliminary hearing. Next.
38.
Representing the petitioner in this matter, Lordship, I have served a copy to the
Your Honor.
respondents, Lordship.
Sir, ಮಾಡಿದಾರ copy?
Notice, sir, notice.
Yes.
My lords, kindly matter might be listed after 2 days, my lordship. Because
Urgency ಇದೆಯಾ?
Senior counsel ಊರಲ್ಲಿ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಊರಲ್ಲಿ ಇಲ್ವಾ?
ಅವರು due to some inconvenience is on out of station.
What is the matter, sir? List on 25th in preliminary hearing. Interim order subsisting will continue to the next item.
Grateful, Lordship.
Yes, next.
49.
In this case, my lord, I filed wakalat for R6 and R7 with no objection from previous counsel, KV Shama Prasad. And I also filed objection statement office along with the citations. Maybe.
Learned counsel so and so submits that he has entered appearance for
Respondent number 6 and 7.
respondent 6 and 7. ನೀವು?
I filed waiver of retirement report.
In the light of the counsel representing 6 and 7, counsel YK Narayan Sharma is permitted to retire from the case.
Kindly I have put up for objection statement all filed in office.
All right, process.
I have paid it for the other
Counsel for the
respondents, my lord.
petitioner submits needful has been done, office to verify. Objections in office objections.
My lords, it is with regard to the annexure preamble not being there, I filed a application
order
for
ಇದೆಯಾ?
dispensation.
Interim order
No, my
ಇದೆಯಾ?
lords, they are given an undertaking on the last.
28th
It is
preliminary
Prior
hearing.
to that, my lord, because case is posted 20.
on the 20th.
28, no problem. Yes, next.
40.
Your lordship, the respondent has been served and a memo has been filed with respect to
Counsel
that.
for the petitioner submits needful has been done, office to verify.
Lord, I appear for the respondent in this case.
Interim order, yeah.
There's a status quo order, your lordship.
Lord, in this case, the present petition has been filed only on the ground that the application for attachment before judgment was kept in abeyance. It may be, the trial court may be directed to dispose of that application. I'm ready to argue that.
I have to take instructions. It may be at tomorrow, your lordship.
No, that is the relief.
You're not ready?
Senior has to appear in this matter.
List, day after tomorrow, but Friday. Yes.
41.
For the petitioner in this matter. This matter pertains to that.
Office objections.
Now, my lord, I have sought for dispensation of production of the entire gazetted copy of the preliminary notification, my lord.
Entire petition dispense ಮಾಡ್ಬೇಡ ಬಿಡಿ.
My lord, that original will take time and also, my lord, more than 1,000.
Then what is the matter?
No, I'm challenging the preliminary notification.
ಏನ್ disposition ಇದೆಯಾ?
There's a threat of disposition, my lord, because
It is always there.
now, my lord, it is not as per the section 10A of the right of
ಅದೆಲ್ಲ merits
compensation.
ಮೇಲೆ ಆದ್ರೆ list on Thursday.
Now, my lord, may I seek at least a notice may be issued to the governments on.
Thursday in preliminary hearing. Dismiss ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ notice ಯಾಕೆ issue ಮಾಡ್ಬೇಕು? ಅದಕ್ಕೆ Thursday. Yes.
Office objections may be overruled.
Office objection, accepting the submission of the council, office objections overruled. List on Thursday in preliminary hearing.
Grateful.
Next.
42.
Appearing for the respondent KV.
Needful has been done, my lord.
Learned council submits needful has been done, office to verify.
R2. I filed a wakalat today.
Learned council so and so.
My lord, in this case.
I have 1 ನಿಮಿಷ sir. Learned council submits that he has entered appearance for the second respondent. Registry to print the name of so and so is appearing for the second respondent. ಈಗ ಹೇಳಿ.
In this case, in the execution petition, we filed an application under Order 1 Rule 10 and also filed an application under Order 20 Rule 1 Rule 52 to determine the legitimate share and right of the petitioner, my lord. The petitioner is the sister of the respondent number 1. And the respondent number 1.
FDP ಇಲ್ಲ.
Not FDP, my lord, against in a LAC case, my lord. LAC, my lord, where since she has also got a legitimate share, that is why she filed an application to implead her as a party and also determine her share. Because the respondent number 1, without impleading as a party in a LAC case, he about to disperse the entire compensation amount. That is why.
List tomorrow in preliminary hearing.
No, day after tomorrow.
Day after tomorrow. All right. Correct. You reminded me. Day after tomorrow. Yes.
43.
My lord, the petitioner
On
has,
payment of DCF.
we have complied with office
Learned council
objection.
submits the office objections has been complied with, office to verify. List day after tomorrow in preliminary hearing.
Much.
44.
ಪಿಟಿಷನರ್ ಕಾಪಿ ಸೋರ್ ಮಾಡೋದಕ್ಕೆ ಕೌನ್ಸಿಲ್ ಜಡ್ಜ್ಮೆಂಟ್ ಹೋಗಿರೋದು ಅದು, ಅದಕ್ಕೋಸ್ಕರ ಸಿಗ್ತಲ್ಲ ಅವ್ರ ಅಡ್ರೆಸ್.
ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ
ಜಡ್ಜ್ಮೆಂಟ್ ಗಿಂತ ಇಟ್ಕೊಂಡಿರೋದು
ಯಾರು ಎ.ವಿ. ಗಂಗಾಧರ ಏನ್ ಗಂಗಾಧರ ಅಡ್ರೆಸ್ ಸಿಗ್ತಾ ಇಲ್ವಾ?
ಅಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂತ ಹೋಗಿ ಚೇಂಬರ್ ಅಲ್ಲಿ ಇದೆ, ಇವರು ಜಡ್ಜ್ ಚೇಂಬರ್ ಅಲ್ಲಿ ಇದೆ ಫೈಲ್.
ಜಡ್ಜ್ ಚೇಂಬರ್ ಅಲ್ಲಿ ಫೈಲ್ ಇದೆಯಾ?
ಜಡ್ಜ್ಮೆಂಟ್ ಗಿಂತ ಹಾಕೊಂಡಿದ್ರಲ್ಲ ಸ್ವಾಮಿ, ಅದಕ್ಕೋಸ್ಕರ ಅಲ್ಲೇ ಇದೆ. ಅವ್ರ ಅಡ್ರೆಸ್ ಸಿಗ್ತಲ್ಲ
2
ಕೌನ್ಸಿಲ್.
weeks to do the needful.
Interim
Next
order
is-
action.
Interim order subsisting will continue to the next date of hearing.
45.
For the,
So then, what is this matter?
this matter is a suit has been.
ಒಂದ್ ಯಾವ್ದೋ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ನಲ್ಲ ಅದೇನು?
Yes,
Ah,
Your Lordship.
Same thing.
The same-
Idರಲ್ಲಿ
same,
they are
matter.
seeking for a declaration of
ಪುಷ್ಪಂ
rights.
ರಿಯಾಲಿಟಿ ಅಂತ ತಕ್ಷಣ ಗೊತ್ತಾಯ್ತು.
They are seeking for a declaration of their rights in respect of property situated in Coorg in Bangalore City Civil Court, and City Civil Court has granted injunction also. So territorial jurisdiction. Section 16.
ಸ್ಟೇ ಇದೆಯಾ?
Section
22
ಅಲ್ಲ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದಾರಾ?
ಇಲ್ಲ, ಇಲ್ಲಿ ಸೂಟ್ ಹಾಕಿದ್ದಾರೆ ಹೊಸದಾಗಿ. ಆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ನಾವು ಹಾಕಿ ಅದ್ರಲ್ಲಿ ಒಂದು
ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ
ಮಾಡಿದ್ವಿ. ಅದಾದ್ಮೇಲೆ ಒಂದು ಸೂಟ್ ಕೂರ್ಗಲ್ ಹಾಕ್ತಾರೆ, ಸೂಟ್ ಫಾರ್ ಇಂಜೆಕ್ಷನ್. ಅಲ್ಲಿ ಎಕ್ಸ್ಪೋರ್ಟ್ ಇಂಜೆಕ್ಷನ್ ಸಿಗೋದಿಲ್ಲ. ಅದ್ ಮುಗಿದ ಮೇಲೆ ಅಲ್ಲಿ ಸಿಗ್ಲಿಲ್ಲ ಅಂತ ನೆಕ್ಸ್ಟ್ ಡೇ ಬಂದು ಇಲ್ಲಿ ಸೂಟ್ ಫಾರ್ ಡಿಕ್ಲರೇಷನ್ ಹಾಕಿ ಇಂಜೆಕ್ಷನ್ ತಗೊಂಡು.
ನಿಮ್ಮ ಆಫೀಸ್ ಎಲ್ಲ ಕಡೆ ಇದೆಯಲ್ಲ, ಅದಕ್ಕೆ ಏನ್ ಮಾಡಕ?
It is not office, it is a section 16.
Yes, how did you?
Immoral property.
Who is senior counsel representing? ನಿಮಗ?
No, I am on behalf of respondent number 2. I filed my wakalat, but it doesn't reflect in the cause.
Learned counsel Anjana CH submits that she has entered appearance for
Respondent number 2.
the second respondent, registry to print the name of so and so is appearing for the second respondent day after tomorrow.
Yes.
ನೀವ್ ಯಾರಿಗೆ?
Well, I'm for the respondent number 1. I'm the one who filed this suit, and there was an office objection on territorial jurisdiction. Court overruled it and then passed ex parte temporary injunctions. They don't appear before the court, my lords. Under order 22, any action that you have to do, first you will have to take up the contention there. And we are in a position to show part of cause of action has arisen here. The suit filed in Coorg has nothing to do with this. I'll be able to point that out, my lords. It's not a case of filing the suit on the same of cause of action in Coorg. My lords, this entire dispute I will point out, my lords.
I know.
Consent. It was a consent.
I know.
So my lords, day after tomorrow I will.
I dealt with it recently. Adinno ಕಳಿಸಿಲ್ಲ sir.
So
Evening we'll release
virtually
it.
what they have challenged in this writ is, my lords, an office note which says on territorial jurisdiction which has been overruled by the court, after which temporary injunctions granted, they don't appear before the court, writ is filed here.
They appear here.
22, I will point out section 22, my lords. If
List
they have
on.
not taken, yes,
Friday
day after tomorrow,
or 23rd
Please.
preliminary hearing.
please.
24th.
24th Thursday ಇಲ್ಲ Wednesday or Friday?
Friday.
Friday 25th.
So they enjoy the interim relief, my lords.
No, only for a limited period.
All right, my lords.
Only for
Friday.
a limited period of time. That's
Friday,
another 2-3
Friday,
days.
we go on.
He is confident that it will be only for next 2-3 days.
Obliged.
All right, yes, 25th.
Interim order may extend.
Interim order subsisting will continue to the next date of hearing. Yes, we will release that today, madam. I'm not.
Please. 46.
46, my lords, matter pertaining to the land acquisition of KADB.
Stay ಇದೆಯಲ್ಲ?
Respondent
Covered
number
by
2
me.
and 3, my lords.
Covered by,
It's covered by.
By my lords.
Coordinate
File,
bench is passed
wakalat,
on
my
order.
lords.
ಅಲ್ಲ ವಕಾಲತ್ ಹಾಕಿದ್ರೆ ಏನೋ ಮಾಡಿ ನೀವೇನ್ ನೀವು ಅದಕ್ಕೂ ಅಡ್ಡ ಬಂದ್ರೆ
ಇಲ್ಲ, let them
Yes.
not.
BB Patil.
list on Tuesday. The learned counsel with the petitioner submits the issue and the list stands covered by plethora of judgments. The counsel BB Patil seeks 3 days time to file his wakalat. List on Tuesday.
Obliged.
Yes, next.
My lords, seal number 87 also on the same subject.
ನೀವು ಮೂವಿಗೆ ಹೋಗ್ಬೇಕಾ?
ಇಲ್ಲ, my lords,
ಇರಿ.
go on.
Yes.
Preliminary hearing 47.
And for the petitioner, my lord. Petition's application for amendment of FD petition to incorporate 2 more properties which had been not included in the working document. Yes, my lord. For the petitioner's application for amendment of the FD petition to incorporate 2 properties, 2 more properties which were not there in the final preliminary decree. is
Why did you
about-
forget in preliminary decree?
Yes, that is.
That's the problem, sir. Not possible.
Yes, because any number of decrees, preliminary decrees can be passed in a partition suit.
Correct.
And any number of final decrees also can be passed. A coordinate bench of this honorable
But why
court-
did you forget it then in 2012?
No, because because she said daughter, she was not aware of what are the properties.
Oh,
also
judgment
belong
ಆದ್ಮೇಲೆ
to-
ಬಂದಿರೋದ
Yes.
Supreme Court judgment. Yes. Petitioner to serve on the counsel who represents the respondents in the trial proceedings and file an acknowledgement.
No, I am the petitioner, my lord, in the trial court.
Serve ಮಾಡೋದು ಬೇಡವಾ? Respondents serve ಮಾಡೋದು ಬೇಡವಾ?
ಈ preliminary ಇವಾಗ first time ಬರ್ತಾ ಇರೋದು.
First time ಬಂದಾಗ notice ಮಾಡೋದು ಬೇಡವಾ?
Because the final decree will be passed next day.
That's the problem. Yes.
That is the urgency.
List on, ಇವತ್ತು serve ಮಾಡಿ, list 28th in preliminary hearing. Next.
Stay of the other
Next.
proceedings.
48.
My lord, I pray for petition, my lordship. Respondents. My lord, in this case, my lordship, it is church matter, my lordship.
Church matter.
Yes, my lordship. CSI.
And take me to the church.
Yes, my lord. My lord, the election which was taken place during the stay granted by the Supreme Court, my lordship.
Oh, this is that church matter.
Yes, my lord.
Stay, my lord, was only in
No, I'll just,
relation to-
one second, I'll just
My lord,
finish it
please.
off. After that, you can do it, sir.
Church matter, you should not be in a hurry. Wait.
My lord.
My lord, there was a stay.
ಅದು ಕೊಡಿ ಕೊಡು sir.
During the substance of stay, my lordship, election
What was this? What was the nature of the interim order, sir? Interim order to continue till the next date of hearing.
Next date of
What
hearing.
was that was granted?
Not to conduct any administration charges, not to
Not to conduct elections. and
elections
like that.
also is there, my lordship, covered in that.
Where is the order? Sir?
Order is passed, my lordship.
What was the date of this order?
Date of the order, my lordship.
22/5/24.
Yes, my lord. Subsequent to that, my lordship.
When were the elections conducted?
Subsequent to that, my lordship.
ಅದು subsequent date ಇಲ್ವಾ? ನೀವು ರಿಟರ್ನಿಂಗ್
22/5/2024, my lordship. was the
22/5 elections.
Election.
When, sir?
Election, 11/6/2024, my lordship.
Where is the notification of election or notice of election by the church? Page.
Page number, my lordship. The order has been passed, my lordship.
Page number ಹೇಳಿ sir. ನೀವು ರೆಡಿ ಇಲ್ಲ ಅಂದ್ರೆ ಹೇಳಿ 4 ವಾರ ಬಿಟ್ಟು ತಗೊಂತೀನಿ ಅಂದ್ರೆ ನಿಮ್ಗೆ interim order ಬೇಕೇನೋ?
To vacate the interim order, my lordship. The interim order is there, but interim order, my
That's why
lordship.
I'll vacate the interim order and list it after 4 weeks.
No, my lordship. Interim order is
If you
there.
are not ready in the matter and want to argue the matter of flipping the pages before the court, I will
No,
vacate the interim
accidentally-
order and adjourn it by 4 weeks.
No, my lordship. It will be taken up on Monday, my lordship.
What taken up on Monday?
Accidentally, I got some other file, my lordship. That is the problem. It was there and there. One more file I got it, church matter only, my lordship.
ಅದಕ್ಕೆ ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್ ತರ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ಅಂದ್ರೆ
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಬೇರೆ ಕೋರ್ಟ್ಲಿತ್ತು ಕೇಸು, ಆ ಫೈಲ್ ತಗೊಂಡ್ಬಂದ್ಬಿಟ್ಟಿದ್ದೀನಿ.
ಬೇರೆ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ಬಿಟ್ಟು ಈ ಕೋರ್ಟ್ ಫೈಲ್ ತಗೊಂಬನ್ನಿ. ಪಾಸ್ ಓವರ್ ಮಾಡಿ.
Yes, my lord.
Yes, pass over.
Pass over.
Yes, sir. Why did you hold elections?
My lord, the order of the Supreme Court, my lord, is not to hold election in relation to moderator and deputy moderator of the synod.
ಎಲ್ಲಿದೆ ಅದು?
ಅದು ನಾನು I will place that before this court, my lord.
ಅಲ್ಲ,
Now,
where is
they have
that?
not taken this
Only with
contention.
regard to synods ಅಂತ ಎಲ್ಲಿದೆ?
I will produce that, my lord, because they have not
This
taken.
is not the order of the Supreme Court?
That is the order of the Supreme Court, my
Then-
lord, but only in relation to the synod.
How, where do I gather that here?
That I will produce it, my lord, because, my lord,
Are
before
you
the trial
wanting,
court.
are
they
you
have not
wanting me
taken
to
this-
interpret the order of the Supreme Court?
No, my lord.
Then?
My lord, before the trial court, my lord, they have not taken this contention.
You forget it, sir.
Yes, my
If you have violated the order of the apex court, then we view the matter seriously and stall everything.
Yes.
Where is it said that for the synods?
Because the order which has been challenged before the Supreme Court, my lord, is the order of the Madras High Court.
Election,
In relation
that
to
I am
election.
aware, sir.
Yes.
Any decision with regard to holding election or administrating the church South India so and so. How did you hold elections when there was an embargo, unambiguous embargo?
Yes. There is,
How
is
did you?
the two administrators were appointed by the court, my lord. They
Yes.
have very categorically, my lord, given a letter. I will place it before this court, my lord.
Administrators giving a letter will override the orders of the apex court?
Certainly not.
Then?
They were appointed by the court, my lord. But my lord, I will clarify that, my lord, I'll place all these records before this
We'll
court.
haul you up for
Today, the
contempt if
election
you
has
have held
been-
elections in the teeth of the interim order.
My lord, I will produce it, my lord. We have not,
ಈ ಕೇಸಲ್ಲೇ ಫೈಲ್ ತರಲ್ಲ.
I will not I have not committed any willful disobedience or any contempt of the order of the court, my lord. I'll produce all these things, my lord. Yakandre allegation, my lord, is that 20 non-Christians have.
Forget it, sir.
yes.
Merits ಮೇಲೆ. When there is an order of the apex court not to hold election, how did you hold elections?
That was only in relation to synod. I'll place the material before this court, my lord. I'll send
Whatever,
a copy.
Supreme Court has not clarified with it's not qualified its order by saying it's.
Final order clarify ಮಾಡಿದ್ದಾರೆ. Final
ಇದು
order
interim
ಮಾಡಿದ್ದಾರೆ.
order
ಇದು interim order.
Final order
ಈಗ
ಏನಾಗಿದೆ?
dispose ಆಗೋಗ್ಬಿಟ್ಟಿದೆ. matter.
ಏನಾಗಿದೆ ಅಲ್ಲಿ?
ಅಲ್ಲಿ my lord to hold elections ಅಂತ ಆಗಿದೆ. ಇವತ್ತು synod held the election. Today the moderator was.
ಇಲ್ಲ,
elected.
ಇವತ್ತು ಆಮೇಲೆ Supreme Court has permitted you?
Yes.
Today is the election, my lordship, for the synod. But this is pertaining to all over the election to be held at administration.
Anyway, you
We'll produce all
have
this.
bought a different file. Search the regular file and get back next week.
Grateful.
Yes.
Monday, my lord.
Monday.
Grateful.
No problem. Yes.
Sorry, my lord.
What? Interim order action ಮಾಡಲ್ಲ ನಾನು. Yes.
My lord, till next date.
File problem. Yes, next.
No, that's there was little modification is required on the interim order, my lordship. Interim order is
ಇಲ್ಲ
given.
ಅಂದ್ರೆ ಈಗ ಮತ್ತೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
So this copy I got it, my lordship. There is last word only. There is a interpretation, my lordship. They are holding the post actually. There is a clear cut order.
List
Nevertheless, having
list
read
on-
the facts of the impugn order was
List
passed
on
on the
28th, interim order extended. Yes.
much obliged.
Next.
Grateful.
49.
Appear for the petition this matter, my lord. But at the last instance, my lords had asked for a clarification. My lords, this is
ಹೌದಾ? I have not asked any clarification.
one clarification, my lords. FDP, when I was not there in the suit, so how come I was seeking for relief of entering into FDP? My lords, page 92 of my petition,
In daughter,
daughter.
that's all right. Daughter ಅಂದ್ರೆ will permit. ಏನಿಗೆ?
Page 92, I had filed an application.
The petitioner shall serve on the council who represents the respondent.
Yes, sir, my lords.
Huh?
They are on record also.
Where are they?
R1, R2 was there last time. This time I'm not able to see. R3, R4 were served.
49 ಇದು.
49.
So and so. List the matter on 28th. Further proceedings before the concerned court shall remain stayed.
ಇಲ್ಲ ಇಲ್ಲ ಅದು dispose ಆಗಿದೆ. I am only seeking
ಏನ್
for.
ಕೇಳ್ತಾ ಇದ್ದೀರಾ ಈಗ?
My prayer is.
Then let them come 28th. Yes.
Right.
Appearing for petitioner, my lord. Senior counsel not in station, kindly may give a day after tomorrow, my lord.
Yes, Devanand sir.
My lord, the judgment of the trial court has been stalled on the day when they made an application, postponed the judgment. And it was to be pronounced during the month of November 2024.
No, the coordinate bench has granted interim orders. Yes, sir.
A day after tomorrow.
Why you are not ready?
Senior counsel is now not in station.
List the matter on 28th as a last chance in the event.
Interim order.
30th as a last chance in the event the submissions would not be made by the petitioner's counsel, the interim order would get vacated. Next. Subject to the aforesaid interim order stands extended. Next.
51.
Vacating stay?
Yes, yes. I filed synopsis also. My lords has asked us to file a synopsis.
Oh, R176.
Yes. Correct.
Yes. Hello, Friday.
Great.
Friday or Monday? Next Monday.
Hello, Friday. Friday. I have some difficulty on Monday.
I have some difficulty on Friday, we'll see. List on 30th and for under the caption vacating it, under caption interlocutory applications. Next.
Interim order be
Interim order subsisting would continue to the next date of hearing.
52.
My lord. It is application that were filed under section 10 and order 2 rule 2 was dismissed, my lord. I have challenged section 10 application under WP, my lord, and 2 rule 2 under CRP, my lord.
You have tag agiro petition, oh, this matter. Yes. Yes, list on 30th. Yes, next. Interim order idea?
ಇಲ್ಲ
ಇಲ್ಲ,
ಸ್ವಾಮಿ,
30th,
ಇದರಲ್ಲಿ
yes.
WPL ಕೇಳಿದ್ದೀನಿ.
30th, yes, next.
53.
For the respondent.
Non-compliance of the section 12A of the Commercial Court Act.
My lord, I filed the judgment and the synopsis, my lord.
Yavaga?
It was filed, my lord, on the 18th.
No, nothing is here.
Could I pass on, my lord?
What is it? What is the issue?
My lord, the non-compliance of 12A is the ground that is urged, my lord, to file a 7 to 11 application. The Dhanbad oil judgment, my lord, is quite clear that if an urgent interim relief is being sought for.
What is the urgent interim relief you sought for?
My lord, it's a suit for eviction, my lord. I am the landlord. The plaintiff is the tenant. The defendant is the tenant. I am the plaintiff before the court. There's an apprehension made out, my lord, that they will sublet the property. They have not paid rent for the entire duration of the 10 months of the tenancy. After the tenancy has lapsed, my lord, about 2 years now, they continue to squat on the property. Therefore, I filed the suit for eviction. Under the apprehension, my lord, that they will sublet the property, my lord, I filed the suit. And also an IA one, my lord, was filed.
What's
2
the
IAs
prob-
are filed, my lord, please complete.
What's the problem?
No, your
Not paying rent, is it?
No, without for filing an apply, seeking without exhausting the remedy available under section 12A.
So don't worry about it.
No.
You're not paying the rent?
No, this is under construction project. Project is not yet completed. It's only a financial transaction. There is no landlord and tenancy.
My lord, they dispute, my lord, the sale deed by which I become the owner of the property. They do not set up a counterclaim. My sale deed is not questioned.
See, where's the matter on 30th?
Madam, I'm copy.
54.
Yes.
Appearing for rest, kindly pass or filed an application for vacating also.
Kindly pass over, madam. This is the matter MFA.
No, idiano.
For a permission to put up a
151,
compound wall.
section 150. Injunction order has been granted by this honorable court, my lord, in the MFA. And writ petition has been filed by my lord against the order under order 9 filed by the applicant deputy number 6 under section 151.
Have purchased the property, my lord, and has made all preparations to put up a compound wall. All materials are, my lord, there at the spot. But at that time, my lord, the court has permitted me also, the trial court, to put up a compound wall. But now an injunction has been granted. I have filed an application for vacating also. My lord, I have purchased the property, my lord, paying huge amount. But 3, 4, just facts, my lord, I will just narrate. I have filed synopsis in both the cases, in a writ petition as well as in MFA.
ಏನ್ ಕಾಂಪೌಂಡ್ ಕಟ್ತಾ ಇದ್ದೀರಾ?
Compound ಕಟ್ಲಿ.
ಇಲ್ಲ ಕಟ್ತಾ ಇಲ್ಲ.
ಕಟ್ತಾ ಇಲ್ವಾ?
ಕಟ್ತಾ ಮೆಟೀರಿಯಲ್ಸ್ ಹಾಕಿದ್ರು ನಾವು ಅಷ್ಟೊತ್ತಿಗೆ ಅವ್ರದ್ದು ಆರ್ಡರ್ ಆಗಿದ ತಕ್ಷಣ ಇಮಿಡಿಯೇಟ್ ಗೆ MFA.
ಮೆಟೀರಿಯಲ್ಸ್ ಯಾಕೆ ಹಾಕಿದ್ರಿ ಅಂತ ಕೇಳಿದೆ.
Please.
ಕಾಂಪೌಂಡ್ ಕಟ್ಟಕ್ಕೆ.
Compound. And I have specifically said, my lord, I will give an undertaking. I will not plead any equity at all. My lord, in case, my lord, if I lose the suit. My lord, there was a direction to dispose of the suit within a year, but that has not been done.
ವಾಲ್ ಯಾಕೆ ಕಟ್ತಾ ಇದ್ದೀರಾ?
Compound.
ನಿಮ್ ಮನೆದ?
Managalla is a vacant property, my lord, which I have purchased, my lord, by paying you 12.5, more than 12 crores. My lord, it was an occupancy right granted to my vendor. My lord, he got it converted, and my lord, thereafter he has sold it to me. Now, my lord, when I went to the spot, my lord, this man came and said, my lord, I have purchased it from the one of the sons of the owner. 2 sale deeds, my lord, that is also manipulated there. Then, my lord, at that stage, my lord, I said occupancy right is granted much earlier to his purchase, and therefore he has no title. He came and filed a writ petition before this honorable court. This honorable court recorded, my lord, prima facie you have no title. Then he withdrew the writ petition.
Where is that?
Pardon me?
Recording ಎಲ್ಲಿದೆ? He has no title ಅಂತ ರೆಕಾರ್ಡ್ ಮಾಡಿದ ಈ ಕೋರ್ಟ್ ಎಲ್ಲಿದೆ?
Yes. My lord, annexure. My lord, annexure. Justice
ದೇವದಾಸ್.
Pardon me?
ದೇವದಾಸ್.
No, Justice Veerappa.
Page.
My lord, page writ petition, page 853.
53.
50 or statement of objections. Statement of objections, page 53.
Volume 1, statement of objections.
But earlier to it, my
Yes,
lord.
sir. If that is the issuing.
But page 50, man. Statement of objections.
Yes,
Kindly pass over, my lord. Senior wants to argue. Kindly.
Day of tomorrow.
Please.
Yeah, day of tomorrow. We'll see. Yes, next.
Interim order.
Interim order subsisting will, day after tomorrow.
Very good.
Day after tomorrow in preliminary hearing. Next.
In both cases, my synopsis is there, my lord.
No problem.
P5.
Yes, Vishwanath sir, ಏನಿದೆಲ್ಲ ಇಷ್ಟೊಂದು?
They filed an application to eschew some of the paras in the written statement. And before considering the statement, application to seek leave of the court to file written statement, the court has passed an order in some cases. So I have procured the order sheet also.
Yes, sir. Admissions, huh?
They wanted to eschew some of the paras in written statement stating that para number in some writ petition.
Oh, you are the plaintiff.
I am the defendant.
Who wants to, who you want to?
Plaintiff has filed an application in section 151 CPC to delete some of the paras in the written.
In what?
It is
the written statement.
In the written statement.
Yes, sir.
They have made allegation against the counsel appearing for the plaintiff in the written statement, and the application which they have filed for seeking leave to file written statement, that we have no objection, my lord. But the problem is that open allegations that are made against the counsel himself. How can it be defended by the counsel when the allegations are made? Let them meet the points as far as plaint allegations are concerned.
ಏನ್ ಮಾಡಿದೀರಾ counsel?
ಏನು ಮಾಡಿಲ್ಲ, ನನ್ನ ಡಿಫೆನ್ಸ್ ನಾನು ಸೆಟಪ್ ಮಾಡಿ one para your lordship.
Which is that offending clause or
clause may
paragraph?
kindly be seen.
ಅವರೇ ಹೇಳಿ ತಾಳಿ.
Because they filed a complaint. Advocate went to the high grounds police station and lodged a complaint. So what I have stated, advocate has lodged a complaint. On the basis of that, criminal case has been registered. That's all I have stated.
Page.
Please, my lords, in WP number 14041 may kindly be taken.
I am holding
14041. In fact, writ petition I have extracted, in all the writ petitions I have extracted that portion. That is page number 9 may kindly be taken, please. Page number 9 of the writ petition.
The buildings bold murder,
that allinda 10(5) in the 10 subclause 5, that is Roman 5. Adanna they wanted to delete full. Nothing as just
Robespierre suit bearing so and
that
respect of the property, the building site together structure north south bounded by
all
belonging to the defendant.
Then
submitted that so and so.
Then 10
during the pendency of 3 suits, father of the defendant expired. Advocate ಮೇಲೆ ಏನಿದೆ?
Advocate ಮೇಲೆ 10 para number 10 subclause 10 may kindly be seen, page number 14. Page number 14.
Page 9
It is pertinent to mention here that the advocate on record came to the High Grounds Police Station on 30/6/2021 and pressurized the inspector.
Sir, ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
Page number 14, please.
I am at 14.
Ink page, second line.
14.
Yes, ink page, second line. It is pertinent to mention that here that the advocate on record came to the High Grounds Police Station on 30/6/2021 and pressurized the inspector of police to raise FIR against the defendant in crime number so and so on the basis of the alleged complaint said to have been filed by Pinto, Saroja and Vijaya. That's all. Nothing has been stated. This what transcribed I have stated, and on the basis of this complaint, criminal case has been registered. Now I am prosecuting, I am defending that also. That is the only issue. And if they, because criminal case has
thing is, ಅದೇನು advocate ಅಂದ್ರೆ ನೋಡಿದೆ. Otherwise plaintiff cannot dictate the defendant to say you alter your written statement. ನಿಮ್ದೇನಿದೆ ಅದು ನೋಡ್ಕೊಳ್ಳಿ.
And that too,
written statement ಎಲ್ಲ change ಮಾಡಿ plaintiff has no right to say that.
And next para may kindly be
seen. You amend your plaint.
No, he has not read the earlier paragraphs where the relevance is given to this is a second round of litigation.
Let it be any number of rounds, sir, but which is that offending clause?
Allegation is in 1981 the same
offending clause ಯಾವುದು?
Who represented the same party ಅದೇ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರು ಅಂತ.
ಏನ್ ತಪ್ಪು?
fact ಹೇಳಿದ್ದಾರೆ. ಅವರೇ ಪರ್ಸನಲ್ ಆಗಿ
ಅಲ್ಲ fact ಹೇಳಿದ್ದಾರೆ.
They wanted to delete court fee issue also. Your lordship may kindly turn to next issue.
Anything else, sir?
ಕೋರ್ಟ್ ಫೀ ಇಶ್ಯೂ ನಾವು ಟಚ್ ಮಾಡಿಲ್ಲ.
ನೀವು ಯಾವುದನ್ನು ಟಚ್ ಮಾಡಕ್ ಆಗಲ್ಲ. ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅದು ಮಾಡಿ ಇದು ಮಾಡಿ plaintiff cannot say.
10 and 14.
A plaintiff should be given an opportunity to defend the allegations that are taken up.
You file rejoinder. That's
whatever you want. Rejoinder.
ಅಲ್ಲ ಏನ್ ಬೇಕು ಹಾಕೊಳ್ಳಿ ಸರ್.
Yes.
ಆಯ್ತು rejoinder ಆಗ್ತದೆ.
ಕಾನೂನು ಇಲ್ಲದೆ ಇರೋದೆಲ್ಲ ಆರ್ಡರ್ ಬರೆಯಲ್ಲ ನಾನು.
But what has happened is
Whatever may have happened.
90 ಅಲ್ಲಿ ನೋಡಿ ಒಂದೇ ಸೆಕೆಂಡ್ ಗೆ.
Page 90.
90. ಆದ್ರೆ ಒಂದ್ಸರಿ ಒಂದ್ ಕಡೆ 23 ಅಂತ ಬರೀತಾರೆ, ಒಂದ್ ಕಡೆ 90.
ಆಯ್ತು.
90 ಅಲ್ಲಿ ಹಿಂಗ್ ಬರೀತಾರೆ. Police authorities instead of protecting the interest of the advocate at the instance of the advocate on record, a false criminal case has been initiated against this defendant, and this defendant is prosecuting the said criminal case. Also lodged,
I don't find anything offensive.
Kindly see, go further, my lord. Below that, it is pertinent to mention here that the advocate on record came to the High Grounds Police Station on 36/21, pressurized the inspector of police to raise FIR against the defendant in crime number so and so on the basis of the alleged complaint said to have been filed by Pinto so and so, all the 5 members. Said alleged complaints is none other than the children of so and so. Counsel,
So and so, nothing.
Go and let it be on the plaintiff. We are not having any contention as far as plaintiff and the
ಅದ್ರಲ್ಲಿ
defendant.
ಏನೇನು
Counsel ಗೆ
there
involve
is
ಮಾಡಿದ್ರೆ
nothing derogatory to be apprehensive of any order that would be passed against the advocate. There is nothing. Anything else?
problem
You
is
you are the plaintiff.
yes.
Our written statement ಈ ತರನೇ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಕ್.
ಅದು ನಾನು ಹೇಳ್ತಾ ಇಲ್ಲ.
ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ಅದನ್ನ ಹೇಳ್ತಾ ಇಲ್ಲ. ನಮ್ದೇ ರಿಕ್ವೆಸ್ಟ್ ಏನಂದ್ರೆ delete those portions which are derogatory to the counsel on
It is
record.
not derogatory at all. ನಾನ್ ನೀವು ಹೇಳಿದೇನೋ ತುಂಬಾ ಬರೆದು ಬಿಟ್ಟಿದ್ದಾರೆ ಅನ್ಕೊಂಡೆ. ಏಮ್ ಲೆದ್. Yes. Dismissed. Sorry, allowed, quashed.
Liberty to file oppose the application.
That you always have. Barkoli, therefore citizens petitions are allowed. The ಏನ್ ಆರ್ಡರ್ ಏನ್ ಮಾಡಿರೋದು? ಆರ್ಡರ್ ಇಸ್ ನಾಟ್ ಅ ಚಾಲೆಂಜ್.
What, that is the
expunge.
That's allowed, is it?
Allowed, ಅದು eschew ಮಾಡಿರೋದನ್ನ that
The order of the concerned court eschewing or eschewing the observations which are said to be derogatory.
paras Millard, paras
Paragraphs, the deletion of paragraphs in the written statement permitted on an application filed by the plaintiff stands quashed. The petitioner, the plaintiff is at liberty to take recourse to proceedings in law, comma, as available in law.
Much of.
Yes.
56.
In FTP proceedings, my lord, they were impleaded on the basis of a will, my lord.
So what?
My lord, they have to seek, my lord, their right under different, in a suit, my lord.
Why?
Because, my lord, they are not the LRs of.
That's a matter of evidence.
ಅಲ್ಲಲ್ಲ ಅದನ್ನು ಅಲ್ಲೂ ಮಾಡಿದ್ದಾರೆ, ಅಲೋ ಮಾಡಿ ಅವ್ರ ವಿಲ್ ಅನ್ನ ಡಿಸ್ಪ್ರೂವ್ ಆಗಿದೆ ಅಂತ ಆರ್ಡರ್ ವಾಸ್ ಪಾಸ್ಡ್ ಬೈ ದಿ
ವಿಲ್ ಡಿಸ್ಪ್ರೂವ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
ಅಲ್ಲ, that's what your lordships.
I hear
With number 37.
List on 30th interim order subsisting will continue to the next day.
May I make one submission, my lord? There are 1/5 share, my lord. We have got only 1/5 share I have got, my lord. Remaining shares are in intact. Therefore, my lord, it may be restricted to, my lord, 4/5 share of the, my lord. That's, my lord.
Wednesday 30th. Yes.
30th. Interim order may be extended.
57.
Matten, madam.
4th June, my lord has passed an order. Summary suit nalli regular
Oh,
suit summons.
yes, a detailed order I think I have passed.
4th
I guess so.
That captures the issue at stake in. Okay, that's-
Form number 4.
My lord, what has
Only-
happened is, my lord, first of all, the order passed by the trial court and the IA filed by them is wrong, my lord. They have filed 37 Rule 3, my lord, which should have filed it under 37 Rule 2 for writ of summons. They filed a summons for judgment, my lord. My lordship may look at the order on page number 37, my
No,
lord.
the error is committed by the court, sir.
My lord, because they've adjudicated on the wrong
You
application.
have filed a wrong application?
Yes, my lord.
No,
I might- if I can point
out.
If I may point it out from the order sheet, my lord, page number 37, my lord.
IA, plaintiff has filed IA under order 37 rule 3 of CPC, praying to issue summons for judgment in form 4A, my lord.
That is the error committed by the court.
No, my lord, I also point it out in the front, my lord. IA 1 is
Front,
37 rule, in the first, page number 33, my lord, the cover page of the order sheet.
Where is that?
Page number 33, my lord, annexure A.
Summons in form 4A.
My lord, IA number 2, they should have adjudicated upon first. They should have argued that first, my lord. They haven't pressed on that. The council has argued in the trial court on summons of judgment, my lord.
296, no, page number 296 is the IA which was urged before the honorable court.
This on the, this is what I have also considered. I marked it already.
Correct.
Yes, sir.
This is the IA.
My lord, there's also the concern that it doesn't fall under.
Win over a case on merit, sir. Why all this?
My lord, it doesn't fall under the ambit of a summary suit, my lord. It doesn't fall under the ambit of a summary suit, my lord.
Court has committed, it has issued summons for judgment.
My lord, it appears that they have filed it wrong as well, my lord, and they've argued on the same.
Sir, any number of applications with wrong provisions may be quoted. Court has a duty to look into it.
Yes, my lord.
Court cannot go on.
My lord.
It issued notice for pronouncement of judgment instead of trial.
In fact, no, it has issued regular suit summons.
Not the summary suit summons.
Not summary suit summons at all.
My lord, it's also there's a contest. It's contested that it doesn't fall under summary suit, my lord. And respondent number 3 ceased to be a partner in the firm, my lord, which has also been brought to the notice of the petitioners.
Who is respondent number 3?
Partners. Respondent number 1 is the partnership firm. 2 and 3 are partners.
My lord, respondent number 2, my lord. Respondent number 2 has ceased to be a partner in the year 2013, my lord. In fact, before filing of the summary suit, we had brought it to the notice of the petitioner when they issued a legal notice, my lord.
But may I just take 2 minutes of this course? 2 minutes. Summary suit I filed. Summon should go in form number 4. Form number 4 is unique in as much as it gives time of only 10 days.
When I take this case, deja vu.
I stopped filing summary suits. Familiarity illa.
She knows it, yes.
My lord, there's also the contention, if I may pass on a judgment, my lord, the Bombay High Court has also held that a recovery of money via on a check doesn't fall under the ambit of the summary suit, my lord.
I will consider it. Yes. Day after tomorrow.
Yes, my lord.
Great.
Much obliged.
List day after tomorrow in preliminary hearing. Interim order subsisting will continue till the next date of hearing.
Much obliged.
Great.
58.
My lord, I appear for the petitioner. My lord, in earlier proceeding, it's a suit for partition and separate possession. During the pendency of the suit, the matter was settled before the Saddharma Pita, Nyaya Pita.
Pita?
Saddharma Nyaya Pita, where all the parties have approached the Swamiji and there they have agreed.
Swamiji?
Sirigere Swami. Saddharma Nyaya Pita, what alternatively he entertains the parties for ಅಂದ್ರೆ mutual settlement ಗೆ mutual. There, my lord, it was settled. Thereafter, the suit was decreed.
Based on that settlement?
Not.
Then?
Both the parties did not follow up. In the meanwhile, the suit came to be decreed, giving 1/5 share, whereas before the Nyayapita, they agreed for certain. Sorry, the name is there. They have agreed for that. Subsequently, even after filing the suit, also there was one more settlement in same terms.
Before the same Pita?
Not after that.
Different
amongst them, they have entered into an agreement. FDP has been filed. Even after that, one more settlement they entered into. Subsequently, the FDP came to be one order has been passed where the share has been altered, challenging that they filed a writ petition before this honorable court. That in that writ petition, this honorable court,
Narendra Avarda?
Allah, Justice Natraj, 112 page number, para 9.
Why are you back to the court?
They did not hold any inquiry whatsoever as per the direction of this honorable court.
Where is the direction of this court?
Page number 112, para 9. However, it is to be noticed that the parties had purportedly entered into the settlement in terms of which the petitioner had agreed to receive 3 acres of land and a sum of rupees 6 lakhs towards her share in the suit scheduled property. A document in writing.
Inquiry ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
ಇಲ್ಲ ಕೆಳಗಡೆ ಮಧ್ಯದಲ್ಲಿ final, in view of the settlement arrived between the parties or not, has to be now considered by the final decree court before it takes any other steps to demarcate and hand over 1/5 share of the petitioner in the suit schedule properties. For all practical progresses, the document referred above could be treated as settlement, which does not require compulsory registration in view of the judgment of the apex court in the case of so and so. Therefore, the final decree court is bound to verify whether the parties have settled the dispute fully and finally, and whether there is a need to pass a final decree in terms of the preliminary decree. In view of the above, this writ petition is allowed in part, and the impugned order passed by the final decree court is set aside. The case is remitted back to the final decree court, which shall consider whether the parties have settled the dispute, putting an end to the enforceability of a preliminary decree. If it is of the opinion that the parties have not settled the dispute, then the final decree court shall take steps to appoint a commissioner. Then we wanted to produce the document. Now an order has been passed on that application stating that the other side has disputed. Now there are continuously in 4 documents, there is a signature. Even there is a complaint, police complaint stating that they have undertaken to hand over the possession, that they have handed over, but later there is some dispute. Like that, there are documents which clearly establishes the fact that they have settled the dispute. Now, even I have not been allowed to produce the document. On that application itself, the court has come to the conclusion that there is no such settlement and immediately appointed the court commissioner.
My lord, my submission is threefold. Firstly, my lord, the preliminary, the decree was passed preliminary in a partition suit declaring me that I am entitled for 1/5 share. That was questioned before this court way back in the year 2013. That was dismissed. RFA was dismissed. Later execution, FDP proceedings were taken out to carve out my share of 1/5 among the scheduled properties. And of course, in fact, there were moves for compromise, which I declined it. Now, this court earlier in the writ proceedings, what my learned friend read was, shall consider if there was a settlement, the FDP court to take notice of it. Not an inquiry to be held. No, I said I have no.
No, you come to page 113.
113, I am at it, my lord. I am at it.
I am also at it. Notice.
The case is remitted back to the final decree court, which shall consider whether the parties have settled their dispute, put an end to the enforceability of the preliminary decree. If it is of the opinion that the parties have not settled the dispute, then final decree court shall take steps to appoint a commissioner to demarcate the share. No, I did not agree for the compromise. Of course, there were moves for compromise, in fact. And I did not agree for it. They wanted to give up my...
No, enforceability of so and so. If in the opinion of the parties have not settled the dispute, the final decree court shall take steps to appoint a commissioner to demarcate so and so. Again, document produced madadre.
We have produced 4 documents which were produced before this court was taken into consideration, and I wanted to produce those documents for inquiry purpose. Application melene order ಮಾಡಿ they closed it.
158
inquiry has to be held as per the signatures and other things are concerned.
158.
158. Court did inquire.
So let those documents be taken on record. So what?
It is of no consequences at all.
Court orders no consequence.
Allah, I have not agreed for a compromise. In fact, compromise.
If he wants to prove something, let those documents come on record. So what?
As in the wake of the direction of the learned single.
In the wake of the direction,
the inquiry has been held. What more?
What inquiry without those documents?
No, even in reference to it, in reference to that, inquiry has been held. Kindly.
What? Now tell me, what's the problem in producing the documents? Nothing.
Absolutely nothing.
Then we will allow this.
Yes. I am not agreeable for it. Final decree proceedings to go on with the next stage of the proceedings.
No, I will direct production of those documents and the court to regulate its procedure.
Please, my lord, when I do not agree, it's okay. Then the final step would be, the result.
If you do not agree there, then whatever it is, that's a different thing. Now, produce the ring.
Because let the order of this court, my lord, honorable court, be made clear. In event, let them produce the document before it. And in event of my disagreement with it, of course, the court cannot compel.
The court will regulate its procedure and pass necessary orders.
That is all observation I wanted it.
Ultimately, my lord, there is signed documents are there. That I wanted to produce and hold an inquiry on that. That is what we require.
detailed inquiry has been made, my lord. There is
No,
no
it
need
is
for
only-
second inquiry at all.
The honorable judge says that they have
156
denied.
may kindly be looked into, 156.
My lord, even they denied before this honorable court. But this honorable court, after noticing the documents and the signature and the conclusiveness of the settlement, it has directed to hold an inquiry. That is the purpose. Otherwise, even they denied before this honorable court.
167 may be looked into. Inquiry did take place, 167.
Without
And-
those documents on record.
Yes, there, in fact, the photocopies of those documents were placed on
Tell me
record.
where is it?
167. On the last few lines from the bottom, my lord, this is how the sentence commences. On the other hand, the respondent number one. Did my lord got it?
On the other hand, the respondent number one has not placed any material before the court to show that he gave 2 acres 20 guntas in so and so as recited in the consent deed. ಯಾರ್ದು ಅವ್ರದ್ದು ಅದು?
ಅಲ್ಲಲ್ಲ, ನಾವೇ ನಮ್ಮ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲೇ ಮೊದಲು 2 ಎಕರೆ 20 ಗುಂಟೆ ಅಂತ ಒಪ್ಕೊಂಡ್ರು. ಆಮೇಲೆ ನಾವು 3 ಎಕರೆ ಕೊಟ್ವಿ. ಹಣ 6 ಲಕ್ಷ ಕೊಡು, 2 ಲಕ್ಷ ಒಪ್ಕೊಂಡಿದ್ವಿ, 2.5 ಲಕ್ಷ. Then we wanted to give 6 lakhs.
Let the documents come on record. You contest it. If there is any order passed, remedy always open.
Why? Because they already an order on the relating to the inquiry of that document has already been gone into by the court earlier, and the court has passed a detailed order, which conclusion is at page 168.
So which is the order pursuant to the order of this court?
My lord, this is the order.
That is reducing the quantum of grant of.
Allah, this is the order, is it?
Yes, sir.
Reducing they wanted the final decree proceedings to reduce the quantum of share from 1/5 to 1/15 in view of the compromise. And the court did consider it and reduce the quantum of my share. As against which, my lord, I had to come before the court. That portion of the order is set aside by this court.
Yes, sir.
My lord, the total land which was available was 20 and odd. Even, my lord, when the order was passed, 3 acres we have agreed.
There is inquiry conducted by the court.
My lord, kindly see in the inquiry, the learned judge says, my lord, they denied it. Now, my lord, the very same thing has happened before this honorable court. But on the other hand, there were 4 documents. My lord, in all the documents, signature is available. And the finalization of their dispute was there. Under these circumstances, my lord, now what happened when settlement took place? The properties were developed by the other parties according to the settlement. Now they want.
Anything else, sir?
My lord, kindly see, I may be permitted to read that the order which says that they denied. My lord, that cannot be alone be considered. My lord, my humble submission is that when this court, after considering all these things, has directed to hold an inquiry, my lord, it is something more than what they say and what we say.
Anything else, sir?
My lord, that is the only point, my lord.
The petitioner is before this court calling in question an order dated 10/3/2025 passed on IA3 and order dated 4/4/2025 on IA2 in FDP 3 of 2016. Heard so and so. The parties to the list were before this court in writ petition 46023 of 2018, which comes to be disposed on 10th December 2024. In the light of the parties being the same, I deem it appropriate to paraphrase the observations of the court to the subject order, page 106 to 113. The petitioner is back to the doors. The respondent in writ petition, in the said writ petition, is back to the doors of this court on the score that there has been violation of the order passed by this court with particular reference to paragraph 9 and 10. It is the contention of the counsel for the petitioner that the concerned court has not acted pursuance or in furtherance of the order passed by this court, and no inquiry has been conducted as was directed. The learned counsel appearing for the respondent submits the detailed inquiry is conducted and the observations of the inquiry forms the fulcrum of the impugned order. The order dated so and so reads as follows, page 165 to 168. The concerned court observes that on inquiry being conducted about the proceedings as directed by the court and draws up a reasoned order. In the light of the only submission made by the counsel for the petitioner that the order did not act in pursuance or furtherance of the order passed by the coordinate bench quoted supra, and this court finding no error on the face of it for this court to interfere in exercise of its jurisdiction under Article 227 of the Constitution of India, the petition stands rejected, leaving open, rejected, sir. Yes. Next.
Respondent number 1, my lord. Petitioner, my lord. 59.2 is my petition, my lord. My lord, there was a direction by this honorable court for the respondent to produce the bank statements.
I have produced my bank statement, my lord.
My submission is, my lord,
Number 1.
they have suppressed the facts about the presenting of checks to another bank.
Less the matter on 1st August. Interim order subsisting will continue to the next day. Next.
60.
Respondent, my lordship.
2 to 6 yaru.
Appear for
Formal
petitioner, my
partition, my
lord. The
lord.
settlement talk is going on, my lord. Kindly 4-week time to.
Last 2 times of the same submission, my lordship.
The learned counsel in the event and birthday then already. Yes, sir. Come on, merits. Fast. Really?
Yes, it's a proxy counsel, my lord, actually.
The counsel representing the counsel seeks adjournment list after 2 weeks.
Interim order to be-
Proxy counsel interim order action madala. Yes,
61.
next.
You appear for the respondent, my lord. I filed a memo on 18/7/25.
My lords, this is a matter where, my lords, a nominee to a safety deposit box ought to be impleaded. The court allowed it.
No, State Bank of India.
Yes, my lords.
Inspection is done.
Inspection is done, no will is found, my lords.
There are other 2 bank lockers, my lords.
Yella bank ko same direction.
Please. They said no objections in their.
My lords, in my affidavit, I've said no. My client is very clear, my lords.
Which other?
They have the details. Last time I didn't have the details, my lords.
Memo is filed on 18/7.
This court on 4/7/2025 had passed the following order. Counsel Ajay Nandalike files a memo
My lords.
of inventory drawn by the manager of Canara Bank where no will is found. Yes, sir. The learned counsel appearing for the respondent now submits that there are 2 other bank lockers where the will may be there. So address kodi madam.
I filed a memo.
They filed a memo on 10th.
The learned counsel for the petitioner is no objection to check every bank locker. Therefore, the observations shall be observations dated 4/7/2025 shall be paraphrased with a change in the name of the bank. Memo kodi. Nimde kodi. ಎರಡಕ್ಕೂ ಮಾಡೋಣ. ಇದೆರಡು ಅಲ್ಲಿ ಏನು ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿದ್ದೀನಿ ಆ ಥರ ಇದು 2 ಬ್ಯಾಂಕ್ ಲಾಕರ್ದು ಬರ್ಬಿಡಿ. ಸಾಯಂಕಾಲ ಕೇಳಿ ಹೇಳ್ತೀನಿ. ಎಸ್, ಅದು ಮೆಮೊ ಇರಲಿ ಮೇಡಮ್.
Just request for a date to be fixed for the.
List on 1st August.
Yes.
62.
So last time, my lordship have asked that where is the compromise petition, the 20,000 amount is returned, my lordship. It's a case where the petitioner.
Where is the compromise petition?
Lordship, page number 14, my lordship. It's a case where petitioners have filed a suit for declaration and possession, my lordship, and a gift deed, cancellation of gift deed.
Idena?
Yes, my lordship.
Order decree ಅಲ್ಲಿ.
It was settled in Lok Adalat, my lordship.
ಆಯ್ತು, ಎಲ್ಲಿ ಆರ್ಡರ್? ಲೋಕ್ ಅದಾಲತ್ ಆದ್ಮೇಲೆ ಡಿಕ್ರಿ ಡ್ರಾ ಆಗಿರ್ಬೇಕು. ಎಲ್ಲಿ ಅದು?
It's a compromise decree.
Told you, get the documents.
Page number 14.
Counsel for the petitioner to produce the entire documents in support of his claim. List on documents being produced. List on documents being filed in the registry. Next.
A date may be given.
Next file ಮಾಡಿ. ನಾಳೆ ಮಾಡಿದ್ರೆ ನಾಳೆ ಬರುತ್ತೆ.
Otherwise, it may not be listed.
No, first you file, sir. I have said so. Yes, next. ಮತ್ತೆ ಬಂದು ಮತ್ತೆ ಅದಕ್ಕೆ ಅಡ್ಜನ್ ಆಗೋದು ಬೇಡ.
Oblige.
Petition.
I represent the
Plaintiff's
respondent.
petition, my lord. Order 18, Rule 13, my lord. After, sorry.
60?
Order 18, Rule 17.
17.
ಹೌದು, ರೂಲ್ 13 ಅಂತ.
ಇಲ್ಲ, 13. Rule 17, sorry, my lords.
Yes, sir.
Plaintiff's petition, my lords. after conclusion of trial, my lord,
ಯಾರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು?
further examination PW1, my lords.
ಫರ್ದರ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಬೇಕು.
ಎಷ್ಟು ಸರಿ ಮಾಡಿದ್ದಾರೆ?
ಒಂದ್ಸರಿ
ಇಲ್ಲ,
ಮಾಡಿ
ಒಂದೇ ಸಲ ಮಾಡಿರೋದು, ಪ್ಲೀಸ್.
TW1 ಆಗಿದೆ, ಕ್ರಾಸ್ ಆಗಿದೆ, ಡಿಫೆಂಡೆಂಟ್ ಆಗಿದೆ, TW1 ಆಗಿದೆ, ಅವ್ರನ್ನು ಕ್ರಾಸ್ ಮಾಡಿದ್ದಾರೆ. Now in order to fill the lacuna, my lord, he wants to examine again. And that
Not
apart, if your lordships could kindly, my lord, a suit is filed against an unknown person initially, John D. suit. Thereafter, my lord, he files a suit against the true owner. Their injunction is refused. My lord, that suit itself is stayed now. He is a third party, my lord, wherein they want to.
I will hear on Wednesday. List on 30th.
Interim order may be
Interim order
extended.
subsisting will continue to the next date of hearing. Next.
Counsel for petitioner, my lordship.
Respondent
Short
number two, my
accommodation will
lords.
be needed, my lord, to
At the
release.
request of the council appearing for the petitioner list after 2 weeks. Interim order ಏನಿಲ್ವಲ್ಲ?
Interim ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ, but execution is pending. my lord.
Pendency of this petition will not come in the way of further proceedings before any fora. Next.
Great.
Read, lordship.
People, the respondents, man. At least short accommodation.
Stay there. At the request, council for the respondent seeks 2 weeks' time. List after 2 weeks, interim order subsisting will continue to the next date of hearing.
Date may fix, man.
66. Appealing for petition. My lord, in this case, my lord, the petitioner herein, my lord, filed suit for partition and separate position, my lord. The trial court granted an interim order of temporary injunction, restraining the respondent number 2 from alienating the property, my lord.
Alienating the property.
Yes, my lord.
ಏನಾಯ್ತು ಈಗ?
Now, my lord, in the meanwhile, my lord, the brother, my lord, behind the back of the petitioner, my lord, he has sold the property to the respondent number 1, my lord. In this case, my lord, he has filed suit for specific performance, and on the date of appearance, my lord, matter was referred to the local, they have compromised, my lord. Thereafter, my lord, since he has not executed the sale return, he has filed execution case, and coming to know about the same, my lord, I have filed application to implead and brought to the knowledge of the court about the
And
interim order.
2197 application ಹಾಕಿದ್ರು.
ಹೌದು. Now, the trial court, my lord, without conducting inquiry, my lord, rejected the application as not maintained.
Separate suit is filed, my lord, interim order is granted. My lord, they can adjudicate their own.
Execution ಹಾಕಕ್ಕೆ ಏನಂತೆ?
Execution is pending, my lord.
ಅದ್ರಲ್ಲೇ ಬರ್ಲಿ ಬಿಡಿ.
ಸಪರೇಟ್ ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
ಯಾವ್ದು ಬೇಕು ನಿಮ್ಗೆ?
ನಮ್ಮನ್ನು ಇಂಪ್ಲೀಡು ಮಾಡಿದ್ದಾರೆ.
Lord, ಅವರು ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ತಗೊಂಡಿದ್ದಾರೆ.
ಯಾವ್ದು ಬೇಕು ನಿಮ್ಗೆ? ಇಂಪ್ಲೀಡಿಂಗ್ ಬೇಕಾ ಅಥವಾ ಅದ್ರಲ್ಲಿ ಬೇಕಾ?
ಅದೇ ನೀವು ನಂದ್ರಲ್ಲಿ ಇಂಪ್ಲೀಡಿಂಗ್ ಮಾಡಿ ಟೆಲ್ ದೆನ್ my lord not to.
No.
ಆಲ್ರೆಡಿ ಅದರಲ್ಲಿ
Otherwise, my lord, I am permitted to implead in the execution case.
ಐ ಹಾಕಿದ್ದಾರೆ. That may be allowed.
So ಆ ಸೂಟ್?
ಅದು suit for partition ಅದು. ಇದು
You have
suit
no
for
objection?
My lord, they himself, my lord, made part.
The petitioner is before this court calling in question an order dated 6/3/2025 passed on IA 6 and 7 declining to allow the application under order 21 rule 97 of the CPC seeking impleadment into the party, impleadment as a party in the execution proceedings. Execution proceedings.
OS. Execution ಅಲ್ಲಿ
In the execution proceedings, execution petition 80, no objection na?
21 rule 97 dismissed in execution petition, my lord. Based on that, my lord, separate suit is filed, my lord. They can adjudicate the matter before their own.
But now since there is a decree obtained by the my lord.
Separate suit ಹಾಕಿದ್ರಲ್ಲ contest
Separate
ಮಾಡಿ.
suit to partition, separate position. ಈಗ one of the brother has sold the property to third party. Now he has remained absent. His court has appointed court commissioner to execute the sale deed, my lord.
ಅದರಲ್ಲಿ ಪಾರ್ಟಿ ಇದ್ದಾರೆ, ನಮ್ಮನ್ನು ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ. ಇಂಟ್ರಿ ಆರ್ಡರ್ ಗ್ರಾಂಟ್ ಆಗಿದೆ.
ಯಾವ್ದ್ರ ಅದ್ರಲ್ಲಿ?
ನಮ್ಮ ನಂಬರ್ದಾಗ ಎಂಟ್ರಿ ಮಾಡಿದೆ.
ಯಾವ ಸೂಟ್ ಅದು?
OS.
ಪೆಟಿಷನ್ ಯಾವ್ದದು?
OS 443 of annexure E, my lord.
ರಿಟ್ ಪೆಟಿಷನ್ ಯಾವ್ದು ಸರ್?
ರಿಟ್ ಪೆಟಿಷನ್ ಅಲ್ಲ, OS
ಮಾತ್ರ.
OS ಅದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ನಾಟ್ ಟು ಅಲಿನೇಟ್ ಅಂತ. This is contrary to the direction by the civil court, my lord. Very civil court, my lord, is
civil court ಅಲ್ಲಿ adjudicate
List on 30th. Yes, next.
Right, in the meanwhile, my lord, commissioner is appointed to execute the sale deed, my lord.
ಅದರಲ್ಲಿ ನಾಟ್ ಟು ಅಲಿನೇಟ್ ಅಂತ ಆಗಿದೆ.
Yes, ಇನ್ನೊಂದ್ರಲ್ಲಿ ಆಗಿದೆಯಲ್ಲ. Yes, next.
ಆಗಿದೆ, despite my lord, commissioner is.
Yes.
For the defendant petitioner, Lord, both the matters are on board now. Lordship will recall this is the 2004 suit, not
earlier than 2006 suit.
Earlier than the 2006 suit, which our lordships were pleased to dispose of recently. Lord, in this suit, when the matter was put down for arguments, the plaintiff takes out 3 applications, the defendant takes out 3 applications, all 3 applications under identical provisions. One under Order 18, Rule 17, under Section 151 and 7 Rule 14 for recall, reopen and for production of certain documents. The trial judge, my lord, allows the applications filed by the plaintiff and dismisses the applications filed by the
Plaintiff
defendant. Yes, my lord. Plaintiff is the respondent.
Mm.
Lord, the trial judge applies a twin test of relevancy and reasons given for non-production at the earliest point of time. Now, Lord, I'll take your lordships. The 3 applications which the plaintiff had filed, Lord, is IA 31, 32, and 33, which is impugned in WP 19133 of 2025. So, Lordship, may I please have 19133 of 2025. I'm fully conscious, Lord, of your Lordship's board today. I'll not waste a single minute, but I have to demonstrate to your Lordships the extent of fraud and falsehood played on this court. So, Lord, without wasting a single minute, Lord, please come to page 63 in WP 19133 of 2025. This is the affidavit, Lord, which was filed.
Why heavy jargons?
But your Lordship will
Come on,
see it,
merits. Yes. Mm.
page 63 in WP 19133
I'm there,
of
affidavit.
20. Yes, Lord. That's there. Please come to para 3, Lord. I'll just read 3 paragraphs to point out, Lord, 3 things that your Lordship will note, Lord. I state that the plaintiff herein is the absolute owner of the suit schedule property bearing 17/2A. I state that the date of execution of the sale deed dated 24/11/1994, the plaintiff is in possession and enjoyment of the suit schedule property and was under the impression that the suit schedule property was situated in 3/3B of Ganakal. Now, please note, in para 4, I state that during the pendency of the present suit, in view of the doubts created by the defendants herein, the plaintiff addressed a letter to Special Tehsildar, Bangalore South Taluk, Bangalore, sought for the survey of the suit schedule property as per the boundaries in the sale deed. Now, this letter was sent in 2007 to the surveyor to conduct a survey. The Taluk surveyor went to the spot, identified the land in possession of the plaintiff as per the boundaries shown in the registered sale deed dated 24/11/1994, found that the suit schedule property is situated in survey number 17/2A, though the same is numbered as so and so. Now, my lord, para 5. I read out para 4 to explain to your lordship the purpose for which this application is taken out. Please see para 5. I state that in order to substantiate the said fact, I have already produced the said survey report and the same has been marked as exhibit P5 in the present suit. The survey sketch is P5. I state that though survey report is produced before this honorable court and marked by me as exhibit P5, defendant number 11 raised various adverse contentions as to the genuineness and the custody from which the said survey report was produced. Therefore, Lord, please mark this. On 21/20/25, I had filed an online application seeking for certified copies of the documents relating to exhibit P5 under RTI. Para 6. I state that after a lot of efforts and only after filing of the second appeal before the Karnataka Information Commission, the said documents were made available to me on 11/6/2025. Please mark that note. And immediately upon the receipt of the documents, without even a delay of 1 day, I am filing this application to produce the same before this honorable court. I state that the said documents could not be produced earlier despite due diligence, which phrase your lordships had very recently interpreted, as the same were made available to me by the concerned authorities on 11/6/2025. So, my lord, from these 3 paragraphs, there are 3 points that I want to highlight to your lordships. One, they, my lord, filed the application for survey in 2007. The survey was conducted in 2007. Point number 2, my lord, they make an application to receive those documents on 21/20/25, and pursuant to the RTI, they say they obtain those documents on 11/6/2025, and immediately thereafter they produce it before the honorable trial court. Lord. Now, Lord, on the previous day when this matter had come up first day, Lord, at the stage of the first hearing, first stay, my learned senior had pointed out this is basic CPC, Lord. I understand we are all just now starting practice, we are learning CPC, but your lordships will see, not from what we learned from our seniors, basic CPC is you must never plead falsely in your affidavit. Now your lordships will see.
What is false here?
Yes, Lord. Let me just show your lordships what are the documents that they have sought to produce, Lord. Your lordships will find that. Please come to page 71, Lord. This is IA 33 filed under say, Order 7, Rule 14. There were 10 documents that they intended to produce before the trial court. Very quickly, Lord, to give your lordships what those documents. The first 4 documents relate to the RTI correspondence. That is, they applied to the RTI on 21, the correspondence there, 11/6 acknowledgement that pursuant to that. 5 to 10, my lord, relate to.
So, yalla very old documents.
5 to 10, document 5 to 10 relate to a public record, the survey reports of 2007. Why they are producing it now is because Exhibit P5, which was the survey report, in their cross-examination of their PW1, there was a credibility concern. Therefore, to satisfy the genuineness of Exhibit P5, they have produced certain other documents, all relating to 2007. My vigilant client went before the RTI authority before whom they applied. And my vigilant client went and applied an RTI himself to receive the documents which were given pursuant to their RTI correspondence.
Your client is here.
I don't know, Lord, if you say I'm not, but my vigilant client went
The
to the
vigilant-
RTI department. I have to tell your lordships why he's so vigilant. Now, please see, Lord, what the concerned RTI correspondence that we received pursuant to our RTI application.
Kudi. What is the vigilance problem now?
The vigilance problem is there was no document given pursuant to their RTI application at all. They say on 21/2025 they apply for RTI, and through RTI they obtain these documents. On 11/6 they say they obtained these documents, certified copies, and on the very next day they produced it. Now please see, my lord, I've produced the RTI application, page 8, my lord. Now this is a correspondence between the AC and the Tehsildar, and this is dated 23/6/2025. This is the AC telling the Tehsildar, please give them their documents. So at least till 23/6/2025, and I've got it verified, till now no documents have been given. At least till 23/6/2025, no documents were given pursuant to their RTI at all.
What is your suggestion?
Lord, my suggestion is the Supreme Court says three things, Lord. There are three consequences which follow when you plead falsely to a sworn affidavit. One, Lord, it's clearly abuse of process. Therefore, Lord, cost must follow. Two, Lord, if you plead falsely and you deceive the court, I have judgments which say that amounts to criminal contempt of court, and in any case it amounts to perjury. Therefore, Lord, this is what my vigilant client just found. Other than that, no, I have to say, Lord, where the
That's why he's not here.
it's not me who has gone there. So, Lord, credit where it is due to my client for having found this out. Where litigants like this, Lord, take the courts for a ride. From 2004, this suit is going on, and this is how I explain, Lord, why this suit has gone on for so many years. In fact, Lord, at the time when your lordships heard this first day, I had said these documents were in fact in the custody of the plaintiff, because in 2023, in a petition that was heard and filed before Justice Nataraj, a coordinate bench, these very same documents, document 5 to 10, which I showed before your lordship, were part of that petition. Later, Lord, my client goes there and obtains a copy of the RTI correspondence.
Vigilant client.
Vigilant client. Yes, Lord. Therefore, your lordships will see they have come to this court, pleaded falsely before the trial court, pleaded falsely before the high court in their statement of objections. Serious cost must follow, Lord. And in fact, if I have to show your lordships, what is it that the
I knew exemplary. What is serious?
I'm sorry, Lord.
Yes.
Lord, therefore, they say there was due diligence. They could not produce it earlier because of due diligence. Now, Lord, the test which the trial court applies is relevancy and non-production at the earliest point of time. The earliest point of time when they could have produced a document relating to a file in the year 2007 was in the year 2013, when the PW1 first entered the box. He enters the box in 2013. That was the first time when he could have produced it. He has to give reasons for non-production from 2013. He gives no reason. He says in 2025, January is when he first applies for RTI. When he already had it, not to demonstrate that he already had those documents. Please just come to one page, not.
Again, documents here
Just
than
please see,
our produced
in their
model.
own documents, just please see what they say. Page 83, Vansala Nodi.
To delay the proceedings. Is it? Now this application is filed.
Lord, they have filed these applications, and these applications are filed in 2025 June. The trial court has got deceived by the governments in their affidavit, has allowed their applications. Now it has to again go back for
Applications
plaintiff's
are,
evidence.
you are challenging those orders allowing the
Yes,
application.
their applications are allowed, my applications are dismissed.
Oh,
Now-
those are the two petitions now.
Yes, Lord. So
One
the petition-
dismissal, one allowing.
One dismissal, one allowing. And Lord, in my case, look at the arbitrary manner in which the learned trial judge applies the law. He says relevancy and reasons given for non-production at the earliest point of time. The reason on which my application is dismissed is saying I've given a Xerox copy of the Leveni sketch. Not whether it's a Xerox copy does not turn on relevancy. It turns on admissibility. So he cannot, when he applies the test of relevancy and non-production, apply the test of admissibility. The test of admissibility will apply when he enters the box and marks the documents. That stage has not yet come. Therefore, not the learned trial judge has acted with complete arbitrariness in allowing their application, having got deceived by the governments in their affidavit. And therefore, in fact, I have produced the WP copy which they filed in 2024 before a coordinate bench, in which all document number 5 to 10 were already produced there. Annexure K of that petition, Lord, they've already produced all of it there.
Right.
Yes.
Yes, madam.
Lord, our applications, writ petition challenging order on our application is taken first. Your Lordship may kindly look at the order,
Madam.
which is now my,
9133, na?
Yes.
which your Lordships are now holding. Reasons given, my Lord.
ಇದು ಯಾವುದು ಇಲ್ಲ petition is, oh, that is.
19133.
Alright,
in
yes.
which
Second petition is the order challenging, allowing our application. I had filed a suit in 2008 seeking for rectification of the sale deed, which came to be dismissed. There, I had relied on the survey sketch. Subsequently, in 2013, I entered the witness box, and this sketch is marked as Exhibit P5 without any objection from the other side. Once the subsequent, vigilant, diligent client is the subsequent purchaser of a disputed property. So he steps into the shoes of the plaintiff, and then he takes this investigation forward according to them, and identifies that this is actually a document which is not available with the revenue authorities. So we make an application to summon the revenue authority. The revenue authority comes before the court, doesn't bring the file. On 2 occasions, he appears without bringing the file. So hence we close the side of our evidence, and the matter gets posted for their evidence. Subsequently, my lord, parallelly, the plaintiff had made an application under RTI before the authorities, and he doesn't get any response from them. Once he files a second appeal, he gets the documents. On the very next day, the application is made, and as my learned friend is saying, applications under Order 7, Rule 14, 18, Order 18, Rule 17 is filed by both of us. Their application is.
ಎರಡು ಅಲೋ ಮಾಡಕ್ಕೆ ಏನಾಗಿತ್ತು ಮತ್ತೆ?
ಅಲ್ಲ, ಅವರು ರೀಸನಿಂಗ್ ಏನಂದ್ರೆ ಒಂದೇ ರೀಸನ್. ಐ ಓನ್ಲಿ ಟೇಕ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಟು ದೇರ್ ಅಪ್ಲಿಕೇಶನ್.
ಎರಡು ಅಲೋ ಮಾಡಿದ್ರೆ ಆಗ್ತಾ ಇತ್ತು. If ಇಲ್ಲ ಎರಡು ಮುಗಿಸ್ಬೇಕು.
I did not disturb, so let him not disturb.
Yes.
If your lordship may kindly take the first petition which he has filed, the reasoning by the trial court, only reason is non-production of a 2003 document by them is they had filed multiple applications. I was engrossed in defending all these matters before the High Court, so hence I could not file. That is the only reason given by them. The trial court comes to the conclusion this reason is not tenable because you had these documents with you from 2003 and 2007. You have not produced it.
You also had it.
No, I did not have it. Because I had to. They had an endorsement from the very same authority in 2023.
You forget about that. I may dismiss that. But you also had it.
No, I did
earlier.
not have it because I had gotten it marked down also, my lord. Because
it presumes that you had it.
No, they make an application in 2023 before the revenue authorities, get an endorsement that we had never done the survey. So that is why we had to apply under RTI. And this is the reason, my lord, I wouldn't want to take your lordship's time because your lordships have a heavy board. This is all. I leave it to your lordships. I don't want to do long winding
They
arguments.
still stand to their argument that pursuant to the RTA, they've obtained these documents. Lord, I have correspondence to show pursuant to the RTA, their own RTA, they get nothing.
Will dictate on 30th.
Please, oblige me.
List on 30th at 4:30 PM.
So great.
Orders. Yes. Yes, next.
68.
No representation.
But second matter could be taken first. Connect.
First matter close ಮಾಡ್ಬೋದಾ?
First matter speedy disposal, but I think second matter come.
Second matter needy disposal. Yes.
This is more relevant. But what has happened here is suit for eviction. He has not paid the rents from 2021. We instituted a commercial court case for eviction. By page 145.
Why are you here?
ಏನಂತಂದ್ರೆ he was directed to pay rents about 2.5 crores and more. He did not deposit the rents. He moved the Supreme Court after the directions of this honorable court. December, the Supreme Court dismissed his SLP. In January, he filed one more application seeking to amend the counterclaim, seeking 10 crore damages. The court permitted it. Please, it was allowed. It was allowed. Though affidavit evidence was led in July.
Heard the learned senior counsel Vivek Reddy appearing for the petitioner. The petition is the first itoli WP 19826, madam. The learned senior counsel takes this court through the documents appended to the petition to demonstrate that an application seeking amendment of the counterclaim by insertion of the damages of 10 crores
Yes, my lord, 10 crores.
10 crores is permitted at the fag end of the proceedings. In that light, there shall be an interim order of stay of the order dated 10/6/2025. It is made clear further proceedings before the concerned court are not stayed.
Please, please, please.
Next.
But second matter is first matter is early disposal.
ಆಯ್ತು ಬಂದ್ಬಿಡ್ಲಿ ಅವರು.
But-
Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement.
Please, please,
Yes, next.
please.
GMKL ಇಲ್ಲಿ ಯಾಕೆ ಬಂತು?
My lords,
Why GM
writ
matters?
petition seeking
Nitin Ramesh. Oh, all right, yes.
But I am the impleading applicant, my lords. There are three more impleading applications which have been filed by my office.
Three more
my lord,
impleading
that may also-
applications.
Yes, my lord. What has happened is they want a sweeping investigation to be done. They have
ಅಖಂಡ
already
ಕರ್ನಾಟಕ
approached the
ರಾಜ್ಯ ರೈತ
Lokayukta.
ಸಂಘ.
My
ಏನಿದೆ?
lords, it's a registered farmers organization.
ಅದು ಗೊತ್ತು.
It
What do you
consists of-
want, sir?
My lords, I'm seeking a direction to I'm seeking a writ of mandamus from this honorable court to direct the respondent number 5, who is the honorable Lokayukta, to investigate into the irregularities which is committed in the distribution
Complaint
of
ಕೊಡಿ.
irrigation systems.
Complaint ಕೊಡಿ.
I've given a complaint, my lords, to the
Yes,
Lokayukta as per annexure
Arbadi,
A,
sir.
page number.
Complaint ಏನಾಗಿದೆ?
They've not taken action.
ಒಂದು ನಿಮಿಷ. ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಎಲ್ಲಿದೆ?
Yes, my annexure A, page number 15 to page number 19, my lords.
ಹಾ. ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
Copy of
I have
sir.
received a copy, my lord.
List on Monday, 28th.
Take instruction.
Learned counsel Sri Venkatesh Arbatti to secure instructions and make his submissions.
Great.
All the applications said to have been filed and pending in the registry be put up on the next date. Next.
I'll file my detailed objections to that IM, my lords. Much obliged.
Senior counsel set up in another court, my lord. Kindly have it on tomorrow at least.
ಲ್ಯಾಂಡ್ ಎಕ್ವಿಷನ್ ಇವತ್ತು ಯಾಕೆ ಬಂತು?
It was given date, my lord, on Friday. And that day, my lord, it was not listed. Maybe taken up tomorrow or any day after tomorrow.
ಎಂದು?
Any day.
Any day.
Any date, my lord.
Friday.
Please.
Till such time, my lord, not to
No.
disperse the compensation.
No, no, my lord, there was no order at all.
There is
Question of,
no order at all, therefore I am praying for that.
ಆಲ್ರೆಡಿ ತಗೊಂಡಿದ್ದೀರಲ್ಲ ಕಾಂಪ್ರಮೈಸ್.
ಇಲ್ಲ.
ಅದನ್ನೇ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದೀನಿ.
No, we have not received.
No, takes this court.
Compromise decree is
Petitioner is abused, having taken all the properties pursuant to the
That-
compromise.
that precisely
Now
that-
wants compensation
Now-
also.
Now precisely the dispute pending in a recalling application where a compromise have taken place. One of the property, a claim, grievance of the petitioner is earlier occasion where a compromise have taken place. This petitioner is not aware of other properties available in the family. Therefore, we sought for reopening of the partition that is permissible in law subject to satisfying certain elementary. Compromise decree under the law is also permissible to be reopened, required subject to satisfaction. That is pending, where one of the.
I have not said anything. I will take it on Friday.
Friday.
Next.
71.
Present respondent.
Short adjournment. Interim order ಇದೆಯಾ?
ಇಲ್ಲ.
At the request of the council appearing for the petitioner, 30th.
Much obliged.
72.
Hearing for petitioner. My lord, this honorable court has directed to produce the entire order sheet of OS number 53, my lord.
ಯಾಕೆ?
For us.
List on Wednesday in preliminary hearing. ಅದು ಫೈಲ್ಗೆ ಹಾಕಿ ಮಾಡಿ.
73.
Challenge, my lord, the execution petitions, my lord. before this court.
ಬೆಳಗ್ಗೆದ?
ಬೆಳಗ್ಗೆದು ಒಂದು ಆಗಿದೆ. ಒಟ್ಟು there are 3 petitions. Can be taken up
Other
together.
2 matters. We have
ಯಾವತ್ತಿಗೆ
precisely-
adjourn ಆಗಿದೆ ಅದು?
Day after tomorrow.
List day after tomorrow along with serial numbers?
26, list 2, serial number 26, my lords.
List 2 serial number 26. List 1 ಅಲ್ಲೂ ಇತ್ತಾ?
ಇಲ್ಲ.
List 2 serial number 26. Day after tomorrow. ನಾ ಯಾವತ್ತು ಹಾಕಿರೋದು?
Day after.
Day after tomorrow. Yes.
Much.
74.
Time for the respondent, my lord.
Yes, it's a clubbing application has been rejected, Your Honor.
ಆಯ್ತು ಇದು 233 ಮ್ಯಾಟರ್ಸ್ ಬಂದಿದೆ ಮೇಡಮ್. ತಗೊಳ್ಳಿ. Wait, 233 ಮ್ಯಾಟರ್ಸ್ will take time ಆಯ್ತು.
234. more matters, orders, seal number 1. Vintage Talwar.
Next area is the impugned order passed by the work tribunal. Not they say that petition is not maintainable, revision is maintainable, but the learned single judge Malords has ruled that there is no revision under the work file. So I have the revenue of coming before your
To
lordship.
serve on learned HCGP 3, 4 petitioner to serve 1, 2 and 5 by way of hand summons.
There is an order for demolition, Malords, of the.
There shall be an interim order as prayed for till the next date of hearing. So, next, yes, list on 1st August. Ivatte serve ಮಾಡಿ. Next.
Number 2, Shore PK.
Madam.
Matter I had moved in the morning as there was.
One minute, sir. Yes. Yes, sir.
Yeah. Lord, this matter I had moved in the morning.
Correct. ಅದಕ್ಕೆ ಈಗ ಬಂದಿರೋದು.
ಹೌದು. ಅದು ಏನಾಗಿದೆ ಅಂದ್ರೆ ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರು.
ಯಾಕೆ ಮಾಡಿದ್ದಾರೆ?
He was, the lawyer was not present ಅಂತ. I have now received a call that ಇವತ್ತು ಬಂದಿತ್ತಂತೆ.
Recall ಮಾಡಿದ್ದಾರೆ.
ಕೆಳಗಡೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೌದು ಈ ಫ್ರೆಶ್ ಇನ್ನು ರೀಇಶ್ಯೂ ಮಾಡ್ಲಿಲ್ಲ.
ಸೊ ಇನ್ಫ್ರಾಕ್ಚರ್ಸ್ ಆಯ್ತು.
ಒಂದು 2 weeks ಅಡ್ಜರ್ನ್ ಮಾಡ್ಬಿಟ್ಟು.
ಏನ್ ಬೇಡ ಇನ್ಫ್ರಾಕ್ಚರ್ಸ್ ಆಗಿದೆ ಮತ್ತೆ ಹಾಕಿ ಬೇಕು ಅಂದ್ರೆ.
ಅಂದ್ರೆ ಅನೆಕ್ಷರ್ ಬಿ ಅಲ್ಲಿ ಸಫಿಶಿಯಂಟ್ ಮೀನ್ಸ್ ಇದೆ ಅನ್ನೋ ಆರ್ಡರ್ ಅನ್ನು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೇನೆ. That's why I just request lordship.
Learned counsel appearing for the petitioner seeks 2 weeks time. List after 2 weeks.
Yes, I'm sorry for this.
No problem. So, yes. Senior. Learned senior. Yes.
3.
My lord, in this writ petition, I'm challenging the compromise.
Office objection.
Lord.
ಕೇವೇಟ್ ಇದ್ದೀರಾ? Yes, madam.
Served a copy, my lord.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ. Today afternoon copy is served.
ಏನ್ urgency?
My lord, the urgency is, my lord, there's an interim order operating in.
Against whom?
Against the respondents from receiving the compensation amount in LAC matter, my lord. So we are, my lord, we are the rightful owners of.
You are the rightful owners.
Please, we have a share in the acquisition. My lord, we have a share in the award amount, my lord.
ಈಗ ಅರ್ಜಿ 230 ಗೆ ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರಿ?
My lord, in spite of there being an.
You did not expect the caveat?
My lord, we were aware of the caveat, my lord. Yes,
I'll take it day after tomorrow.
My lord, my lord.
Urgency ಏನು madam?
My lord, the LAC has already been compromised, my lord. If the defendant number 8.
Lord, what has happened, they are the family members, my lord. This land originally belonged to one Hanume Gowda. He had 5 children. A suit for partition was filed in which the present petitioners are also staking a claim and they say they're entitled to 5/24 share. Whereas the present respondent number 1, my lord, in respect of the same property, through a court auction, I have purchased 20 kuntas of land. Now, my lord, subsequently acquisition proceedings were initiated. In the acquisition proceedings, since I was the registered Khatedar, my lord, my claim petition is filed, it is ordered. Now the Honorable Court has proceeded for releasing the compensation in my favor. 12/7, my lord, and
Day after tomorrow we'll take it.
and their earlier impleading application in the LAC proceedings has
see.
been.
Heard the
My
learned
lord.
counsel. What's your name?
Chandana, my lord.
So and so appearing for the petitioner and Srimati Rakshita DJ. Copy ಕೊಟ್ಟಿದ್ದಾರಾ?
ಮಧ್ಯಾಹ್ನ ಕೊಟ್ಟು.
ಆಯ್ತು. List day after tomorrow in preliminary hearing.
Please.
ನಾಳೆನೇ compensation ತಗೊಂಡ್ಬಿಡ್ಬೇಡಿ.
My lord, stay of.
3 no draw like 12/7 is.
My lord, stay of the compromise, my lord.
Wednesday, we'll see.
Number 4,
Yes.
Naveed Ahmed.
Careful, my lord.
Seal number?
Lords, there is an injunction order, Lords, permanent injunction order against me, Lords, in my favor, Lords. Lord, the BDM, Lords, without hearing me, Lords, passed an impugned order, Lords.
Permanent injunction of what, sir? How did you go before the civil court?
Lords,
Not even maintainable.
Lords, BBMP disturbed my position, Lords. I approached the civil court, obtained permanent order of permanent injunction.
ಏನಾಗಿದೆ?
Lords, now, Lords, without hearing me, Lords, BDM, Lords, passed an order, Lords, evicting my, for eviction.
Serve on Ajay Kumar, counsel for the petitioner to serve on counsel Shri Ajay Kumar for the respondents. List tomorrow.
Lords,
Second
tomorrow
list.
is the action, Lords.
Tomorrow.
Tomorrow is the action, Lords.
Tomorrow morning I will take it. Don't
Appellate,
Yes. ಇವಾಗ್ಲೇ serve ಮಾಡಿ.
I will serve it.
Yes, next.
Raghavendra S.
Request for stay against the order, impugned order. So
What is
actually
the,
the
what is the impugned order?
order has been passed because 1 minute.
ಆರ್ಡರ್ ಪಾಸ್ ಆದ್ಮೇಲೆ ಇಂಪ್ಯೂಂಡ್ ಆಗೋದು ಏನಂತ ಹೇಳಿ
ಇಂಪ್ಯೂಗ್ಡ್ ಆರ್ಡರ್ ಮೇಲೆ ನಮ್ಗೆ ಸ್ಟೇ ಬೇಕಾಗಿದೆ.
ಯಾಕೆ ಬೇಕಾಗಿದೆ?
ಯಾಕೆಂತಂದ್ರೆ ಅದು ಆರ್ಡರ್ ಆಕ್ಚುಲಿ
ಸರಿ ಇಲ್ವಾ?
ಸರ್ ಒಂದು ನಿಮಿಷ.
ಯಾಕೆ ಬೇಕಾಗಿದೆ?
ಆಕ್ಚುಲಿ ಅವಾರ್ಡ್ ಬಂದು 2004 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಕ್ಚುಲಿ ಅದಾದ್ಮೇಲೆ EP ಫೈಲ್ ಮಾಡಿರೋದು 2017ಗೆ. ಸೊ ಅಲ್ಲಿ ಲಿಮಿಟೇಷನ್ ಇಲ್ಲ. So they have barred the limitation.
Who has barred the limitation?
ಅಲ್ಲ ಸರ್, ಲಿಮಿಟೇಷನ್ ಬಾರ್ ಆಗಿದೆ ಬಿಕಾಸ್ 2004 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ, ಅವಾರ್ಡ್ ಆಗಿದೆ, ಆರ್ಬಿಟ್ರೇಷನ್ ಅವಾರ್ಡ್. ಅದಾಗಿದ್ಮೇಲೆ EP ಹಾಕೊಂಡಿರೋದು
17 ವರ್ಷ ಆದ್ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ.
ಅದಕ್ಕೋಸ್ಕರ ಆಕ್ಚುಲಿ ದಿ ಟುಡೇ ಇಸ್ ದ ಸ್ಪಾಟ್ ಸೇಲ್ಗೆ ಇದು ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಸ್ಪಾಟ್ ಸೇಲ್? ಯು ಆರ್ ದಿ ಜಡ್ಜ್ಮೆಂಟ್ ಡಿಟರ್.
I am the petitioner. I am for the petitioner.
Who is the petitioner?
Petitioner is JDR 1.
Oh, JDR. Joint development ಹೇಳ್ದಂಗೆ. Judgment debtor.
Judgment debtor 1. So actually ಆರ್ಡರ್ ಇದು
ಸ್ಟೇ ಬೇಕಾಗಿತ್ತು. ಹಂಗೆಲ್ಲ ಕೊಡಕ್ಕಾಗಲ್ಲ, ನಾಡಿದ್ದು ಹಾಕ್ತೀವಿ. ಸರ್ವ್ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ.
ಇಲ್ಲ ಸರ್, ಬಿಕಾಸ್
ಸೇಲ್ ಯಾವತ್ತು?
ಇಲ್ಲ, ಇವತ್ತೇ ಸೇಲ್ ಸರ್. ಅದಕ್ಕೋಸ್ಕರ
ಆಗೋಗಿದ್ಯಾ?
11 o'clock ಇತ್ತು. ಅದಕ್ಕೋಸ್ಕರ
11 o'clock
ತಗೊಂಬನ್ನಿ ಅಂತ ಹೇಳಿದಾರೆ ಅವರು.
ತಗೊಂಬನ್ನಿನ
ಸ್ಟೇ ಇದು ಕೊಡಿ, ಆರ್ಡರ್ ತಗೊಂಬಂದ್ ಕೊಡಿ, ನಾವು ಇದು ಮಾಡ್ತೀವಿ.
ಸ್ಟೇ ಅಲ್ಲಿ ಕೊಡ್ತಾರೆ, ತಗೊಂಬಂದ್ಬಿಡಿ, ಆಮೇಲೆ ನೋಡೋಣ. ನೀವು ಕೇಳ್ತಾ ಇರೋದು ಹಂಗೆ ಇದೆ, ಸ್ವಲ್ಪ ಸ್ಟೇ ಕೊಟ್ಬಿಡಿ ಅಂತ. 2004 ಅವಾರ್ಡ್ ನ ಈಗ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಹೌದೌದು, EP ಇವಾಗ 2017 ಹಾಕೊಂಡಿದ್ದಾರೆ. ಅದಕ್ಕೋಸ್ಕರ ಅಲ್ಲಿ it is barred by limitation.
The petitioner is before this court calling in question proceedings in execution petition 31 of 2017, seeking to execute an award of the arbitrator of the year 2004, to be precise 28/12/2004. Therefore, further proceedings before the concerned court shall remain stayed till the next date of hearing. List on 25th.
Stay.
ಇಸ್ಕೊಂಡ್ ಬಂದಿದ್ದೀನಿ ಅಂತ ಹೇಳಿ. Yes. Other matters will give a date.
Serial number 136.
5 o'clock there is a meeting.
Tomorrow.
Serial number 95.
One ನಿಮಿಷ madam, GMC.
136.
1 minute.
Yes,
wherever there is an interim order, give it after 2 weeks. Where there is no interim order, it will be Wednesday or Friday.
Serial number 95.
Whatever it is.
Serial number 95.
Yes, madam.
Serial number 95.
Madam, serial number 136 mentioned.
Madam.
Court officer? Court officer? Court officer? Court officer? Court officer? ಬೇಗ ಬೇಗ. Court officer? Court officer?